Grace and peace, everybody. Good morning. We're back. We're back up in here doing the thing that we do when we do the thing that we do. Right. Getting it set up over here, making sure that we're loud and we are clear. All right. That's all right. So we're ready to go. I know court is not supposed to start. The jury's not supposed to come in until 9:30 today. So we're gonna be a little bit early today, but it will not be said that the DWC Nation comes to court late, unlike Adrian Love. How's everybody doing today? Thank y'all so much for hanging out with me today. Thank you so much for your support on this week. I was out of town, but thank y'all so much for tapping in. It was great to see you all in the live chat. Thank you again to Mandy. Hats off to Mandy for sure. Did I have it right? It does say day 132 up here. Why does it say that? All right. It says it right on the thumbnail though, but it's wrong on the hopefully that's right. Okay. Do y'all see does it say day 130? Okay, on the okay, it says 132, 133. So we're good to go. Thank you so much, B. Appreciate you loving. I hate I miss you all. Come on over here. We got you. We're gonna save time for you. We got you either way. We got you. Good to see you. I see you, Donna. Thank you so much. Lucky number three. Good morning, DWC, and the best live chat on the planet. Absolutely. If you're not familiar, you have the privilege, the honor, the wonderful opportunity to be a part of the best live chat on the planet. All you got to do is hit that like button and jump on in the chat. So let's go. I see N Doug up in the building. Good morning. I'm her. I'm her. I love it. Good to see you. Good to see Q. My sister Q's in the building. Good morning. Now, Fonnie has filed an emergency order to block the subpoena to open records. I bet Fonnie told Love to bump up Ashley's client. I guarantee you. Send me the link and we have a lunchtime video to go over today, but we'll try to get it all in. There's so much that's been happening. Can we all agree again that 2024 has been nonstop from the word go? I mean, we have a lot going on. We got Diddy in jail. We got the Ashley Ashley Fonnie. I don't know if this is going to be a battle royale, WrestleMania. What do we want to call it? But we got that brewing because Ashley about to give 88 Love the business, and then she's gonna turn around and give Fonnie the business. It's gonna be man. That's gonna be a mess. Um, Judge Whitaker is collapsing and falling apart, and right before our eyes, we have an election coming up in what 2 months? Less than 2 months. This year has been wild. The hearing we're finally yes, it's supposed to be for 9. You are correct. Can we do that? Can we jump over there to that? Judge Cross's courtroom. Let's see that. Let's do that. Let's do that. I like Judge Cross. I think I think the bad thing is I think we all like Judge Cross now. I remember we were all like giving Judge Cross that side eye at one time. Q, send me the link to it in Discord because it's not her courtroom. She doesn't have anything new scheduled on her court. So I don't know if it's gonna be in there or not. But yeah, we'll do that. That'll be dope. Let me get this over here ready. All right, let's see what we got. Oh, people have been sending me things in Discord. Okay, I think we're ready. So if you send it to me, Q, we'll be ready to get going. All right. All right. All right. Thank you so much. Robin's in the building. Here, let's do it like this. I appreciate all of y'all for stopping by. All right. I got it now. No, that's not the order. That's not the I wanna see if we can actually do the, hear the hearing. It's only gonna be 30 minutes long, and court is on pause. So if we could send me that link, we can get going. All right, let's see. All right, let's see what we got. I got good stuff popping in here. Thank y'all so much, everybody who's already tapped in. Thank you. It's about 110 of y'all at the current moment. I do appreciate it. I do greatly appreciate y'all stopping through this morning. She said she got both her phones ready. Send me the link. Now, my G, y'all know I'm over here multitasking. Y'all know I'm over here struggle streaming too early in the morning, and I'm coffee free. So we're gonna have a problem one way or another. I'm gonna set us up for failure. Lady Dear Old Christian got a K cup subscription dealio, and I don't think they ordered any K cups, so there was no cups in there. So your boy's sugar is coffee free this morning. So I'm about to run out there and go get some later on. All right. Maybe her she just didn't maybe Judge Cross just doesn't announce her live streams. Because she does live stream them though, which is kind of crazy. All right, let's see what we got. Nah, I don't have it. Okay. So I appreciate y'all. We're gonna keep our ears to the ground. And as soon as I get the link, which I think it just came in, got it. Oh, but that's the one I have already. That's the one I got already, Q. She's not, there's nothing in there. Yeah, I'm gonna show you so y'all don't think I'm making this up. Y'all don't think I'm struggle streaming. I've never had instant coffee, now, Kels. Now that's something I've not had. I'll have some unsweet tea before I do that. I've not had instant coffee. Let's see. So y'all can see, like, there's nothing in here in her. Here's another link. Yeah, she may not announce it. So we're gonna just sit here and wait and see if Judge Cross pops up with a yeah, just so y'all can see. So waiting to see if she pops up with a an impromptu live stream discussing Ashley Merchant. And if you're not familiar, this is the part that this is that horse trading part that just seems crazy. So y'all know that Ashley Merchant is one of the lawyers in the Trump interference case. And Ashley Merchant is the one that blew the box off of the whole Nathan Wade, Fonnie Willis brouhaha, right? Canoodling. There we go. I want to use that word today. So she revealed that. One of the things that they realize in this is that the Fulton County DA just spends money. He or she don't really have any accountability. So with that being the case, they wanted to kind of look into the finances. Like, how are you spending this money that's coming in, the money that came in for the Trump interference, as well as just other money that's come in? There's no way of knowing how you're spending money. If you go back and then put a pause there and jump to the Georgia Senate hearing, they realized that when they had the Georgia Commission come in, there's no way of knowing how much money these people spend. They just spend money. They give them money and then they just spend it. Then they come back for more money and they just spend it. So back to Ashley. So she wanted to know a little bit more about how do you decide, what are the records? How do you determine who gets hired, who gets fired, who gets paid what, so on and so forth. And of course, Fonnie Willis was willing. She was already ready. She had a wheelbarrow of information and jump drives and USB drives and brought all that up to her and gave it all to her. No, she didn't. She's fighting now a subpoena because they had a um, they had a hearing before a judge. First of all, Fonnie first of all, Ashley Merchant filed a Freedom of Information Act. You should be able, as a citizen, to follow the proper steps to get information based upon that is required in public information. First of all, they gave them the runaround. They were saying like you filed it to the wrong department, blah blah blah. They went before Judge Cross, and Judge Cross said, "No, y'all got to give them that information." Well, what did they do? They immediately did not do that. So then, because they have an order from the court, they're now in contempt of the court. So Ashley Merchant filed a contempt charge against her to get this. And so now they're going to fight the contempt charge to not give the information that the judge said that they got to give. It's crazy. It's crazy. I don't understand it. And the bad thing is that somehow or another, in their minds, they think this makes them look good. This makes them look like they're fighting for righteousness or fighting for the right cause. When I think we all could agree, you couldn't do this at your job. You couldn't do this anywhere else, but Fonnie Willis and others feel like they can. Not only can they do it, they can do it without any kind of pushback whatsoever. Tell the truth, shame the devil. All right, now I see that the Georgia Seal is still up in our courtroom, 1C, and there's nobody in Judge Cross's courtroom. I think is 4B, I think. Anyway, it's upstairs. So, all right, we're gonna just keep jumping between the two of them because I don't want to miss the start of court. Let me just show y'all real quick. The court has not started yet. I don't want to miss the start of court. So we're waiting for Judge Cross because she has a 9 o'clock. Maybe she's gonna just start right at 9 o'clock. Maybe that's it. And she's not gonna give any kind of warning, anything like that. She's popping in, surprise. Maybe that's what she's gonna do. I believe that. She seems like that kind of lady. And Ashley did file the motion for contempt. I was going to go over that during lunch, but I also have something fun about Kamala for lunch. Not fun, but something that kind of shows the type of woman that she is at lunch. So we got that. We got a lot to go over, man. We got a lot. This might be a 12-hour day. I'm just kidding, because I got to go to a DQ meeting today. All right. And Cindy says something. When you get caught speeding, they fight or flight. Fonnie is in trouble now. She's in deep trouble. And I'm gonna put the ask out there again. Throw the ask out there again. There's still opportunity for Courtney Kramer to at least make some waves. I mean, they've been serving up Courtney Kramer some really, really ideal situations, from what's going on in the YSL trial to that foolishness going on with Mr. Zachary in the hospital, to the pure unadulterated lies that Adrian Love just told Judge Whitaker, and Judge Whitaker ate them down like a fat kid in cake. That was really telling. That was really telling. I don't think people really picked up on the fact that Adrian Love is giving hearsay information about the doctor. Mr. Shive was told information about the doctor, and the judge went with Adrian Love. I think that's crazy. Let's also just point out, there was no case law, no laws, no statutes or anything argued about whether or not Mr. Zachary should have to come to court. Because I think the first thing is, you can't have a witness on the in the witness box who's inebriated or under any kind of substance. So go back to Glanville. Glanville was wrong for having that man sit there in the box saying that I'm so high, I'm gonna fall asleep on you. That was wrong. He can't do that. That man should not have been able to do that. So now you have somebody who's in sickle cell crises. Now, granted, the pain levels, that is on the person. But if this man is popping Oxycontin to stay coherent, sir, ma'am, you can't do that. You can't drive a car on Oxycontin. You could not pass probably a drug test to be for various careers on Oxycontin, but you can sit in the booth. I'm sorry, you can't do that. And there was no argument. I feel that not only was the judge wrong, Judge Whitaker was wrong, But I think Mr. Scheib should have argued that point and gave some real solid case law. Now, your next logical question is, well, why did the defense not do that? I think the defense knows that this is a dumpster fire. And if that man comes in that booth and passes out, falls on the ground, has a medical event, it's only going to make them look ridiculous in front of the jury. So they're just letting them go. I hate to say it. I think they might have just let it go because there's not much that he's going to say that's going to go well for the state. So I think that's why they didn't push it. But that's my little 2 cents. Back to Mr. Scheib and Adrian Love. So we've seen this kind of level of shenanigans and such like that. I hope Fonnie Willis realizes, like, young lady, this is not a good look for your administration. You really need to cut bait and try to repair your image because your image is not looking like is going anywhere. Because all your resources are right here on Pryor Street in Courtroom 1 Charlie, when there's so much stuff going on in Atlanta that your focus and your determination is all over the place. I think that that's going to come out. Yeah, it's addictive. And you're okay with having somebody who's popping these up. We got court movement. We got court movement in 1 Charlie. We got court movement. Let's go. Can you real quick let me know when you can hear? Put me down here. There we go.
Do we know who our witnesses this morning are going to be?
Should be Crime Scene Tech Turner, Ms. Latner's Officer McGovern, Crime Scene Tech L. Jenkins. Court's indulgence for 1 moment. Ms. A.S., who we've spoken about previously, Ms. Smith.
All right, so we still need to resolve the issue of whether that person is going to be shown on film,
Okay, yes,
right?
yes, Your Honor. And
Can you drop a 1 in the chat if you can hear?
one witness we've been discussing all week, Your Honor, who has the condition. Yes, and lastly would be depending on the status of the witness.
We discussed yesterday the possibility that Mr. Zachary may or may not testify, depending upon when and if he is released from the hospital. All right, so with regard to AS.
Your Honor, the state's position,
You need to talk into the mic.
yes, I'm talking into.
It is working. She's just not close enough to it, and it's attached. So you're gonna have to just pick one up and use that one. Or go to the podium. Either one.
Regarding Ms. A. Smith, again, Your Honor, the state is asking for her not to be shown on television. I believe she still lives in the community in which this incident occurred back in 2020, Your Honor. I believe she has voiced some concern. Ms. Love is the prosecutor who has been in the most communication with Ms. Smith, but my understanding is she has voiced some concern. I can't go into specifics regarding her safety in this case, Your Honor, given that she still lives there. I believe at one point she did communicate with one of our victim advocates that members of one of the defendants' family had approached her and this was probably about a year ago. And so she was supposed to provide us more information about that particular individual. And so those are some of the things that I am aware of that she has discussed with us and with the state. And so given some of those factors, we would ask for her not to be shown on camera, Your Honor.
All right. And is there any objection to just having her audio but not her face shown?
Yeah, Your Honor, I object to that. I don't believe that what you've heard from the state today rises to the level that was set by the previous court on the standard by which a witness would not be videoed while testifying. Of course, this is the first I've heard that maybe possibly she may have talked to a victim advocate. I know that when this came up in court the other day, that was not mentioned, but absent that, which it sounds a little bit loose at this point, I just don't believe it rises to the standard. And if this is what's established, then any witness could potentially just raise their hand and say, I don't want to be videoed.
Okay, well, obviously, this trial's been going on for a really long time and not that many people have done that. So that doesn't appear to be an actual legitimate concern.
Well, Your Honor, I would say that since these requests have started coming in, that approximately, I don't know, I'm making a guess, so don't hold me to it, but roughly 20% of the witnesses that have appeared on the list that we get at the end of the day on Friday for the next week, I would probably about 20% are highlighted as not to be shown. So it's not a one or two off thing in the history of this case.
Okay, so since I've been presiding over this case, which has been since what, mid-July or so, this is the second witness that has had anything raised. So that doesn't seem to be the percentage right now, but that's not the determining factor anyway. It's whether there is a legitimate security concern that can be substantiated by either the witness or the state. I mean, Ms. Hilton, are you representing that she has had threats made to her that she's brought to the state's attention?
She's communicated, I know for one specific incident that a family member of one of the defendants had approached her.
Okay,
But
and
not
what?
Approached her asking her not to testify in the trial. She did not say that that individual threatened to
All
harm
right,
her.
so maybe we find out a little bit more from her when she gets here. Is she here now? Okay, well, we'll maybe revisit that issue. And if the victim advocate has further information or you develop further information before then, let me know. Okay.
And Your Honor, just
Yes, sir.
to be clear, if she can show that there's been a threat made against her, or you believe there's a threat made against her, then I will not object to her not being shown on video.
All right, threat or intimidation?
Your Honor,
Yes, sir.
turning the page from the video, on video, off video, with Ms. Smith, the information just recited by Ms. Hilton is the first I've heard of this. I don't know what this interaction is, but the state, am I correct that the state, regardless of whether she's shown on video or not, is not going to seek to admit any testimony about whatever this interaction was as part of her testimony, is it? Okay, all right, cool.
All right, thank you. Okay, is there anything else the state intends to present with regard to that particular 911 call with Ms. Latner's? Mr. Atkins had sort of left the door a little bit open to bring something else up.
Your Honor, we're going to hold on
Okay.
that call for right now, and so we
All
would
right.
just ask to
Sounds
hold for
good.
that. In addition, Your Honor, the pictures that we intend to introduce today through some of our witnesses are on its way down, so we can distribute to defense counsel so that they
Okay.
can have them. In
Go ahead and do
advance.
that. All right, and then I wanted also to go over the couple of motions in limine that were filed last night or yesterday afternoon that I referenced, but that we didn't review. 56 is sort of just a general, the defense position is that they don't think testimonial statements or hearsay should come in inappropriately. It's just kind of a general, here's the law. And so I agree. But we're gonna obviously have to see how that plays out.
Can I mention something?
Yeah.
And good morning, Your Honor. Good morning to everyone. Your Honor, the import of that obvious, I guess, motion is what happened. I tried to articulate yesterday with the blue flame. So it is gone on before you or the court that a quote gang expert would say, and I'm paraphrasing, I'm not going to tell you who I spoke with. You don't have any of my notes. I did not do a report, although ordered by Judge Glanville to do a report. And I spoke with an unknown person, but we verified them and we find them to be credible. And they told me that, you know, Jeffrey Williams' stepfather's home had bullets driven into the home. And I always want to go back and interview everybody. So that is was my objection yesterday with the blue flame. I know you excluded it, and thank you, but it was argued by Prosecutor Love that people told us, the gang, whomever, that this was a retaliatory shooting done by YSL. And it's the same thing over and over. And that's really what I'm trying to get at. In this case, Miss Battle called me, the same witness, proposed witness who wrote to the Ensemble Court, and she was very upset. It's the same thing, nothing new. And I told her the same. I said, you know, courts are where we resolve issues, and she's been properly subpoenaed, and you know, she knows that. She's testified 50 times. She's a chemist.
Yeah.
But she said that the authorities were not doing anything wrong. There's nothing wrong, but we're trying to see whether she knew over and over again who lived next door and the name of the person. And she kept saying, I don't know, I don't know, I don't know. My point is, I just want to keep all that out. And I don't want somebody to lay some foundation that, hey, on this form, which came in yesterday, of tenants, this person rented the apartment, and then have a gang expert come in and say, well, we interview people, and her boyfriend is this known gang member with IF. And that is really what this motion's about. It just shouldn't be circular and hidden. We should have the authority to go out and interview the people and have the same information the police are relying on to make those representations. And if they don't give it to us, then clearly to me, it's hearsay and confrontation clause. That's my issue.
Aaron, I think with many of our experts, they can rely on certain,
Kick up the mic and use it.
with our experts, they can rely on reports or certain information to gather their conclusions. And what I believe happened during the course of this period in 2015, from January to ultimately October, is all these shootings occurred. They received these reports, they gathered information, they interviewed witnesses, and they were able to get information to form opinions about what was happening during the course of.
Yes,
Yeah,
experts can rely on hearsay in forming their conclusions, but there's a difference between the expert coming in and saying, based on our whatever they do, our conclusion was this is a retaliatory shooting, which would be permitted under the rules of evidence. And we concluded that so-and-so's boyfriend was a rival gang member whose name was whatever, or even without whose name was whatever. That is clearly hearsay and so obviously hearsay that the regular rules of evidence have to still apply to that.
Right, and so hence why we're here, bringing in officers who are responding to these scenes, gathering information, because now this information is before the court. This is what they've learned, and so that's why we're going through introducing all of the various retaliatory shootings now with officers and the information gathered, because when the experts come, this is the information that they relied on to form their ultimate opinions about.
Okay, do you understand? I mean, we
understand.
can't exactly, figure out all of the contours of what might come in beforehand, but an expert conclusion that this was a retaliatory shooting, even if based upon hearsay, would be admissible under the rules of evidence. Expert testimony that is just basically hearsay, that this is the person that lived in this apartment, or this is the person's boyfriend, it would still be excluded as hearsay, even if it was being offered through an expert.
We understand.
Clear? Okay. All right. That takes care of that one. The number 57 is essentially some further argument as to the contents of the text messages authentication issue. And I've looked at the case law and looked at the statute again. And the issue was that one column that had text message contents, but essentially on authentication, it's a prima facie case that it is what it purports to be. And that was shown that it is the Verizon record of that phone number. It has been established that maybe everything about the contents is not 100% accurate, and it'll be for the jury ultimately to determine whether they want to believe that anything in that column is accurate. But the prima facie case has been made, and so it's not excludable on that basis. Yes, sir.
And can we just have a continuing objection to that issue?
Yes.
Because I'm not going to belabor it. And can I just cite what I sent this honorable court into the record?
Sure.
Johnson, John, SON versus State. And it is cited at 348 Georgia Appeal 667. Your Honor, that's in 1B as in Barry, 824 Southeast 2D 561 2019 case. And it's our position, which you've articulated and respectfully rejected, that it has to be reliable. And I believe that the witness was clear that the records itself, she said she would not verify, but I've argued it and it's preserved, and thank you.
All right. Motion limiting number 58 covers a couple of different things. One, that on the two charts by agents Cunningham and Officer Kilgore, that one particular gun, the seizure of which has been determined to have been illegal, those charts need to be redacted so as not to include that. I think y'all said, the state yesterday, yes, we'll make sure. I think there was only a mention maybe of one chart at the time, so just make sure that it's gone from both of those charts. Then there is a request that Mr. Zachary's recorded statement from March of 2017, where Detective Dennis asked Mr. Zachary how the assault rifle was located by police in Mr. Williams' home, be excluded because the search itself was illegal. Now, I don't know exactly what got said then, so do I need to listen to it or see a transcript of what was said?
We have a transcript where you
Okay.
can listen to it. I don't know if the state's position, they may agree. It's a 2017 statement, Your Honor, March 3rd, if it comes in. I'm just
Right.
preempting it. And the search that's been deemed illegal of Mr. Williams' home is July 15, 2015. And it's simply the detective asking Mr. Zachary about this weapon that they would not have known about, and the derivative evidence has been
Oh, I
also
understand
suppressed.
what you are saying now. Okay. What's the state's position on that?
Your Honor, the state that does not intend to introduce anything regarding the July 2015 search or the item seized from the search.
Okay, and so the reference to the assault rifle, which the state only knew about because of the search, I understand now what the argument is. Y'all won't have any reference to that. Okay, and then the third thing is that in that same transcript, Detective Dennis at one point states, or is her, what this says is heard stating that Mr. Williams is the owner of the studio that was the subject of that search, and you want that statement that he was the owner of that studio to be excluded?
Yeah, I think we had an order previously, and please correct me, from the predecessor judge that on the same morning as July 15, 2015, law enforcement went to Mr. Williams' home.
Mm-hmm.
That's been deemed illegal as search, as well as to a recording studio. At their recording studio, they found, I believe, marijuana, $40,000, U.S. currency. I'm going to say firearms with an S. It has been previously said that search of that studio is not related to Mr. Williams or anyone on trial directly. It was another person named Rico, and his last name is
Rico.
evading me.
We found Rico.
I can't remember, but it's a Rico Ritchie,
Rico
R-I-C-H-I-E.
Richie.
And that would be excluded. And I just want to make sure that that doesn't get mentioned either. And the way it was said in the transcript is that that's Mr. Williams' studio, which is just not right. But Mr. Williams did have a connection to the studio because he would perform at many studios throughout.
So it's not true that he's the owner of the studio, is that what you're saying?
He's not the owner of the studio.
Okay, any issue with that piece of that interview being excluded?
We believe that is in the order, and we will follow the court's order.
Okay, I don't understand what you're saying there. Are you conceding? Okay. All right, so that takes care of that.
Can I add one more thing to that, Your Honor, this motion?
Sure.
And I think the court ordered it yesterday, but the blue flame shell casings are on that same chart that is referenced by Agent Cunningham, according to the state, as an exhibit of hers, as well as Officer Kilgore. So I asked that blue flame mentioned on that chart be please removed. And that's the search by the firearms police database.
It will be removed.
All right, thank you.
She giving it up. She giving up everything.
All right, and then the last one was a supplement to the big motion to exclude various pieces of evidence that we'll need to go through whenever we have our next non-jury day. So we won't deal with that one right now.
Your Honor,
Yes.
may I just add one thing? Again, I'm, like Mr. Steele said, not conceding the admissibility of any prior statements of Mr. Zachary, but I just wanted to remind the court that there were some matters that we took a wait and see approach, Your Honor, took a wait and see approach to see if a foundation could be laid by Mr. Zachary regarding one. I was reviewing in preparation of court today. One specifically was whether something counted as a tacit admission. And we just needed to hear from Mr. Zachary to lay a foundation on some of those matters. I just wanted to remind the court that we do have that issue out there, those issues out there. There's a few of them.
All right, so does the state recall what it is that Mr. Sharp's referencing?
Your Honor, I don't. I unfortunately do not, because I don't think I was here when the Quindarius Zachary statements were reviewed. Mr. Atkins and Ms. Love were here, and give me a moment, I can reach out to them to see.
All
if
right,
they can
well,
recall.
I guess until he shows up here, it won't become an issue anyway, but maybe circle back on that when we've got a different prosecutor in the courtroom. and
Circle
we
back.
get Mr. Zachary. All right, thank you. Okay, do we have the jury? Not everybody, okay. Yes, sir. Yes,
Before that's done,
we'll wait.
can I ask a quick question?
Okay,
Apologize, Mr. Weinstein. Your Honor, the state was kind enough to point me in the right direction for the witness list.
Mhm.
And they said, I think the Honorable Court is on that email. So they said that Miss Bailey, Bailey, Miss Galloway, Galloway, and Miss Chavo, Chavo, or E rather, ES, Chaves, Chaves, we're not on any witness list. If we could get contact information and if the state could make them available for us to interview, that would be helpful. I'm not moving to exclude, the witness for not being on a witness list unless the court wants to do that. But I would like to speak with the witnesses.
Yes, Your Honor.
All right, how soon can y'all do that? All right, it looks like these are all like APD employees.
Let me just look.
Oh,
because of the
man.
investigative team, we should be, hopefully if they still work with the department, we should be able to get that pretty quickly.
More APD
All right,
employees.
anything else? All right. Will you?
And while we're waiting, Judge Cross has not started court at all. So I know I said we were going to jump. I was hoping we would be able to, but Judge Cross has not started here, just so y'all can see. All right, so we're
To or want to use the restroom real fast. Hopefully we'll have all of the jurors in the next 5 minutes or so.
okay. So they're going to the seal, and nothing's going on over here. Nothing is happening. They got some funky music though. They got some adventure music. I don't know what that is. Anyway, so if you're new or you just popped in, Ashley Merchant filed a Freedom of Information Act request for data and information from the Fulton County DA's office. Fulton County DA's office said no. They went before Judge Cross about 2, maybe 3 weeks ago. Judge Cross said, yeah, y'all got to give them that information. So they didn't do it. Fonnie's office did not do it. So Ashley Merchant filed a subpoena, or rather a motion for contempt of court, followed by a subpoena asking her to come today. So it's getting kind of spicy over there in Bonnie's office. We're gonna see what happens. Yo, that might be where she is. That would be so wild, Matthew. What does this man have that's that important that literally his life is in jeopardy about? That is craziness. And the bad thing is, I think we all know that that might be true. We all know it. But yeah, I would definitely. I think it might be a little bit more interesting than listen to another, ballistics expert and whatnot. But at the current moment, none of them are available. So Judge Cross hasn't done anything, and the Georgia Seal is still up in our court. Hey there, how are you?
I'm sorry to bother you. I know a lot about FOIA requests. I used to pull them all the time for my last boss.
Yeah,
So I wanted to chime in for a minute, if that's okay.
we got you. Let's go.
Okay, you are not allowed to deny a FOIA request. It's your constitutional right under the First Amendment.
That's what Judge Cross said in the last one. That's why Fonnie Willis's office was doing this 3-card Monty, just keep moving they sent it to the wrong place. They gave it to the wrong person's name on it. That's why they
Uh-huh.
did that. But go ahead, continue.
Yeah, it's like mailing in your light payment and not signing the check. You just can't do it. Eventually, it's going to come back at you. But I have filed for more than 100 FOIA requests, and
Okay.
about one that I've just filed for us. And you have to give it up. It's your First Amendment protected right to get.
Right.
It's the Freedom of Information Act. It's
Wow.
You are protected to get it. So the fact that she just didn't want to give it up, it's she knows better though. She knows better.
Yeah.
But then I do question after seeing her testimony in the Trump case, how much she actually does know about the law.
Well, there's that as well. But also, I think she realizes that whatever she gives, she's not going to give enough. because she doesn't have enough. She doesn't have receipts on all this stuff. So she's gonna get 3 and 4 and 10 pushbacks. Like, what about this right here? I don't see this right here. And there's not gonna be ancillary stuff like whether or not you paid with your card or your Starbucks Gold card, but rather it's going to be really intricate stuff that she knows she doesn't have answers for. So that's why I believe she's really trying to stall and trying to find a way out of it, in my opinion.
And sometimes they do have the right to redact like certain information,
Yeah,
but
take your
not,
Netflix off of there. We don't want to know about your Netflix, Fonnie.
but for court proceedings, they're not allowed to redact anything.
Okay, got you.
So, but like the one we're getting, they may redact some stuff, just because it's for personal or business use, but they're not allowed to redact anything for court proceedings. So they need to give that up.
Yeah,
They
they
need
got
to
to
give
give it
that up.
up. Give us
So sorry
those
I
details.
popped in
Oh,
unexpected
no.
like that, but that was just something I actually know a little bit about. So
Well, we appreciate you so much. Thank you, Mandy. And thank you again for holding down court earlier this week while I was jet setting around. It was fun, but I'm glad I'm back.
not sure I did such a good job, but you're welcome.
No, you did a great job. Thank you, Mandy.
Bye, guys.
All right. Bye, girl. Thank you, Mandy, for popping through, saying hello. I appreciate her. So I'm looking, Judge Cross is about to start. Okay, let's see. All right. I'm looking where are y'all getting Judge Cross is about to start? I'm looking at it. All right, here we go. Let me put it back in so y'all can see too. Yeah, see, I'm not tripping. I ain't tripping. All right, as soon as she starts, I would love to. We're gonna go into lives. There's no live schedule. Nothing there. What y'all seeing? Now here on 11 Alive, they got this big. Put this over here. 11 Alive, they have this, but again, nothing's going on. But I'm ready though. Trust me. I would like to keep it entertaining. Think perjury. Man, if she sat there and perjured herself on that stand and nothing happened, I don't know what could, in my opinion, I don't know what could happen. News says that Fonnie is in California at a campaign fundraiser. That is so interesting to me. She is a local state or rather county DA. What fundraiser are you doing in California? Just like the fundraiser she did in Washington, D.C. Why are you doing fundraisers out of your immediate district, immediate fiefdom, whatever? That makes no sense. Can you keep an eye on YSL Trial for when it needs to switch a little? That's understand. Yeah, absolutely. I'm not. Hopefully, this. Let me jump back over here. Hopefully, I got the other ones. I'll leave YSL up on the screen here. It shouldn't. The contempt Ashley versus Fonnie is only supposed to be 30 minutes. Supposed to be, but it's also supposed to start at 9 o'clock. So here we are. It's called trying to get another job. Okay. You know what? Telly, I can dig that. Yeah. No, don't have her stepping for it. Soror. Don't do it. Don't do it. Cross is live on her channel. Let's see. I'm on her channel. Unless she is live. Let's go.
I don't believe.
We do not, Your Honor.
Oh, everybody's here
That was one of my
too.
questions to you, to see if you had one available to take this down. It, something I forgot to do. I apologize.
Okay, so I can certainly reach out to my court reporter, but she, her equipment is here. She would have to drive here and get here. My notices of hearing, I'm pretty sure very clearly state that in civil cases, it is the obligation of the parties to secure a court reporter. And so what we'll need to decide is, are we going to go forward without a court reporter? Or
With
do
a
y'all
court
want me
reporter.
to pause this hearing for about the hour and a half that it will take for me to get Ms. Cantrell here, which I'm happy to do, if we need it taken down?
Just one moment, Your Honor.
Okay.
Wow, they need a court reporter. I don't know why they don't have one though.
Well, let me find out what she wants to do first, since you did not make arrangements for a court reporter either, so. We're not asking for it tonight.
Okay, so apparently they don't have a court reporter. And
Your Honor, we're going to see if we can contact the court reporter who took down the minutes on our last hearing.
Yes, ma'am.
To see if she can come and appear by Zoom, just so we can condense the time, but we do believe that this needs to be taken down. So we're going to have to contact her, and if you could just give us a few minutes so we can give the court an update.
Sure.
Thank you.
okay, so I am gonna jump over here. Okay, YSL is still on the gold seal, the state seal. So remember, YSL now is on that 5-minute break is going to be a 5-minute break kind of deal now. So they're definitely on that Glanville game for sure. All right. So YSL is back in session. We're going to jump back to YSL real quick.
An individual, a defendant's family member reached out to her. That was not that witness. I'm sorry. It was a different witness who relayed that to me. It was not Ms. Smith. It was another witness who
All
relayed
right.
that. So I just wanted to clarify that.
Okay, so is there anything the state wants to present with regard to the request that AS not be shown on video?
Yes, Judge, and I believe she's on her way, but what she has relayed to the state is that since the time that this has been going on, her family has found out things that she had not alerted them to, that it is causing her, she says, distress. She does not say that she has been threatened. She said that it is a source of great concern for her. And she has asked that we not, she said she doesn't want to be here, but she certainly doesn't want to have her face publicized. She said that when when her name began being mentioned, that caused problems for her, and she does not want to have to endure that. Under those circumstances, and understanding counsel's arguments regarding sort of guidelines by the court's predecessor, we're asking that the court exercise the court's own discretion and allow, based on her concerns and the concerns of any lay witness to that extent. They're not asking to cover their faces in court behind a veil, but to not have their faces publicized nationally is what they're asking.
All right, so you say the court's discretion as though it is 100% up to the court. It's not up to the court. It's the case law that guides it. And in Georgia, it is very, very, very tilted towards showing everything all the time. And the court has very little discretion in stopping that from occurring, even if there are, probably none of the witnesses want to be blasted throughout the world, understandably. So that's why the guideline and the determiner was, are there legitimate security concerns? And if there are legitimate security concerns, then detail what those are.
So, Your Honor, I do understand what the court is saying. And regarding the rights or guidelines of having the faces shown on camera, prior to today, and it was prior to this particular argument, I had researched when we were looking at it previously with Judge Glanville. My understanding, and the court has a vast amount of knowledge about what the particular laws in Georgia are, because the court has dealt with those. But my understanding was that there is no, just just if it were such a right that anyone had to have the faces of every witness shown, then arguably speaking, any trial that's not publicized on camera, their rights are being violated because their faces are not being shown. But to the extent that the camera people decide where they want to put the camera, and if they're okay with not showing the faces, the only argument that I would have is that there's no defendant with any right to show the faces. And I would ask the court for, before we bring her in, that just the ability to, if we can find case law directly on point, to show it to the court regarding that particular issue, because
Of course you can do that. And if the media chooses not to show a witness's face because they know that that person has concerns, that's of course up to the media. I mean, frankly, this court is open. Anybody can walk in here anytime they want to and watch the proceedings. But that's just not really the way the Georgia courts overall have perceived the whole televising and videotaping of court proceedings. So sure, I'm happy to consider any kind of case law that you want to present.
thank you.
And obviously, if the media wants to focus on somebody else during that time, that is wonderful. But unless you present to me either case law that covers it or legitimate security concerns, I can't order them not to.
Thank
All
you.
right.
Thank you.
Okay, so are we now ready for the jury?
So apparently she was on social media.
Okay, well, she's not going to be the first witness anyway, so, all right, let's get the jury.
So apparently the young lady that they don't want to be seen on camera was on social media in front of a camera. You can't make this stuff up. You can't. Thank you to all 380 of y'all that are watching. Appreciate you. Grace and peace. Oh, and by the way, Fonnie's team is still stalling.
He brought me one from the jury. He brought me.
So she was on YouTube talking about the stuff that she doesn't want to talk about in court. Make this make sense. Give me some coffee this morning. No, Fonnie's not there. Thank you, retired. I appreciate you, grace and peace.
Get the witness.
All right, witnesses in. Let's go. Here we go. An hour late, but here we go.
Thank you so much.
Your Honor, state calls crime scene tech Alfred Turner to the stand.
All right.
Okay, it's Alfred Turner, ALFRED TURNER.
And welcome back.
Hey,
Seems like we just saw you yesterday. So we're not gonna go over your background since you were here earlier this week. I just want to jump to back in 2015, did you, excuse me, earlier this week, you discussed responding to 1428 Adele Avenue. Is that fair?
yes,
Okay. In 2015, did you respond to other shootings, other shooting calls?
yes,
All right. I want to specifically direct your attention to January 11th, 2015. Did you have the occasion to respond to 197 Hendricks Avenue in Atlanta, Georgia?
yes, I did.
And why did you respond to that location?
We got a call that a shooting occurred.
And once you got to the location, what, if anything, were you asked to do?
Who was asked to take photos and collect evidence.
And did you do that?
Yes, I did.
And have you had the opportunity to review your pictures from that particular incident in that location?
Yeah.
Okay. You have permission to approach?
You may.
I'm showing you what's been marked as 1 triple DA through 17 triple DA. And where you sent those pictures yesterday evening.
Yes.
Okay. And as you're flipping through, were those pictures, did those pictures fairly accurately depict the scene at 197 Hendricks from January 11, 2015?
Yes, they do.
Your Honor, this time the state would like to tender State's Exhibit 1 triple DA through 17 triple DA into evidence.
Those are admitted.
Permission to publish, Your Honor.
Okay.
Now, first starting with 1 triple DA, if you can tell the jurors, where are we looking at, or what is depicted in 1 triple DA?
It was just an overall photo of Hendricks Avenue.
Going to 2 triple DA. Looking at 2 triple DA, was this the home that was the focus of your investigation?
Yes, it was.
All right. Looking at 3 triple DA and now 4 triple DA and 5 triple DA. What, if anything, is depicted on 5 triple DA?
That's for damage to the screen of the window of that residence.
Okay. Now looking at 6 triple DA. Is that a close-up of what you just referenced?
Yes.
All right. 7 triple DA and 8 triple DA. What's depicted in those 2 images?
Those were gunshot holes to the residence, that same residence.
All right. Now looking at, we're going to skip to 10 triple DA. What are we looking at 10 triple DA?
Those were the 3 shell casings that were collected from the scene.
And did you take close-ups of those 3 shell casings?
Yes, I did.
And are they contained within the set of pictures that you have in front of you?
Yes.
Now looking at 13 triple DA. What is depicted in 13 triple DA?
That's a shell casing number 4 that was located near the residence.
Okay. And were you able to determine what type of shell casing that those were?
I probably have to look through my notes to see which one it was.
Your Honor, permission to approach?
You may.
And let me ask, will looking at a copy of your crime scene tech report assist you? Could look at you. No, I have it up here.
Oh.
Permission to approach?
You may.
I'm gonna show you what's been marked as State's Exhibit 18 triple DA. Is that your crime scene tech report?
Yes, it is.
And does looking at that copy help refresh your memory as to what size shell casings those were? If noted.
No, I don't have that on here.
Okay. Are you able to tell, from looking at the pictures, are you able to tell what size they are?
It,
And if not, that's okay too.
no.
Okay. Now, in that year, did you also have the occasion to respond to 198 Stanhope Drive on January 26, 2015?
Yes.
And do you recall why did you respond to that location?
Um, we were dispatched that a shooting also occurred at that location, and they had damage to vehicles.
And when you were called out to that scene, what, if anything, did you do at that scene as well?
They also wanted me to photograph the scene and collect evidence at that scene as well.
Okay. And have you had the opportunity to review those photos as well?
Yes.
You have permission to approach again?
You may approach freely.
I'm showing you those that marked as 1DDD through 29, excuse me, 1DDD subsection C through 29DDD subsection C. Are those the items that you pictures that you previously reviewed?
Yes.
Okay. And did those fairly and accurately depict the scene from 198 Stanhope on January 26, 2015?
Yes, they do.
And let me ask you, regarding that particular scene, do you know if there was a victim involved in that scene?
I'd probably have to look on my notes to see.
Okay. You're on permission to approach. Oh, no, so I can approach. I'm showing you what's been marked as State Specific 30DDD C. Is that a copy of your crime scene tech report?
Yes, it is.
Will that help refresh your memory?
Yes.
Take a moment and look, and if your memory's refreshed, you can let me know.
Yes, there was a victim.
And who was that victim?
I believe it was Trevante Turner.
All right. And I believe I admitted it, but if not, Your Honor, say what like the tender State's Exhibit 1DDD C through 29DDD C into evidence.
Okay. Do you mean, you haven't this morning? Did you mean
Oh.
a different day?
No, I thought I may have said it earlier today. Okay, Your Honor, this time the state would like to admit 1DDD C through 29DDD C into evidence.
Okay, those are admitted.
And permission to publish.
You may.
Okay, team, I'm making an executive call. Fonnie is supposed to be calling in to the Judge Cross. So we're gonna probably jump over there when she comes in.
That was the vehicle that they were that we were dispatched to take photos of multiple gunshots.
Looking at 2DDD C and 3DDD C. Are those the what, if anything, are inside of the car vehicle?
Can you repeat that?
Are those bullet defects?
Yes, they are.
Okay. And looking at 4DDD C and 5DDD C. What is depicted in 5 triple DC?
Those were the actual location where the shell casings were from that scene.
And did you take individual pictures of all of those shell casings?
Yes, I did.
Okay, and are those included in the stack of pictures that you have before you?
Yes.
All right. I want to go to State's Exhibit 21 triple DC. What is depicted in 21 triple DC?
That's a photo of a vehicle parked at the residence, and it also had multiple shell gunshot damages to it.
Looking at 23 triple DC and 24 triple DC. Is that the damage that you were referencing?
Yes.
And now looking at 25 triple DC. What are we looking at 25 triple DC?
That's a residence of 186 Stone Hope.
Okay. And did that also sustain damage?
Yes, to the window.
All right. Looking at 27 triple DC and 28 triple DC. Is that the damage to the window that you were just referencing?
Yes.
And then looking at 29 triple DC. Was that also a defect to the window?
Yes.
Right. And after taking pictures, did you collect those shell casings?
Yes, I did.
And when you collected those shell casings, what did you do with them?
They were put in our Atlanta Police evidence locker as evidence.
Okay. And I'll ask you the same question for the previous set of pictures with shell casings. Did you collect those shell casings from 197 Hendricks?
Yes.
And what, if anything, did you do with those shell casings once collected?
Those were turned over to Officer Williams on the scene.
Now, as a crime scene tech, do you sometimes report to the APD homicide cage to take pictures?
Yes, I do.
And when would you respond to the homicide cage in order to take pictures?
It's usually after the vehicles has been moved from the scene and actually stored in the homicide cage.
I want to direct your attention to February 20th, 2015. Did you have the occasion to take pictures at the APD homicide cage?
Yes, I did.
And have you had an opportunity to review those pictures today, or excuse me, before your testimony today?
Yes.
I'm going to show you what's been marked as State's Exhibit 1 triple D to 11 triple D. And do you recognize those pictures?
Yes, I do.
And how do you recognize those pictures?
These were the photos that, excuse me, that was taken at the homicide cage.
And are they a fair and accurate depiction of the picture that you took at the homicide cage on February 19, 2015?
Yes.
Your Honor, at this time, the state would like to tender State's Exhibits 1 triple D through 11 triple D into evidence.
Those are admitted.
And Crime Scene Tech Turner, did you know the location of where that car derived from?
I believe it was 140 Maury Avenue.
We're looking at a copy of your police report, Crime Scene Tech report, have refresh your memory as to the exact address.
Yes.
I'm going to show you what's been marked as 12 triple D for identification purposes. Is that a copy of your Crime Scene Tech report?
Yes, it is.
And does that help refresh your memory to the address of where the car was taken from?
Yes.
And what was the address?
It was 114 Maury Avenue.
And what is the date of the incident? When did the incident occur?
That was February 20, 2015.
Was that the date of the incident or the date that you took pictures?
That was the date I took pictures.
What was the incident date?
I'm sorry, 2020, 2019, 2019, 2015.
No, what was the incident date? Let me ask, do you see the incident date on the third line down?
Is that the 2019? I'm sorry, 219.
And what was the year?
2015.
All right.
Monroe noted in her announcement, the court has verbally announced that Bonnie Willis in her individual capacity has been dismissed from the suit. I apologize for not having you a written order yet, but I had to stop and turn my attention to some other things. I was also at a conference, and so I expect I'm almost done with that order, and I expect that y'all will have it today or tomorrow, depending on how things go. But just to reiterate that I have already ruled on the motions to dismiss, denying the motion to dismiss as to the district attorney's office. I attention to some other things. I was also at a conference, and so I expect I'm almost done with that order, and I expect that y'all will have it today or tomorrow, depending on how things go. But just to reiterate that I have already ruled on the motions to dismiss, denying the motion to dismiss as to the district attorney's office, Madam DA in her official capacity, and Fulton County, Georgia, and then granted the motion as to Ms. Willis individually. Where we are now, at the hearing on September 5th, so the hearing on September the 5th was originally noticed as an evidentiary hearing associated with understanding some of the underlying issues of efforts to comply with the requests. And that didn't occur because the motions to dismiss are meaty, right? They involve lots of argument. The parties needed to make that argument. The court needed to be educated about what those issues were. And it took a while. And so we did not end up hearing from the witnesses that day. Although my understanding is that most of them were aware, present, and prepared to testify if called upon. And that although I spoke inartfully at one point about them being released from their subpoenas for that day, I made clear, I clarified that what I meant was they were excused for the day and had not been excused from the subpoenas that were served upon them. I've reviewed the record, and I'm not aware of any motion to quash the subpoenas that were served. I understand that either or both the county attorney's office on behalf of the existing DAs or Ms. Allaby, is that right?
Yes, ma'am.
On behalf of the non-parties who were subpoenaed have taken the position that either or both those subpoenas were for the production of documents, not for appearance, and or that any new subpoenas for
appearance at today's hearing have not been served on those non-parties and or the defendants. I will note that I received a motion to hold Ms. Willis in contempt for lack of compliance with the subpoena for today's appearance. Given that, to my understanding, unless and until Ms. Willis is called to the stand and refuses or fails to appear, if ordered to do so, she's not in contempt, and so that motion is premature. Followed by that, and the reason I'm reciting all this is because the last thing in the record right now is my most recent order that I think was entered on Tuesday. And so none of the flurry of filings have actually been accepted into the record, although I am aware of them because y'all provided them to me. So following that, I received a motion to quash the subpoena to Ms. Willis as the DA. And then subsequently, I got a response brief from the plaintiffs. And then subsequently from Ms. Allaby, I received motions to quash or to be excused from, I think 5 or 6 subpoenas. And so we need to figure out where we are and what we're doing today regarding, one other issue I wanted to put on the record, that one of the witnesses, just to make sure everybody is aware of that, one of the witnesses, Mr. Kevin Armstrong, he reached out because Mr. Armstrong historically was I'm not exactly sure what his role is in the district attorney's office now. I know maybe a DDA, but historically he had appeared in my courtroom as an appellate attorney on behalf of the DA's office. And so he reached out to my litigation manager and notified her that he had an appellate argument in front of the Court of Appeals this morning and asked to be able to resolve that conflict by going ahead, of course, with his appellate argument and then appearing today, which informally my litigation manager told him by email was perfectly fine. So just because there was not a record of that, I'm sure y'all were all probably aware of it, but I wanted to make sure that there was a record of it. Okay. So having started with the fact that I'm not going to entertain the plaintiff's motion to hold Fonnie Willis in contempt currently, I think where we need to start is with the motions to quash, because what I anticipated, but for those motions, was for the plaintiffs to call witnesses. Now, one thing I do want to share with y'all is that it was my intention, we're going to sort out these issues in a moment about what witnesses are here and why they're not here and if that's okay that they're not here and all that good stuff. But I will say I was going to point out that while I'm a big believer in letting lawyers try their cases and put on their cases the way they go, I also come from a civil background where it's pretty well established that we don't harass the CEO of a company for information that can be provided by the head of the human relations department or some other similar analogy that I'm not coming up with as efficiently as I should. I say that to say this. If we reach witnesses today, I think everybody should be prepared for the fact that it's not my intention, Ms. Merchant, Mr. Merchant, to let you start by calling Madam DA Willis, because the inquiry here should be about, as I understand it, the receipt of the request, the processing of the request, and the efforts made to comply with that request. And as a practical matter, we all know that while Madam DA may be involved in that process at some point, she's not the first line that's going to answer the questions or have direct knowledge. And so we can hash that out as we move forward. But I say that to start with the idea that there was always a possibility that we might never have reached Ms. Willis as a witness today. But now, everybody's followed their motions, and so we have to reach these issues today. So with that, I think I'm going to stop talking in a moment and give y'all a chance to tell me if there's any procedural issue or preliminary matter we need to take up otherwise. But my intention is to start with the the defendant's attorneys and Ms. Allaby's motions to quash so that we can deal with those issues first? Because essentially, in terms of at least what we're doing today, they could be outcome determinative.
That works for the planners, Judge. And just so you know, our intention was to call Dexter Bond, who is the open records.
Whose job it is to answer open records act requests for the DA's office, yes.
That was gonna be our first witness. Our second witness was gonna be Jeff DeSantis. His job is media relations, and I can go, when I go through and explain why that was relevant. And then Shalonda Miller from the county attorney's office, whose job is also open records. Those three witnesses, and as I told Ms. Monroe, the other witnesses would be potentially, depending on what those people testified to. So it would really depend on what they testified to, but our intention was to call those people first. And you know, we're ready to respond if you'd like us to respond to the states, not the states. Oh, I guess, so I'm gonna call the DA of the state and then the district, then the county attorney of the county. I guess that might be easier.
Well, I think actually, because this is as good a time as any to remind us all that this is a civil case.
Right.
It is not a criminal case. And so I too have had to remind myself, but I think maybe to keep the record as clean as possible, the best way to do this is that Ms. Monroe and Mr. Bowman are defendants possessive plural counsel, and that Ms. Allaby represents the non-party subpoenaed witnesses. Y'all are of course the plaintiffs, which makes it easy.
Right. Okay.
So let's go from there.
So I'm ready to respond, and I think the non-party defendants, non-party witnesses in this case, their motions argue that the burden shifts to us, and so we're prepared to proceed with those first.
Okay. Any other preliminary thing or matter y'all want to address, Ms. Allaby or Ms. Monroe, on behalf of the defendants and the witnesses?
Nothing additional.
Okay. Okay, so. Go ahead, Ms. Beechin.
Thank you, Judge. Is it okay if I stand at the podium?
Yes, please.
Okay, I wasn't sure.
I think this cameraman is better. I like
Yeah,
him.
no, for purposes of the cameras, they're everywhere, so.
Okay.
And the audio is all linked to the podium, so it works better that way anyway. Go ahead.
Great, thank you so much, Judge. Okay, so just to start, the motions to quash that were filed by the district attorney witnesses, in this case, their motion argues essentially that it was oppressive and harassing. They state in their motion that we subpoenaed 12 other DA employees. I'm not quite sure where they got that information from because we've never subpoenaed 12 DA employees. They say that repeatedly in their motions, that's wrong. There are 6 DA employees that were subpoenaed, and there were 6 motions that they filed. So I think they know that there were only 6 people because they only filed 6 motions, but I'm not sure. So I just wanted to clarify that because the number seemed to be part of the argument about how oppressive it was. It says 12 separate subpoenas for 12 other DA employees. The separate subpoenas, as the court knows, we sent subpoenas originally for the first hearing date, and that hearing was an evidentiary motion. It was more fashioned about the motion to dismiss. So we focused on one primary issue with our open records request, the critical mention documents, so that we could have that ready for the court. Once we learned that this was going to be a full evidentiary hearing, and this was essentially the final hearing in this case, we knew that we needed additional documents, and these are the same documents that we've been asking for 9 months. So they're not new. None of this is new. None of this is oppressive and new, and us sending it to them on the last minute, Judge. These 6, it's 6 separate subpoenas. It's 2 per witness, a witness and a motion and a production of evidence. So it's only 6 people. The state the non-party in their arguments first said that our first subpoena was compliant, the September 5th subpoena. They're saying that they have produced all responsive documents.
Right, and that is supported by the certifications of business records that were filed that are actually in the record from, I think, immediately before that hearing on the 5th, right?
Yes, Judge, we filed those into the record as well. And the issue is that's authentication. So that's not the scope of the documents. That's not us being able to ask questions about, are these really everything that you have? And just by way of example, just yesterday, one of those people filed a new certificate that said, oops, yeah, I found another document because I sent that document to them. So Ms. English, who was a county employee, when she certified 197 pages and said, I sent all of it, I said, oh, well, that's ironic because you didn't send this. So she said there were no documents, and then I had one of the documents, and so they had to recertify it. That is why we need to be able to question the witnesses. about that. And that's why that was not, they didn't produce all responsive documents. That's false. They did not. We have documents that are responsive that were not produced, that we have submitted into evidence in this case. So we have a right to question the witnesses about that. But that's back for the September 5th subpoena. Moving on to the September 19th, the one for today, their motions to quash admit that they received it. They received it by email. They're claiming that it's defective because they haven't picked up the certified mail copy. Well, they could leave that there as long as they want. We are members of the bar. They are county employees. They're tax-funded paid employees that work in this office. Everybody was still under subpoena from the last hearing. This is about documents.
Well, let's be specific though, because part of their argument is that the last subpoenas that were served for September 5th, as I understand it, their arguments are twofold. One is that the argument was for the production of documents, not for the appearance of a witness, which this happens pretty routinely. You send somebody a subpoena and what you need is for them to give you the documents. And once they give you the documents, then you consider their obligation of that subpoena satisfied. I'm not saying that that's the rule. I'm saying that's typically how it's done. So one argument is that it was for the production of documents, not for them to appear as a witness. And number two is, to the extent that it was for the production of documents, which you've already addressed, they comply by saying either here are the documents I have or I don't have any documents. So start with, because I think it's clear that the newer subpoenas that you sent, at least by representation, were very clearly for appearance to testify at a hearing. So start with addressing the issue of whether or not the prior subpoenas that nobody objected to were in fact sufficient to require their appearance.
Well, because, and we addressed this. So the reason they're sufficient is we addressed this at the hearing, and it was all by consent. We asked, and the reason that we asked was because we were afraid that they would try to evade service. And you asked if we were okay with an expedited discovery process. We waived our right to discovery. We waived our right to do depositions in this case. We waived our right to do notices of production. We did that because the county, the defendants, agreed to an expedited hearing, and they agreed that the 19th would work. So we did that in good faith, believing. They said they were not going to file motions to quash. Mr. Bowman at the end said he was not going to engage in that. We asked that. We asked that on purpose. You cleared your calendar. You gave us dates that were available. We all talked about the dates. We all did that in good faith. Had we known at that point, had they told us, hey, what we're really going to do is we're going to agree to this date and then we're going to hide from your service so that you can't actually subpoena any of these witnesses. That's what we're going to do. Then why would we have agreed to that? You were offering us an expedited hearing date. We were trying to minimize costs and get the documents. We've been trying to get them for 10 months now. We're just trying to get the documents. And so that's why. I mean, the subpoena, it was clear. Everybody in that hearing agreed that the subpoenas were going to continue. You even mentioned to them, are you really going to make them reserve it? That just drives up the cost. Then, Judge, just so you know the history, so that happened at that hearing. Us being extra cautious, emailed Ms. Monroe immediately after that hearing. And I said that I was worried about it. And I asked them specifically if I needed to reserve these subpoenas. And they told me that if they were properly served, we did not have to reserve them. Nobody has said that our original subpoenas were not properly served. They said we did not have to reserve them. She said that by email. Then she backtracked and said, oh wait, actually the DA's office, you have to reserve them. We can't accept service for the DA's office. So this is like a week ago. This is after we've agreed to this expedited hearing. This is, and we emailed them and said, are you gonna make us reserve them? Do I need to go get a process server? We already have $1,500 in fees. I have over 100 hours in this case. John has 70 something hours in this case. We just wanted documents. I mean, it's getting ridiculous. So are we gonna have to hire a process server now to go and serve them?
I don't think the law, I mean, process servers are required for summons, but I think anybody over the age of 18, including even lawyers, can serve a subpoena. As I understand it, the alleged defect here in the motions is that it wasn't personally handed to those witnesses. That I think instead it was delivered to like the front office of the DA's office, for example, since these are DA employees. And it was served by, mailed, I guess, by certified.
Certified mail, which is what the statute requires.
Right, was it return receipt requested?
Yes,
Okay.
and that's all that the statute requires.
And is it your understanding that no one has signed the return receipts?
Correct.
Okay.
And so it's left at their office.
Right, and then also, I think I understand you to have served them as a courtesy by mail, even by email, even though we all understand that as yet, email service of a subpoena not acceptable, not
Exactly.
sufficient.
And we wanted to give them as much notice as possible. So as soon as Ms. Monroe told us that we were going to be forced to reserve the DA witnesses, we resubpoenaed them by email. We sent that all to them by email, offered, just like we did in the original email, if there's any confusion or concerns, reach out to us. You know, the only response I ever got was, don't talk to me. Don't email me again. I mean, you know, there's never been any discussion. We've tried to do this. But the law just says we have to serve them by certified mail. That's what we did. That's what the law says. And in their motions to quash, they cite one case. They cite Edenfield. Edenfield it actually supports our position. It was a law enforcement officer who was not served by certified mail. He was served by personal service. Someone went there, marshal, and tried to actually serve him in person, and they left it in a mailbox. So it was like an administrative mailbox. There was no proof that he ever got it. They admit in their motions that they received these. There's no question. There's no hide the ball. No one has hidden these. And the other thing that they argue is that it's oppressive to ask for all these documents at this point. These are the same documents. And that's one of the things I want to talk about is relevance, because they also argue that. And I think these go hand in hand, whether or not it's oppressive and what's the relevance. So I'm going to walk through these because this is sort of the elephant in the room. What are we asking for? All you've heard is it's oppressive. Why is it relevant? Why are these witnesses relevant? I'm going to tell you why they're relevant. I'm going to walk through all of that, why they're relevant. So we asked for essentially a couple different classifications of documents. You've heard a little bit about the critical mention documents, Judge. Those documents, and we've got some exhibits to show you, but the first one would be Merchant 0029, if you want to go ahead and pull that up. On January 18th, Shalonda Miller, who's the county attorney, and we filed all these. So when I refer to the merchant number, that's a Bates stamp number that we submitted, and so we'll be pulling those up. And I asked the county, and they said they would agree to all of these documents being admitted because they're all documents we received from the county. So, unless there's any objection to them, I'm planning on referring to these documents.
Is that right?
As I stated to her in the email, there was no objection.
Okay, so, great.
Okay, so this document, let's just take a look at it. So this is part of the packet. It's a 44-page packet that the county attorney sent me on January 18th, in response to my first open records request. If you look at 0055, so look at 0055, Judge, and look after Melissa Fritz, where it says Fonnie Rillis, critical mention search.
Your Honor, I'm sorry. If I may interject here.
Yes.
There was a representation made by Ashley Merchant that these documents were provided by Fulton County, and the documents that she's showing on the screen as is was not provided by Fulton County, they were provided by the DA's office. So I wanted to correct the record as it pertains to that. In terms of my objections, I did not object to the business certifications that were submitted by the DA's office and Fulton County, all members who were subpoenaed in this action. But this document that she is referring to, the 44-page document, was not provided by the Fulton County, it was provided by the DA's office.
I understand why you're making that distinction for your record. I'll just point out that the continuing conundrum that these documents were produced not by the apparent only entity in the case that is actually governed, according to the defendant's position, by the Open Records Act. So either they were produced by the Fulton County District Attorney's Office or the district attorney, whatever legal entity that is, who by defendant's argument are not governed by the Open Records Act. But definitely they were not produced by Fulton County, who is governed by the Open Records Act. And I understand why you're making that distinction. I understand that y'all disagree with the court's ruling on your motion to dismiss. But anyway, I understand these documents were produced by the Fulton County District Attorney's Office. Is that correct? Okay.
And, that's part of the reason we need to talk to the witnesses, because, the letters that I get, one of the reasons I saw on Miller under subpoena, the letters from her, and it's unclear to the recipient, the layperson who's requesting these documents, who gives them. Whoever gave them, this is what the county in general gave to us. So if you look at 0055, look at Fonnie Willis critical mention search, and then you look, it's cut and pasted. So this is not an original document. This is actually 4 or 5 different emails that someone cut and pasted and put together. We have now gotten, as of August 30th, the actual emails with the to and from, the dates, the attachments, but we did not get them back then. So we've got a cut and paste documents. I don't know who altered this. That's why I need to ask these witnesses. I have no idea who did this, but they cut and pasted. They didn't redact. They actually cut and pasted these documents to hide things from them. And if you look at.
Well, hang on. Let's be cautious about our characterizations. I understand that you are distrustful of what's been produced. Saying that it was redacted or that it was cut and pasted is a factual statement, but characterizing it as an intention to hide evidence from you is a little bit more of an argument that I would prefer that we not go down that road unless and until we need to.
And let me re-clarify that we have a right to question how this was compiled and why this is what we got in response to an open records request, how it was altered, why it was altered, who directed it to be altered, those types of things. Those are relevant to the open records inquiry, and that's why we need to question these witnesses. So as far as relevancy, this is just one of the examples. And I can show you if you want to pull up 0138 through 0140, what we received 2 weeks ago. This is the email. And then you see the attachment, critical mention screenshot. This is what we've been asking for 9 months.
Right, but I thought leading up to the September 5th hearing that I had seen some email traffic indicating that that document, whatever that PDF was, had finally been provided to you.
On August 30th, yes,
Okay.
it was. And I actually wanted to clarify that. So since you brought that up, I'd like you to take the chance to clarify that because the state did, I'm gonna mess that up again, I'm sorry.
That's fine.
The defendants, Ms. Monroe specifically, said that the brief update was that this case had been deeply rooted in the alleged failure to provide documents or attachments. And then she said the attachments were provided 9 months ago. As of yesterday, we learned it was not an issue of providing those attachments. It was whether or not the requester, us, had the ability to view the attachments. And that they argued to the court that there was nothing left to do. They said they provided the records 9 months ago with those attachments and that it was very likely.
I remember that argument and your response that was not an accurate recitation of what occurred and that you reviewed what was provided to you and it did not contain either the physical copy or an electronic link that would allow you to observe or view the PDF document. I'm not saying that's factually correct, but I am aware of that representation of what the defendant's position is and your response to it.
Well, that's no longer their position. So
Okay.
they have told us that they are not the same. The 44 pages we were provided in the open records is not the same as the 197 that were provided 2 weeks ago in the lawsuit. They're not the same. So that representation was not accurate and I think needs to be corrected. We were not provided those attachments. They said that they were in the process of reviewing and comparing the documents provided by the DA and Fulton County IT. 9 months later, they're in the process of reviewing those. So it's clear these are not the same documents. And that's part of why we're here. That's part of the litigation and why it's relevant to question these witnesses. What this whole hearing is about. Who supplied the 44 pages? Who decided what was in it? Why the other documents weren't provided? And what else is outstanding? What else is there? Because this was a contract, a media monitoring contract that was renewed by the county. It was so valuable it was renewed. And they want us to believe that there were 2 reports for a 2-year media monitoring contract, that they had 2 screenshots. And that is the extent of all records from $20,000 spent to a company to monitor Fonnie Willis's image. I think that we have a right to ask them that on the stand, if that is really all of the documents that exist and what steps they took to actually find those.
So if we are limited to 6 people, and it sounds like more directly, at least as an initial matter, your focus had intended to be on 3 people, one of whom's job is clearly, like that's his title.
Yes.
Is to comply with open records requests. Let's assume for a moment that I would agree with you that assuming that the nature of your questioning is narrowly focused on those issues associated with receipt and compliance and effort to respond. from a relevance perspective, what of the defendant's argument or the non-party witness's argument that these are, the need to question them is overburdensome or harassing?
It's not. These are public documents. These are documents that they are required to maintain. The law requires that they maintain these documents. So us asking them about these documents, it's very simple. These are documents that they have a public duty to maintain. The taxpayers paid for this. This wasn't something that was privately paid for. The taxpayers have a right to know what they're spending their money on. And this is just for critical mention. There's other classes of documents that we haven't even gotten to. But this is just for critical mention. These are open records. These are records that we're entitled to. I asked for them, I'm entitled to have them. There's nothing oppressive about asking them under oath, what did you do to find them? How do I know that I actually have all the documents? How do I know you didn't not give me something? Because we actually have proof that they did. We have a pattern already because they gave 44 pages and they were cut and pasted. And then later on, they gave us other documents. The documents they gave us on August 30th have some redactions in them. I still don't know what their redactions are. Why? I know what they are because they gave me the redacted information back when they gave me the 44 pages. I don't know why all of a sudden they decided to redact it. But we have a right to ask that. It's not oppressive. These are not difficult questions. It's not deep diving. They are public servants. This is a tax. The money, Fulton County paid for this service. We have a right to know what it is, and they have a duty to maintain it. So that's part of the issue. They have a duty to maintain this, and they have a duty to have these records, give us these records if we want to. I mean, that's the whole point of the open records and open meetings requirement. To be able to peel the layers back and see what's going on, see where taxpayer money is going. If you've got a district attorney that's asking for extra funds, saying I can't process rate kits, I can't do all this other stuff because I don't have any money, we have a right to know where that money goes. It doesn't have to be related to any case. I can just be curious. I'm a taxpayer.
So, I mean, I understand your argument. I mean, I think we should all take a step back though and be reminded that the Open Records Act doesn't require a showing of relevance. It simply requires the demonstration that the records are public. I don't think there's any dispute that the documents are public records. And the question really, to my understanding, is the extent to which they are maintained in the normal course and to be produced when requested. And if they weren't, then why? I mean, that to me, I understand what your argument is, but respectfully, I don't need to know why you think those documents are important. What I need to know is, does anybody dispute that those documents are public records that would be subject to the Open Records Act? Which I don't think there's any dispute that there is.
And Judge, I agree. I'm arguing the relevance because they brought that up in their motion to quash. They said that these items are not relevant. And so I'm trying to explain why they are relevant.
Right, and my point in saying I don't think we need to go there is that I don't think that relevance is a relevant inquiry in an Open Records Act litigation, because in a civil case, obviously, there's always a question of is this reasonably calculated to lead to the discovery of admissible evidence? What is the relevance of these documents? Are they material to the issues in the case? Here, the issue that those issues don't have to be reached if the documents are themselves understood to be public records. And again, I'm not aware of any assertion other than the argument that the district attorney is not governed by the Open Records Act, which is a different issue. I'm not aware of any formal interposition of an exception that these records would fall under, other than I think maybe I saw some informal communication about perhaps invoking work product or attorney-client privilege, which is one of the exceptions. But I think all of the formal responses and certainly all of the briefing do not assert that any of these records are subject to an exception or that they are not in and of themselves public records. So I think we can move on from there and simply focus on the extent to which asking these witnesses questions because I think that's where the defendants go mostly, is that asking them questions at all when they've already said on a document we don't have these records, I've looked and they don't exist, or I don't have them, that itself is the overly burdensome or harassing part.
Judge, I should be able to ask them if they've looked, because I don't believe they have looked. And so, and I know my belief doesn't matter, but I've submitted documents that exist in response that they have not provided. I've gotten them from other entities. So I have proof that they have not complied. So we have a right to ask them, how did you look? What did you do in response to this? And if I can go through, there's a couple, so let's talk about the confidentiality agreements. I asked for all of the confidentiality agreements that the district attorney's office required employees to sign. I requested that on January 9th in my open records. I followed that up on January 24th and said by letter, please don't make us sue you. I want the confidentiality agreements. I had one. I had Nathan Wade's. I had gotten it in another proceeding, and I had a business record certificate from Dexter Bond that it existed. Guess what his response was? No records exist. Well, so I've got a business records, which I've admitted, it's in the documents, a business record where he's certifying a confidentiality agreement from Nathan Wade, and then I've got the response in the open records that no responsive documents exist. So I should be able to ask him, why did you tell me no responsive documents exist when you were asked in a other case and you certified that they did? And now, just 2 days ago, I was given 22 additional confidentiality agreements. 10 months later, 22. I know more exist, but I was given 22. So pick and choose 22 employees in the DA's office who have signed confidentiality agreements. Jeff DeSantis, one of the witnesses we wanted to subpoena, gave a media statement that there had been confidentiality agreements signed in error and they were withdrawn. I followed up with that with another open records, making sure that they knew what I was talking about. You're giving the media a statement saying they exist, and then you're telling me in open records they don't. I have a right to question the witnesses about that. Why do I still not have those documents? I have 22 confidentiality agreements. I don't have them all. And I only got those 2 days ago. The next is, this is one of the most simple requests that the district attorney's office is actually required to do by law, keep a list of attorneys that work at their office. My requests, I think we've gotten lost in the weeds. They're not complex. They're not oppressive. I'm not asking for information I never in a million years thought in January that any of this was going to be a problem. I file open records requests all the time. I pay for the documents, I get the documents and move on. I asked for a list of attorneys and their dates of hire. Georgia statute and the record retention law requires that they keep those in their office. It is a misdemeanor not to keep that.
Keep those, keep what?
The personnel records.
Okay, but in fairness to the defendants, and I know that's one of the things they've asserted, if they don't have a list, right, they might have let's call it, they might have a file cabinet somewhere, probably electronic, of personnel files of the people who work in their office. I know you've mentioned, and I am familiar with the reports that the DA's office puts out that says these are all of our great people who are doing great work. But if they don't have a list, they're not required to create a list in order to respond to your request.
Correct, they're not. But what they are required to do is be reasonable in their response. So if they think, when I ask for the names of the people who were hired and the dates that they were hired, and that's something I know that they have, and they're not sure, they ask me, and I do this all the time, and they did this. The county attorney, actually, when they were responding to my requests, they asked me to clarify. We discussed it. They reached out to me, made sure that I was getting the documents I wanted. The goal of the Open Records Act is supposed to be to give the citizen asking for records the records. It's not supposed to be hide behind semantics. So if they're concerned because they're like, oh, are you asking for the names of the people who are hired and the date they were hired, which is what I asked for? If there's some confusion, they reach out to me. The goal is transparency. The goal is not to hide and obscure all of this. So when I asked for the people who worked there and the dates they were hired, I used to work for Fulton County. I know those records exist. I know what my employee file looks like. I also know that there's a statute in Georgia that says they have to maintain those. And so I'm asking for it based on what the law requires they maintain. They have to keep that. And I guarantee when they sent this to whoever produced this, they sent this to someone. There's a list that exists somewhere that has the names of the DAs. I can go to the state bar and type in the Fulton County DA and print out a list of the names. This is, they're forcing us to go through litigation to get a name and a date of hire, which is definitely maintained, and that's ridiculous. The other thing that we've asked for is, and by the way, just on that, the personnel, the Records Retention Act. So there's a statute in Georgia that requires, it's 50-18-102. It's a misdemeanor to not keep records in regards to what the Records Retention Act requires. The Records Retention Act requires that they keep personnel records for 50 years.
Now we object to this line because the Records Retention Act is not part of this case and from that way.
The retention is always relevant to the records judge.
So I'm not sure I understand the basis of your objection. I'm going to overrule it for now, because whether the county has the documents that have been requested, I think goes immediately to the extent to which they're obligated to have them. I agree that no one has sued or asserted a violation of the Records Retention Act, but to the extent that it's in the same title, it is informative about what the understanding and obligations that parties might have about those documents existing and continuing to be maintained. So to the extent that you're objecting that they're asserting a violation of the record retention obligation, I agree with you. We're not going down that road because that's not before us. But to the extent that that statute can be informative about whether the documents that were requested should still exist, I think I'm going to allow it. Go ahead, Ms. Marchand.
Thank you. And I'm not going down that path deep. It's just when I am asking for records, I have to make sure that they exist before I ask. I don't want to waste my time in an open record. So I use these statutes to ask for records. And when I'm told they don't exist, and I know the law requires they exist, that's concerning. And I have a right to ask follow-up questions to that. For example, on the personnel card, the law requires that the DA keep a list of all employees with ID cards. They have to keep that list. They have to maintain that list by law. If you have an ID card, and everybody has an ID card, I was a Fulton County employee, we all have an ID card. You have to keep that list, and you have to keep it for 4 years post-separation. So when they tell me they don't have a list, I think I have a right to not believe that. And I think that's why I have a right to question these witnesses. Where is that list? Why am I told that there's no responsive documents? Other places there could be responsive documents. The law requires they keep property receipts of everybody who has a cell phone. The district attorney's manual says that every attorney employed has to have a cell phone and a laptop. It's in their manual, it's required. The law says they have to sign a property receipt and they have to keep that. They have to keep a list of that. That would have been responsive to the request. And if they wanted to comply, they could have reached out and asked me, and I was willing to pay for any of these records. I pay them all the time for records. It's not a problem. I've never become paying for county records. All they have to do is ask me. So the other area, the last area, actually the second to last area of documents and why these witnesses are relevant, this is all talking about why I should be able to ask these witnesses questions. I asked for forfeiture disclosure reports. The law requires forfeiture disclosure reports to be produced to state, local, federal governments. There are two separate forfeiture funds. There are federal money and state money. Two different acts. They have to comply with the Federal Forfeiture Act and the State Forfeiture Act. Every district attorney has to file a report with the Prosecuting Attorney's Council every single year, and they have to file one with the DOJ every single year. I asked for those reports.
And those are not accessible to you publicly?
I got them by subpoena.
No, let me clarify.
No, they're not.
They're not publicly maintainable in a database that's accessible to the public other than by requesting them through FOIA from the DOJ or from whatever entity maintains them for the state through an Open Records Act. Is that?
To a certain extent,
okay?
Let me clarify that because I want to make sure I'm completely accurate in my answer. The Carl Vincent Institute at the University of Georgia maintains some of them. They do not maintain all of them. In this case, the Fulton County actually misspelled the name at the beginning, and so you couldn't find it on there. So when I first actually asked for this, I couldn't find it and I had to call them and I ended up getting it through PAC, but I couldn't find them on Carl Vincent because they misspelled it. And so it's a search and it comes up by the county and it was in the wrong place. So it's not, but they're not all there. Some of them are there, but not all of them are there. So I asked for the documents from Fulton County. The point is,
Hang on.
Mhm.
You submitted, just to Ms. Monroe's earlier point, you just said you asked for them from Fulton County. And I know there's some discussion in the briefing that there was in fact one request that was formally directed at Fulton County as opposed to the district attorney's office. Is that what you're referring to? Or are you colloquially referring to Fulton County under the umbrella of you asked for these documents because they belong to an entity in Fulton County?
I think the best way for me to say it is I asked through the portal.
Okay.
I asked for the open records
So you
portal.
submitted a request through the portal for forfeiture disclosure reports for some period of time related to something.
Yes.
Okay.
And what they do, so it's actually changed. When I first asked for these requests, if you go to the DA's office, the landing page on the DA's office takes you to the portal. So back in January, if you go to the DA's office website, it has an open records link. It takes you to the portal, the county attorney portal. When you go to the portal, you submit your open records, okay? But you can start at the DA's office, but it bounces you to the portal. Then you put it in the portal. You can click down if you know the entity. You can click down, I want it from the district attorney, I want it from the county attorney. I'm over-inclusive because I've learned that I'm regularly told we don't have it, so I make sure to ask anybody who might have it. So I put it through that. 2 weeks ago, that open records link was not there anymore. Now it's back. So I don't know, currently, I don't know why it's been changing, but when I submitted the request in January, I'm making representations based on how it existed then. I clicked on the DA's office open records link, it took me to the county attorney portal. That's where I requested that. So I requested, on January 16th, I requested the reports and the itemization. The reason I requested the itemization, and I actually put the property, the funds obtained, these reports that are required by law, the statute actually says how you have to report them. And I will tell you, the ones that are on the Carl Vinson Institute, they don't comply with the statute. So they're not complete. So I'm assuming maybe they've got other documents because I'm assuming they're complying with the law. I'm asking for those. I'm asking for those forfeiture documents. I asked in January. Mr. Bond sent me a letter January 26th that said the records are attached. They were not. Only the equitable sharing, which is the federal summary, was attached. None of the state forfeiture documents, none of the ones that the law requires that they itemize were attached. Kept asking, been asking for 10 months for these documents. In the meantime, there's been media statements made by the district attorney's office that it was false and it was an error that any forfeiture funds were paid to any private contractors, Nathan Wade in particular. The forfeiture funds were used to pay Nathan Wade. It's clear from the documents that I got from purchasing and finance.
So again, I do not want to go down the road of what it is you believe these documents are relevant to, what use you plan to put them to. The issue before me is the testimony of these witnesses relevant to your public records request? And again, absent having heard anyone assert that an exception applies or that these documents are not public records, then to me, the issue is the extent to which you are questioning of any witnesses about their processes and efforts to comply. As long as it is narrowly focused on that issue, I think you've met your burden for relevance to the public record request. Not, because again, what you think they might be useful for or why you want them, my understanding is it's very clear. The reason that a member of the public requests a document has nothing to do with anything.
I completely agree, Judge. And the reason I was pointing that out is because when statements are made about documents that I've been told don't exist, that causes me to think I need to question a witness. If you're telling the news that a document that I've requested and you tell me doesn't exist, you're making statements about them, that leads me to believe that they do exist. So that's why I want to question Mr. DeSantis, because he's made statements about documents that I was told don't exist, that I do believe exist. So that was it. And I'll move on. The last one, though, is the promotional materials. So if these things, they're paid for somehow. And I was very specific about all of these. If you walk into the DA's office, there's big wall hangings, things like that with, rebranding. There's this whole rebranding campaign. I asked for how that was paid for, like rebranding, payment, requests. I tracked the statute. I tracked So the statute, and the reason that that's relevant, tracking the statute, is because I know they're required to maintain these. The law says they're required to maintain these. And so because they're required to maintain this, and it's an open record, and I'm told that they don't exist now, I think I should be able to question the witness as to why they don't exist. If they don't really exist, under oath, the law says that they've got to include all the accounts payable, bank statements, all of this stuff, deposit slips, canceled checks. They have a duty to maintain that for 5 years pursuant to statute. So where are all of those documents? And I was again told they don't exist. They have to exist, or else, I mean, they should exist. I guess maybe they couldn't exist. Maybe they didn't pay for them. Maybe these vendors donated this out of the goodness of their heart, whoever printed this. Maybe the taxpayers didn't pay for it. I don't know. But that's why I need to ask the witnesses. And the last thing I'd point out is to relevancy. It goes along with the paycheck or the accounts payable. I asked how critical mention was paid. I've been asking for 10 months how it was
Can
paid.
you finally get, I think in some of the documents I saw,
For
a
critical
check,
mention.
like a handwritten check.
Yes. I still haven't received that. They still not even admitted that exists, that account exists. I got that from critical mention. That the reason that that's relevant is because part of what you have to decide is if they have been hiding documents, obscuring, keeping things from us for 10 months. Did I have to file a lawsuit to get that? Did I have to waste all of my time to get that document? I still wouldn't have it from them because I still don't have it from them. They're required to maintain that. They're required to keep canceled checks. I still don't have that from them. I had to file a lawsuit to get it. So it's relevant for you to inquire as to whether or not they've complied with the open records request, for me to ask about that. So I think all of these things, Judge, are why we should be able to question these witnesses. Thank you.
Thank you, Ms. Merchant. Who am I gonna hear from first? Ms. Alavi or Ms. Monroe?
I'm happy to go first, Your Honor. Thank you so much.
I'm sorry, Your Honor, do you mind if we pause for a small bathroom break? I really have to use the restroom.
Sure, no problem. We will take, it is 10:56. We're gonna take a break until about 10 after 11.
Thank you.
Thank you. Yeah, one call.
Okay, grace and peace, everybody. That was yo. Ashley Merchant did not come to play games. He said, I'm not playing no games. I'm taking names. That was amazing. That was great. But I think the thing is kind of lost. And I literally just posted it right here. Oh, wait. We got a new witness on the stand over at YSL. Who is that?
No. Do you recall telling them anything about
Oh, and it's love.
anyone that might have wanted harm to Kelvin?
No.
Okay. How long do you recall, if you recall at all, the police being on scene?
I don't know.
All right.
I wasn't there.
Were you there when you got called and you came out?
When I got there, nobody.
Okay, I'm trying not to. I don't want to miss Ashley again. Is this her?
I don't know what they're gonna do. She's just not been sworn in, no. No. Mm-mm. Is it okay if she uses her first initial?
That's fine with me.
Yes.
Oh, this is her? Oh, she big man. Oh. Darn it. All right.
Right.
Oh, She ain't happy at all. All that's gonna be. Y'all put some spiders in the eye. Spiders in the.
Thank you.
in the chat.
Okay, Ms. Love, go ahead.
Did she get sworn in?
Can you stand up to be sworn, please?
I do.
I need you to state your first initial and your last name. Spell your last name for the court.
A. Smith.
Would you spell is common spelling for Smith?
SIMTH.
Okay. Thank you, and good morning, Ms. Smith. It's still morning.
Good morning.
All right. Ms. Smith, would you tell the jury where it is that you're from?
Atlanta, Georgia. Born and raised.
Born and raised in Atlanta?
Yep.
All right. And on January the 28th of 2015, did you live in Atlanta?
Yes.
All right. What was your address?
I don't remember the address off Cleveland Avenue.
Do you recall during that time living on Springdale Road at 2905 Springdale Road?
Yes.
All right. Now, were you living there with anyone or were you living by yourself?
By myself.
And is that an apartment, a house? condo?
Townhome. A townhome.
All right. And you said that it was off Cleveland Avenue?
That's what I said.
Okay. Ms. Smith, were you living at that time in apartment P3?
I don't remember the address.
Okay. Do you recall having a neighbor by the name of Gilberti Mack?
I do.
And do you recall whether you asked Mr. Mack to put cameras on his house?
Can't tell nobody put a camera in their house. That's their house.
It is. Do you recall whether you ever requested that of him?
I didn't.
All right. Now, back on January the 28th of 2015, how long after that date did you live in those townhomes?
Left.
Did you leave on that particular day or the next day or shortly afterwards?
I wasn't there before that.
Okay. Now, when you say you weren't there before that, what do you mean?
I just wasn't home.
Oh, you mean you were home on January 28th?
If that's the date, I wasn't there.
Okay. When did you move out of those apartments?
I don't remember the exact date. The day they said I had to leave.
Did anything precede your having to leave?
A shootout.
All right. Now, when you say a shootout, what do you mean? You weren't there, so what do you mean? And the jury hasn't heard this, so please tell them what you mean when you say a shootout.
I mean, I had to go there. I got a call from the rent office saying that my house got shot up.
Okay. And was that at night? Do you recall?
I think so.
All right. And so when you go on scene to see what's going on, what do you see?
Bullet holes.
Where do you see the bullet holes?
I don't remember exactly what a bullet holes was.
As far as not specifically remembering them, what I'm asking is, are they inside your home?
Correct.
All right. Do you recall whether the window or the door was hit or something different?
No.
All right. Now, when you got there, were there police inside your home?
No.
Did the police go inside your home with you?
With me, no.
Did they go inside your home?
I'm sure they did.
All right. Now, when you say a shootout happened and after that you left, do you know how long it was after that that you left?
No.
All right. At the time that you lived, and I don't want to get too much into your personal business, but at the time that you lived at that apartment complex off Springdale Road, did you know a person by the name of Kelvin Watts?
Of course.
Okay. And what did you call him?
Shell.
Okay. Shell, did you also call him Lil Kel?
No.
Okay. Did you ever call him by the short
No.
name Kel?
I just told you, Shell.
I understand. So at the time, around January 28th of 2015, or before, had Shell been hiding out in your house?
Sustained.
Had Shell been staying at your house at all?
We was dating.
Okay. How long had you all been dating?
A few months.
Now, when you were dating, did Shell stay at your house sometimes?
He didn't stay.
Did he ever hide out at your house?
He visit. I just answered your question.
I understand. Did you ever tell police on January 28, 2015, that Shell had been hiding?
Objection, Your Honor.
I just
That
answered your
calls for
question.
speculation.
Overruled.
And Ms. Smith, I'm not going to keep you up here very long, but I'm going to ask you a specific question because the jury, Your Honor, if I may just be a little.
Overruled.
I'm going to ask you questions so that the jury who doesn't know the answers, so that you can answer for them, okay? Did you tell the police that night that your friend Kelvin had been hiding out at your place?
I did not.
Okay. Do you remember talking to police that night?
No.
Do you recall the name, or do you recall an Officer Collins being the officer that responded to your scene?
I do not.
Do you recall what the officers looked like?
I do not.
Okay. Do you recall talking to anyone about your friend Kel in the presence of officers?
No.
Do you recall telling them anything about anyone that might have wanted harm to Kelvin?
No.
Okay. How long do you recall, if you recall at all, the police being on scene?
I don't know. I wasn't there.
Were you there when you got called and you came out?
When I got there, nobody was there.
So you don't.
Next day, I went down the next day. They said I had to come the next day. You said when I got home, they wasn't there when I got home.
So the night that the rent office called you, is your testimony?
The rent office, just, I know the person. She called me and told me. The next door neighbor called and told me my house got shut up.
And what was the name of the next door neighbor?
Just called his name. G. Gregory, whatever his name is.
Gilberty Mack?
I know him as Gio.
Okay. So when Gio called you, it was that night that your house had just gotten shot up?
A few people called me. It wasn't a secret.
All right. And did you arrive on scene that night? Did you get back to your house that night?
I came, nobody was there.
Okay. Do you know about how long after you called, or you were called, that you came back to your house?
No, I do not.
All this.
Did you know any members, and I know this sounds like it's obvious, but do you know any members of your friend Kelvin's family? Did you know Donovan Thomas?
I did.
Were you close with him?
Yes.
All right. And were you able to observe Kelvin's interaction with him?
I wasn't.
Okay. Do you have any knowledge of whether Kelvin was
Nope.
close to him?
Nope. I do not.
At the time, did you know an Antonio Sledge?
Of course I did.
Why do you say, of course you did?
Because I dated him.
All right. Were you dating him at the same time you were dating?
I wasn't.
Kelvin, how long before your house got shot up did you stop dating Antonio Sledge?
A couple of months. The same time I just told you when I started dating Kevin.
Okay. And what did you call Antonio Sledge?
Monktoon.
Monktoon?
Yeah.
All right. How long had you known Monktoon by that time?
Been knowing Monktoon since I was like 15, 16 years old.
Okay. How long had you known Kel or Shell Kel at that time?
Not that long.
Okay. Now, at what point do you now recall speaking to the police at all about shooting at your house?
I don't.
Do you recall ever communicating with the police in any way?
I just told you. I went down the next day. You just asked me that.
Okay. Who did you talk to when you went down?
I
the next
don't
day?
know.
Where did you go down to?
The headquarters.
Right. Do you recall an investigator, Dennis?
I just told you. I don't remember nobody's name.
Okay. Do you recall providing a video to the police?
I don't.
Do you recall a video wherein Antonio Sledge was talking to the camera?
It's all on social media. I play it, so of course I seen it.
All right. Could you speak into the,
It's on social media. Of course, I seen it.
now, when you say it's on social media, of course you've seen it. What are you talking about that
The
you
video
see?
that you're talking about, the trial is on social media.
Okay.
So yes,
So-
I seen the video.
Oh, so she's been.
And describe the video that, since we've shown a lot of them, that you're talking about.
The video of Mootson calling Shell Kill out.
All right. Did you know at that time Lil D?
Of course I did.
All right. How long had you known Lil D?
I don't know.
All right. Now, the video of Mootson calling Shell Kell out, did you provide that video to the police?
I don't recall.
Do you recall emailing anything to the police?
I don't recall.
Do you recall an investigator Gaither?
I don't recall. I just told you I don't remember nobody's name.
All right. And to be fair, do you have any desire to be here today?
No.
Thank you. That's all that I have.
Oh, really? That's
All right,
it?
Do any defense counsel have questions for this witness?
Not on behalf of Mr. Stillwell.
Thank you. On behalf of Mr. Williams, no question.
None, none, none. All right. Thank you. You're excused.
Oh, and
Oh, yeah.
Ashley and them are back. Right on time. Oh, okay, we gotta jump back to Ashley.
Your Honor, the state calls Ms. Lattimore to stand.
All right.
All right, I think the state is calling another but
And she's already been sworn several times, so.
oh yeah,
we'll
they're
just
just calling
remind
another
her
police
that
officer.
She's still under oath.
Let me just double check. Yo, that was a lot of attitude. There was a lot of man. I wanted some more. It was a waste of time. Technically, but I just wanted love to have another cantankerous woman to deal with.
Okay. So you're saying don't get on you too much. Okay. Got it.
All right, we're gonna jump
Somebody
over
else
back
knows if
over to the
she's not
state
finished, do
and
you have
Ashley.
somebody else ready?
It should be quashed because these employees have not been properly served. They have no firsthand knowledge of relevant issues with regard to the open records matter before this honorable court. I'm going to put an asterisk next to Dexter. He's a little different, so I'm going to separate him out from the other employees. And
I know that your motion is also procedurally differently cast regarding him. Is that right?
yes, that is correct. And you talked about that a little bit with plaintiff's counsel with regard to Mr. Bond having knowledge and being the business records custodian for the office. So his motion is filed as a release from the original, what I call the original subpoena, the one that was received via email on August 2nd of this year. And so his is a little different. And the subpoenas are unreasonable and oppressive. And as I just stated, on August 2nd of this year, the plaintiff emailed a number of subpoenas to members of our office. Those subpoenas were subpoenas for the production of evidence. They did not require witness testimony. Specifically, each email contained a business record certification, which we, each individual, Jeff DeSantis, Paula B. Bailey, Kevin Armstrong, Jeremy Murray, Jasmine Dilligard, and Dexter Bond completed those business record certifications along with the responsive documents, and did provide that to counsel and to this honorable court. And we subsequently, on the 13th of September, last Friday, did receive via email to one or more of the individuals previously aforementioned, another subpoena for the production of documents along with a witness subpoena. But I want to note for the record that that subpoena is different. It asks for different information than the one in which the original hearing started on September 5th of this year before this honorable court.
What do you mean different information?
Different information is contained therein. So the first subpoena, the subpoena dated August 2nd, 2024, asked for 4 items, all emails and text messages concerning critical mention, etc. Second, all emails and text messages, including links with regard to attachments with critical mention. Number 3, PowerPoint presentation identified as media relations executive team presentations for November 30th, 2021 PowerPoint. And then number 4, and lastly, for this particular subpoena was an analytics graph. The email subpoena that was received by members of the office dated September 13th from the plaintiff's firm asked for 7 things. It asks for critical mention emails and texts, checking account information through a Wells Fargo bank with an account number, confidentiality and non-disclosure agreements. Number 4 is forfeiture documents. Number 5, attorneys hired and dates of hiring. Number 6, promotional material. Number 7, rebranding material. Different. We've already started this proceeding. We've already had some arguments with regard to the issues contained therein, and then we get an email saying that we're going to receive certified mail with yet another subpoena asking for different things. And so I'll talk a little bit more about that when I get to the overburdensome portion of this argument. The emails, or excuse me, the subpoenas that we acknowledge receipt of, because there was never consent or agreement or waiver that the emails from August 2nd were properly served. However, District Attorney Bonnie Willis, members of our office, we always try to ensure that individuals that reach out to our office have the things that they need. Transparency is a touchstone of who we are as prosecutors. We take a special oath to ensure that individuals that come before us or who contact our office are serviced well, that our constituents know that we are there for them, and that we are doing everything that we can to get them the information they are looking for. So notwithstanding the fact that counsel has yet again failed to properly serve members of this office with a valid subpoena, we did turn over the documents that were asked for. My motion does not go into whether or not there was proper service with the August 2nd subpoena. At this point, it's inconsequential. She has the information. The information has been provided. We have done that. We have complied at this juncture. We have satisfied the terms of the subpoena. Subpoena asks for documents they have. And so at this point, there's nothing additional that is needed. And I will note for the record that during the September 5th hearing, there were 2 individuals that joined the Zoom, Ryan Holmes and Andrea Geiger, with critical mention. And less than 5 minutes into that hearing, according to the timestamp on the Zoom video, those individuals—
For the record, not an official court record of the proceeding that occurred that day.
Yes, ma'am.
I understand that we can all use it as a reference point. Just to be clear, not an official court record.
Absolutely. Those individuals were allowed to be excused as their business record certifications were sufficient. They did the exact same thing that we did. They provided business record certifications with the information that was provided, that was requested from the plaintiffs. They provided that, and they were excused.
Right, and in fairness, and I don't mean to imply that I agree with plaintiff, but I think plaintiff's position is they had no reason to question the complete compliance with the request that was made to critical mention. And again, I'm not saying it's fair or justified, but the plaintiffs have made a great deal of hay of the fact that they question the completeness of the representations from various witnesses. That in fact, documents have been, all responsive documents have been produced in response to the Open Records Act.
And I recognize that. And I say this in the least flippant way possible, but plaintiff's assertion that there is a belief that she is not receiving all of the information does not make that a fact. It does not make it true. It does
I
not
agree
make it—
with you, but the plaintiff has to some extent been able to point to independent documents received from other entities, like for example, critical mention, that would seem to indicate that additional documents should exist. Maybe they don't anymore. Maybe they're not in possession of somebody. There might be lots of reasons that they weren't produced in response to the Open Records Act that aren't willful or in bad faith. But I think in fairness, the plaintiff has pointed to third-party documents that would seem to indicate that those documents did exist at some point.
And I think in fairness that there has to be a look at the totality of the circumstances. The district attorney's office is not the IT custodian. We only have access to records to a certain date. We do not keep, contain, or have a database that is big enough to keep every single email, every single correspondence, every single document that may have been received within the office. That is literally why we have an IT department. And so if we do not physically have it within our office, we literally, not even 6 months ago, had a cyber attack with this county. And so this assertion that there is a disbelief that there's some nefarious intention, or that we are hiding something, that we are intentionally trying not to give documents or information to the plaintiff or anyone else, is quite frankly just not accurate. Our track.
So here, look, I'm going to back us all up again, because I continue to do this. I'm going to do it again because both sides are doing it. we are here because a member of the public requested from a government agency documents about that government's operations, right? And so the intention behind that request, the purpose that might be intended to use those documents, none of that, to my way of understanding how the Open Records Act is supposed to work, none of that is relevant. What is relevant is the extent to which the government agency should have those documents and should respond to those documents. And one of the things that's presented an issue, and that's one of the reasons I stopped and went back to this, is that I have no doubt that you are highly knowledgeable about the operations of the district attorney's office, but technically you are here on behalf of non-party witnesses. And I think it would help if, when you are talking about the motions to quash, if you talked about the specific witnesses that have been subpoenaed and why they should not be subject to subpoena. I understand some of those issues that go across all of them, and let Ms. Monroe and Ms. Bowman argue about why Fulton County and the Fulton County District Attorney's Office writ large and or Madam D.A. Willis do or don't have those documents. And do you understand the distinction that I'm trying to make for a moment?
I do, but
Okay.
with one caveat, Your Honor, the law for service of subpoenas literally states that subpoenas are not supposed to be used to harass individuals or to, to use those subpoenas maliciously. And I do think that that is a point that needs to be made, especially during this proceeding, considering that the usage of subpoenas and the way in which they are used has been done with an intention to harass, to oppress, to malign the name, the character of not just the individuals that are contained, these non-parties, but also the district attorney herself. And so I would be remiss not to note that, and that the law does give guidance with regard to how subpoenas are supposed to be used. The individuals that—
Fair enough, Ms. Lobby, but here's the thing. I completely understand why the defendants in this case, given the arguments that Ms. Merchant has made, that I've again tried to get us away from, and let's focus on, these are public records, that's all that matters for now.
Just
I
give the record.
understand why the DA's office might feel that these proceedings and these efforts at public records requests are designed to harass the DA or the DA's operations. What I don't understand, though, is how is a subpoena to an individual whose job it is to comply with Open Records Act requests on behalf of the DA to come and testify about what efforts he took to comply with an Open Records request. How is that harassing?
Judge, the individuals, the non-parties, Jeff DeSantis, Kalavi Bailey, Kevin Armstrong, Jeremy Murray, Jasmine Dilligard, are not those individuals that are tasked with responding to open records. Their job duties, what they are assigned to do within the office and what they have been doing has never been that. They are not the business records custodians. They cannot talk about in the court, put it very succinctly, the receipt, the processing, the efforts made to process those requests. Those are not the individuals that can provide that information to the court.
I agree with you, except that, again, I think what I think I understand is that the reason that the plaintiff chose to subpoena those individuals is because after being told there were no documents by the official people, they received some documents that, for example, emails that included Mr. DeSantis, that included Mr. Armstrong. And so then the plaintiff said, well, if Fulton County, writ large, the DA, whatever, all these entities, right, to whomever that request was directed, says they don't have them, well, now I want to ask Mr. Armstrong or Mr. DeSantis, were you asked if you had these documents? I mean, and again, the reason I'm trying to narrow this down is because if these witnesses were to take the stand and Ms. Merchant were to attempt to engage them or question them about matters that don't have anything to do with the request at issue and their association with that request, and I would agree with you, that would start to be harassing. But it's my job to narrow the scope of any witness's testimony to the matters that are properly before the court. And that's why I think this is the third time I keep coming back to this issue of these are public records. a request was made, there was some effort to comply with the request, which the plaintiff has asserted was incomplete and therefore is seeking to enforce. And so, as I understand it, the plaintiff wants to ask these witnesses, what effort did you make to comply? Or were you even asked to provide documents that would be responsive to the requests that I made?
And I understand the court's position with regard to that. But we are feeling around in the dark here. We have assertions that have been made that are not facts, that are not evidence. There has been no witness testimony that has been given. There has been no indication that what plaintiff has asserted is true, correct, that it's anything other than some assumption that there is some nefarious intention.
Well,
she has.
Ms. Amati, okay. There are two reasons we haven't heard from any witnesses. Number one is there were motions to dismiss filed by all four of the entities who were sued, right? Which automatically created a stay of discovery. And number two, no witnesses have testified because the witnesses have all asserted that they're not subject to subpoena, or that they don't have any information. So there might be, at the motion to dismiss stage, the court was required to, and did, rely only on the allegations of the pleadings. And I will say, many of them weren't disputed, right? It wasn't disputed that these were records that would be public. It wasn't disputed that there's a portal operated by Fulton County. I mean, there's lots of things that weren't in dispute, but the court was limited to the pleadings, the allegations in the pleadings. The purpose of today's hearing is to have some actual evidence, to hear from witnesses with knowledge about the nature of this request and what efforts were made to comply with it.
And those individuals, as discussed in the last hearing, have been designated. We know who those folks are. Dexter Barnes Jr. is one of those folks. Shalonda Miller, Deputy Counsel, is one of those folks. But those folks still are not Jeff DeSantis, Palaji Bailey, Kevin Armstrong, Jeremy Murray, or Jasmine Dillard. They have never been considered to be those folks in the discussions and the hearings that were had on the 5th. Their names never came up as individuals that would have information that would better inform or edify this court as to the receipt, processing, or efforts made to process any open records requests or responses to the subpoenas. And so because of that, there has been no dispute in that in the argument that has been presented to the court. And because of that, and the other individuals have fulfilled and satisfied the request for the production of documents, because that's what it was, a request for the production of documents and not a witness subpoena. What we're asking this court to do, at the bare minimum, when counsel comes before this honorable court, we are required to do certain things. And properly serving an individual is one of those things.
I understand, I agree with you, the email isn't sufficient yet. One day, I guess it will be. Why, though, in this particular context, was certified mail combined with an effort to deliver the subpoena into the hands of a responsible person who would then provide it to? And the reason I ask that is, certainly we don't want to live in a universe where the requirement is that individuals personally go and find individual ADAs or individual employees of the DA's office to put a subpoena in their hand when what they're being asked about is their work, and instead accommodate the delivery of a subpoena to a responsible person who will then place it in the hands of the individual who works at the DA's office, given particularly that the DA's office is a limited access location.
No one has ever reached out to me in order to serve these subpoenas. I serve as legal counsel for the district attorney. What efforts have been made to do that? Certified mail, we have no certified mail. We've not received anything. I literally accepted service on behalf of Curry Swift just the other day, the week before last. There's not an issue with service in our office. We get served you'd be surprised to know, we get served all the time. So there's not an issue with service within our office. I don't understand why plaintiff wishes to be treated differently in executing the basic and fundamental duties of any attorney. I shudder to think with this court, how this court would view rule or decide in a case in which the state brought forth a case and did not properly serve our witnesses. That is our duty, it's our obligation. Council mentioned that we are members of the
Then
bar,
do
we
it.
sure are. We need to act like it.
Do
Serve
it.
your witnesses. We do not have service. We do not have anyone who, to my knowledge, who has come to the office. I've not been contacted by the merchants at all in order to receive service. Our chief investigator has not. That has not happened.
What about what about though, Ms. Merchant's representation? And forgive me, I don't know if it's in the briefing that I read at 6 o'clock this morning, or if it's in email traffic that crossed with my staff. But what about, or even today in her argument, but what about her argument that I announced that this hearing was going to take place today? Everybody agreed that the hearing would take place today. I clarified that any subpoenas, any witnesses that were under subpoena continued to be under subpoena with the expectation that they would appear here today. And at no time until about 6 o'clock this morning did those witnesses say, oh, I was never served, oh, I'm not subject to that subpoena, other than the prior representation that had occurred overall, where most of these witnesses said, I've already complied with the subpoena because I've said I don't have any documents.
Judge, I think one, service, I was not involved in the previous hearing. I thought that was discussed, but it sounds like it was not, that improper service, because I saw an email stream with the plaintiff and Ms. Monroe talking about whether or not the individuals from our office needed to be reserved. And so.
Right, I'm aware of that, but I also know that during that hearing, I said, I understand that I'm not releasing these witnesses from the subpoenas that brought them here today, and that I strongly encourage the parties to engage in good faith efforts to agree. And instead, the defendant's counsel took the position that, no, you have to serve these individuals, but then does not acknowledge the email notice, the certified mail, and the delivery to the office of the Fulton County District Attorney's Office, which is, again, a limited access location. I cannot, even as a judge, walk into that office without pushing a buzzer and saying, please let me in, I'm here to see X. And so I suspect that no one, had the plaintiffs hired a process server, et cetera, would have been able to walk into the DA's office. I understand your representation is that they could have contacted you and secured service potentially, or acceptance of service or whatever on behalf of these individuals.
Or they could have come to the front desk. We're open for business 8:30 to 5 every single day, Monday through Friday. We are not cordoned off into some, secret cauldron of some sort.
Perhaps I misunderstood, but I thought the representation was that that's what they did, and they delivered the subpoenas to some front office worker.
That was not my understanding of that, and we do, and
I apologize if I misunderstood.
We have not received anyone to our front desk on behalf of this matter that I am aware of. The certified mail receipt that was attached to the motion that was filed by plaintiff's counsel, there was an indication that there was a mailroom or a front desk of some sort. I don't see an address on there. It does not say the district attorney's office. I don't know if it was delivered to the library. We have no way of knowing what efforts were actually undertaken in order to facilitate service, other than we don't have good service. We were not served. There was no indication that anybody came physically to the government center and to the district attorney's office in order to effectuate service.
Okay, so are you arguing that the representation made by the plaintiff that they served by certified mail and attached copies, that those are somehow not accurate or authentic?
I don't know what they are. I don't have anything that shows, proves, verifies that whatever counsel is representing made it to our office, actually made it to our office. I don't have that.
Okay.
And
But Ashley has a receipt.
So let's say that I disagree with your assertion that the testimony that might be sought from these witnesses is overly burdensome or harassing or not relevant. But I potentially share your concern about a lack of service, right?
Yes,
Given that there's no dispute that these witnesses are aware that they were being requested to appear, right? I mean, to my knowledge, there's no dispute that these individuals, given your appearance here today, also given at least one of the witnesses contacting my office saying, hey, can I please be excused until later in the day? Well, then why not simply acknowledge service and let's start over again in the morning and actually have the evidentiary hearing that was intended to be had and about which everybody had noticed since September the 5th.
I think there's a particular irony in asking that of the state, the non-moving party, when all counsel is not asked to do their jobs, right? We have a duty. We have requirements that we have things that we are required to do as attorneys. And one of those fundamental things are making sure that we have the people there under the proper mechanisms that are outlined in the law in order to be there. There's no requirement on behalf of myself as legal counsel, District Attorney Willis, to waive anything. We do not, that's not a requirement of us. And quite frankly, with all of the vitriol and negative assertions and just the gamesmanship that has been taking place in this case, why would we? We have complied with the
As you said a
subpoenas.
moment ago, almost everybody involved in this case is an attorney who has a professionalism and civility obligation to each other, to the profession, to the court. And again, I fully appreciate and understand that there's lots of gamesmanship, and I don't mean to apply because I know that I don't mean to imply that I don't see some of the gamesmanship coming from the plaintiff side. I understand your concerns, but again, that's why I keep trying to pull us back to, this is a public records request that was served in January, right? Or maybe even before then. Maybe we just got to the point of where's the answer in January. Maybe it was even before then. I don't remember exactly as I sit here, but it's September of 2024. And the plaintiff is taking the position that they still don't have documents they've requested, that the DA's office, whatever we're calling that entity, would have an obligation to produce that are public records, and there seems to be a lot of delay here, a lot of effort to keep pushing backwards instead of making an effort to simply get to the substantive issue, which is, do these documents exist? And if so, why were they not produced? Or do these documents not exist, which is why they were not produced, and therefore why the plaintiff has no claim, no further issue to pursue. And that's what is frustrating the court, and that's what I think y'all both sides should hear at this point, is that this is supposed to be fairly straightforward, and the gamesmanship about which you complain, I'm concerned is being engaged in by both sides. Because it's not that hard for these witnesses to come and say, I got the request, this is what I did, I gave them what we had. Here's what efforts I did when they said, this isn't enough, or I think you have more. These are the additional efforts I made to locate them. Those are legitimate inquiries. And the idea, when there's no dispute that the DA's office has, and when there's no dispute that the defendants and the non-party witnesses who are associated with one or other of the defendant entities have notice of the subpoenas, both from this court stating we were going to have a hearing where I expected witnesses to be called who had previously been identified, to a certified mailing notice, to a courtesy email. And then my question is, well then, okay, why not just acknowledge service, or let's adjourn the hearing, have the merchants walk across the street, give it to the front, give all the subpoenas to the front door window of the DA's office. And is that going to be sufficient? What I'm trying to figure out is, at what point do we get to the merits of this? Because one day we might get to the merits and I might say, you know what? I think the DA did everything they were supposed to do and tried to find all the documents, and they just don't have them, and that's okay, and they didn't do anything wrong. But we'll never get there because everybody keeps throwing up roadblocks to have a conversation about the actual merits of where are these documents and what efforts were made to locate them.
I understand the court's position. I do. I would say that what the court uses roadblocks are our assertions of the law. We look to the law and we look to see what remedies are available to us under the law, and we follow the law. And that's what we have done in filing these motions to quash. That's what we have done with regard to responding to an improperly served subpoena in order to not engage in gamesmanship, in order to give a member of the public what they have asked for. We have communicated with plaintiff's counsel. We have asked for clarification on a number of issues. We have received, yet again, subpoena after subpoena with requesting different information. And we have asserted our legal standings, our legal rights, and we have followed the law and what we are to do when we are presented with these issues.
And I don't fault you for asserting those issues at all. I mean, that's your job and you're right? Like you're entitled to say we were not properly served. If I agree with you that service did not properly occur.
She said she was received them though.
We'll deal with that. But respectfully, you didn't actually answer my question, which was when I said, well, why not just accept service now and let's get to the merits tomorrow? Instead of saying, okay, or no, because you just said, well, I think it's rich for them to, ask the court to go forward and force y'all to do something without observing the legal niceties when they haven't observed the legal niceties. And so
I think I respectfully disagree with your assertion or recharacterization of what was said. My position is we are here and we have been requested to produce certain things. All we're asking is that we have an even field, even requirements, that everybody who walks into this courtroom is treated the same. That when we come in, that we are prepared to proceed with our case. When counsel comes in, they're prepared to proceed with their case. And if we are not properly served, if the law is not followed with regard to whatever it is that is asked of us, the law is not followed, if we drop the ball, then there is that next step. Whatever it is that flows from that, we own that if we mess up.
right, but again, so that again begs the question, what happens if I adjourn this hearing today, say we're going to start again tomorrow, and the plaintiffs take their subpoenas and come over to the DA's office and physically hand them to the front office?
They were served.
And then we can all have this substantive hearing tomorrow where I have a completely free open day.
Your Honor, like I told you earlier, we get served all the time. This is not something that is unique to our office, unique to my role and my position within the office. We literally get served all the time. And so for that not to happen, not just once, but twice in the same proceeding, at what point do we say, hey, we all have a job, a duty, responsibilities?
Well, forgive me for interrupting, I'm sorry. Technically, even if those subpoenas from August 2nd and previously were not served properly, that objection was waived by the fact that the individuals responded to them, right? I mean, they filed some sort of answer saying they acknowledged service, whether they formally acknowledged service or not. Most of those witnesses did respond to the subpoena by saying, here's a custodian of documents saying, I don't have any documents. So I think we're focusing our efforts on the subpoenas that were served in advance of this hearing, correct?
Yes.
Okay.
But I bring up the August 2nd because it appears that the same methodology or tactics were used, even though that was at issue on the August 2nd. And so instead of there being the extra step to reach out to myself or to reach out to someone else within the office to say, hey, we're trying to make sure that this gets to you guys so that you, one, have it, that you know what the scope is, that we can have those discussions as the court has.
Which presumably they did by emailing it to you, but.
And let's talk about this email that we received on Friday, at the end of the day on Friday, to produce voluminous, I imagine, because we haven't even had a chance to take a look at these things.
How do you know?
Voluminous documents, mid-hearing. We're literally on a pause from a hearing that started on September 5th, and the game changes on us. We get served with, we get emails because it's not even proper service, new subpoena, new information is requested, it is voluminous, and then there is that added, an additional request that we have multiple members of this office come in to testify to something that we have already certified, to something that we have already provided, and we're not even given a sufficient opportunity to respond really to anything other than what we have provided by way of the business record certification.
I'm not sure what do you mean you weren't given an opportunity to respond to anything? That's what I'm not, I mean, aren't you doing that now?
No, I'm talking about with regard to what's been requested in the September 13th email subpoena.
So Ms. Merchant during her presentation did not go into detail about the nature of the documents being requested in the subpoenas, or, you know, the areas that the witnesses were being requested to testify about. What she did, the way she framed it, is that the still open public records requests that they made related to critical mention documents, a list of attorneys, forfeiture disclosure reports, and promotional materials or rebranding materials, that those are all open, and to her mind, I understand this, the defendants disagree with that, open records requests that have not been responded to or fully responded to. And so I think to the extent that the subpoenas contain be prepared to testify about X or produce documents regarding X, the idea is that it would be in service of those 4 items, not that it is a new public record request, I think, and maybe I'll hear from the plaintiff differently.
Okay.
Because what I hear you saying, and that's what I'm trying to understand, is are you arguing that this is a new public record request? Because I'm not sure, I mean, formal Open Records Act public request.
I'm arguing that this is a new subpoena. It is. This is a new subpoena. It has a new date. It has new information. It's requesting new and different information from the individuals that are named here. So that was.
People serve subpoenas in advance of hearings all the time with relatively short notice and say, be prepared to, you know, testify about these things. Because these issues aren't new, right? The subpoena is, but the issues aren't new.
But the request to produce these documents with 72 hours notice for all payments, requests, vendor applications, invoices, receipts, promotional material, brochures, flyers, mailers, that's just one enumeration, right?
That's old stuff though.
To research, to compile this information takes longer than that. There's a research period if this had been served properly, though it is not.
Oh my God.
But this is the overburdensome type of subpoenas that we continue to receive. And then to ask that these individuals take time out of their day away from serving the constituents of Fulton County, our victims, our individuals who have been affected by crime, in order to come in here and testify with regard to this. Your Honor, that is what makes this request, this subpoena of a sort that should be quashed as a matter of law, not just for the lack of service. But there are individuals, like I said previously, who have already been designated as the individuals who keep the records for the Fulton County District Attorney's Office, for our county, who know how these requests are received, processed, and the efforts made, as the court has stated. Even plaintiff's counsel herself indicated that Dexter Bond, Shalonda Miller, those individuals, she also included Jeff DeSantis, we disagree with that, but those are the individuals that will have the information that is relevant to the issue before this court. This should not be a fishing expedition where as much information as possible is trying to be obtained in order to help in the adjacent criminal case. That's not what this should be.
I agree, and as I have said multiple times, this case is, despite the subtext that all of y'all seem to be aware of and seem to keep deferring to, which I understand why it frustrates both sides. This is a Public Records Act, an Open Records Act action. It's an action to enforce a request for open records, and that's all it is. Now, what somebody might try to do with those records and why they're being asked for, that is not my concern, and I'm trying real hard to keep it out of this proceeding because it does not control the outcome and it should not concern the court. Now, I also fully intend, whenever a witness actually takes the stand, to keep the nature of any inquiry very narrow to the issue here and not let the plaintiffs engage in some sort of fishing expedition that doesn't have to do with the public records request that they asked for and that they are seeking to enforce. And so what I'm trying to, we've been, let's see, this hearing started at 9. Well, I guess we started late because we had to get a court work. So it started at 10 o'clock. We've been going roughly 2 hours and we still haven't gotten to the where we need to be, which is the subpoenas. I except to the extent that it's my intention to limit the scope of any inquiry of any of these witnesses to the very narrow issues that are presented. I disagree with you that these subpoenas are overly broad or unduly burdensome, given that everybody had an understanding of what was going to be at issue for some time. Now, I think your best argument is probably that they weren't properly served, but that is something that can be remedied through either one, the parties civilly and professionally agreeing to accept service,
yes,
which I can't compel anyone to do, or by securing service today in advance of the substantive hearing that this case should have already had by now. And so what I'm wondering, Ms. Alavi, is does that, if I tell you that I disagree with your position that the subpoenas are overly broad, but that I might agree with you about service issues, but that service issue can be resolved, then does that resolve your issue, understanding that you continue to disagree with that ruling? But it would ultimately be a ruling denying your motion to quash on the basis that it was overly broad, but perhaps granting your motion to quash on the basis that it wasn't properly, specifically served in the exact manner on the individual required by law. What are your thoughts?
I still think, and based on my motion, that the individuals listed for the non-parties, minus Mr. Bond Jr., they have no relevant information with regard to the issues that are before the court. They are not the custodian of records. They are not the individuals that are tasked with determining how those records are received, what we do with them, how we process them, the efforts that we made for diligent searches. They are not those individuals. They just happen to be individuals that may have sent an email or received an email. They are not the individuals that can speak to how open records are handled within the office. So
right, and I think I understood both Ms. Merchant's statement here this morning and also cross email that I saw, that Ms. Merchant, I think at the beginning of this hearing, identified 3 witnesses that she intended to call. One of whom is Mr. Bond, right, whose job it is to deal with open records.
Understood.
And that I think the discussion in the email communications that the parties copied the court on was that the only reason that they might need to get into the weeds of these other witnesses is if those 3 witnesses say, that document doesn't exist, when they have documentary evidence that an email was sent to somebody. And so part of the issue is, as I said earlier today, regarding the motion to quash the subpoena to Madam D.A. Willis, the motion for contempt, I should say, is premature because nobody's actually tried to call on Willis to testify in this case, in this proceeding. And I wonder if the same is true about those extraneous witnesses, because it may be that their testimony would be cumulative or immaterial to the proceedings, depending on how the testimony of those 3 witnesses that were initially identified by Ms. Merchant. And please forgive me, I know Mr. Bond was one of them. I don't remember the 2, maybe Mr. DeSantis and one other person.
Yeah, Ms. Miller.
Ms. Miller, thank you. So if we were to proceed with, at some point, with Mr. Bond, Mr. DeSantis and Ms. Miller, does that also address part of your concerns, Ms. Alabi, on behalf of your clients? Other than what I know you're going to perfect for your record, right? That those individuals have already signed documents saying we don't have anything else responsive. But does that satisfy at least part of your concerns about the nature of what's sought from them for this proceeding?
The nature of what's sought from them.
The nature and scope of the testimony and documents they've been asked to provide.
I would still object to Mr. DeSantis being called as a witness for the same argument that I've made a couple of times now. He is just, he does not have any relevant information concerning anything that has been before Your Honor. Mr. Bond Jr., quite frankly, is the one who has the information. He's the one who has the knowledge of how open records work within the office. He is the best witness. He is, quite frankly, the only witness that can really testify to the mechanisms that we have in place within the office in order to ensure that individuals that reach out to us and wish to receive open records receive them. And so I would still ask this court and move this court to quash a subpoena with regard to Mr. DeSantis. Mr. Bond testifying, I understand that, Your Honor, which is why I separated him from the pack at the onset of this argument, because he is differently situated and he does have information that would be helpful to Your Honor. But the other individuals that I have filed these motions on behalf of, they just don't. That's not part of their duties. It's not part of their job. It's not something that they've handled. They don't have that information. And so because of that and based on that and all the arguments before now, we would ask this honorable court to quash these subpoenas on Mr. Bond if counsel wishes to do that and get that testimony, but the other individuals are not the proper parties.
Okay, but to be clear, only after he's properly served with a subpoena, correct?
He would testify.
Okay.
Yeah.
Well, why didn't you just do it? Just do it.
Ms. Milrow?
Oh, no, another one? I don't know why the audio just went up 10x. Good gracious. Yeah, I'm unmuted for a second. That got loud all of a sudden.
Good morning. Yes, good morning.
You've got 4 minutes to still be good morning.
Okay, so I just don't want to belabor the court with just duplicative arguments.
Cumulative.
As it pertains to Madam DA, in her official capacity, we filed this motion to quash subsequent to plaintiff's motion for enforcement and contempt. And also to Ms. Bonnie Willis is not the person with superior knowledge who can speak to the things that I believe is before Your Honor.
Well, let me save the trouble. I agree with you, right? I mean, as I said, we are in the civil world. Most of y'all probably spend most of your time in the criminal world, but we're in the civil world. And in the civil world, there's a pretty well-established doctrine that says that we don't ask the CEO for documents until we've gone and asked the people whose job it is to have that information. And in this situation, by extension, the analogy here is that Madam DA is the CEO of this entity, and that there are people like the individuals whose job it is to provide these documents, to comply with these requests, and to talk about how they're maintained and how they go about responding. So save you the trouble there. I agree with you that there's a limited universe in which what particular knowledge Ms. Willis has about the nature of this request becomes relevant, but we're nowhere near that point yet.
Right, and so that's where the harassing part comes in. I do believe that these subpoenas were issued not for the information, not to seek information as it pertains to the underlying request, because the underlying open records requests were submitted to the Fulton County District Attorney's Office, not to the DA in her official capacity. The people who can speak to those things, to the
Well,
process.
in fairness, let's be precise. The requests were made through the portal that is maintained by Fulton County to the Fulton County District Attorney's Office.
That's correct, yes.
And the only reason it became an issue that Bonnie Willis, as the District Attorney of Fulton County, did not receive those requests is because the drop-down menu on the portal says Fulton County District Attorney's Office, and then Fulton County District Attorney's Office said, we can't be sued to enforce this request because we're not an entity. So that's how we got here. I don't think you gain anything by arguing, well, the district attorney was never served with this request, because the request was made in the manner that requests are supposed to be made, and that the portal was used to submit it to an appropriate entity that would have custody of these records. So I don't think that helps you, so maybe move on to a different position.
And just to clarify the reason why I brought that up, and testimony from Deputy Shalanda Miller and Dexter Bond can actually clear up that process and how it actually works as it pertains to Fulton County and the District Attorney's Office adjacent and by way of use of the portal. But as it pertains to DA Willis and the process of open records, from receipts of the request, how it's handled, down to the request itself, and how it's provided, she wouldn't have any particularized or special superior knowledge as to that. And so in the interest of judicial economy, we want to make sure that we have witnesses that would be competent to speak to those things, who would have personal knowledge that would speak to those things. And to have DA Bonnie Willis here to speak to those things would not be that.
Okay. But here's the thing. One, DA Willis is not here.
Correct.
Two, if I am presiding over a trial, right, the lawyers will typically subpoena 8, 9, 10 witnesses, right, if they think they can get through that many in a day. And I would never, ever hold a witness in contempt for failing to appear if nobody actually called them to the stand and then they weren't there in compliance with the subpoena. So that's number one, which is why the motion to hold Madam DA Willis in contempt, in my opinion, is premature. By extension, I think the motion to quash at this point is moot because nobody's actually called her to the stand. I've already said my belief based on the case law is that the plaintiffs are going to have to make some sort of showing as to why her testimony would be specifically relevant here. That doesn't necessarily relieve her from the obligation to potentially be subject to the subpoena, to be under subpoena. And I don't know that I can make an informed decision about the nature of any individual information that Ms. Willis may have, unless and until I hear from witnesses and the plaintiffs make some showing that the only way we'll ever answer this question is to hear from Madam DA Willis, which, as you can probably tell from my tone, is a pretty high bar. So I mean, I don't know if it's that, I mean, to my way of thinking, the motion to quash is not something that I'm going to entertain right now. I'm not going to relieve Madam DA Willis of the possibility of having to testify in terms of being under subpoena for this proceeding. But from an evidentiary and court management perspective, the court certainly reserves the right to say, no, I'm not letting you call that witness. That testimony would be cumulative. It would be immaterial. There's any number of reasons that I might never need to hear from Madam DA Willis on this particular issue. And so to me, all of those matters, as I started with this morning, I think are premature at this point. And so I'm happy to let you continue to make your legal argument for your record about why Madam DA should not be subject to the subpoena and that the subpoena should be quashed. But ultimately, I don't expect I'm going to give you a ruling on that unless and until the rubber hits the road and somebody actually tries to call her to testify here.
So we reached out to opposing counsel to inform them that she was not going to be present at this hearing. They've alluded to the fact of who would be testifying, but in terms of making DA Bonnie Willis subject to a subpoena that she hasn't been served with, that is the second part.
That's a different issue,
That's the
right?
sec-
Yeah.
that's the second
Yeah, that's
part of
different.
our motion. So
But- One question, so
Yes.
help me understand factually, is the subpoena that was delivered, we're gonna try and use a different word than served, because I understand that's a disputed issue right now. Is the subpoena that was delivered, for Madam DA, right? Does it fall into the same category that it was sent by certified mail, and an email was sent, but it was not delivered to the front office or in any personal way? So same exact process, is that right?
Yeah, so we have ongoingly checked with the DA's office to see if service was received by Madam or the office, front desk, as they alleged, in their pleadings, and that has not been the case. When I did a checking of the USPS tracking that they provided in their exhibits, I think it's Exhibit G, in their certified return receipt mail receipt, there, it just says Bonnie Willis, doesn't provide an address. And then when I look at the tracking, it says could be at front desk, mailroom, it has all these slashes of all the places that this certified mailing could be.
Well, but if certified mail is allowed, right? If certified mail is an acceptable way to serve a subpoena, and it was mailed to the address, right, that someone, I think I understood Ms. Merchant to say that it was return receipt requested. So someone signed the return receipt?
That is not my representation, that if someone signed the receipt. All I know is that in tracking the certified return receipt that the plaintiff alleged was sent, that it was confirmed that it could be delivered at the front desk, mail, which is all different places within Fulton County government. Front desk and the mailroom.
Being someone who's subject to getting my mail through
Okay,
the Fulton
it's all
County
different
processes.
places.
But I guess my question is there really a dispute that the subpoena was mailed to an address at which one could expect eventually
Yeah,
the DA
it's
to
still
receive?
something that she has to receive, and she was not in the jurisdiction to receive it.
Well, okay. If it was properly mailed to an address that's associated with the DA, where the DA expects to receive mail, if certified mail is sufficient, isn't that sufficient?
It's my understanding that it's not just a certified mailing. Once you've done the certified mailing, the person that it's certified mailed to would have to accept that certified mailing. You can't just
Oh my
leave it at the
gosh,
front
come
desk
on.
of someone's home, leave it at the front desk of someone's office. That person would have to have received personally that certified mailing. I would not be able to accept certified mailing on anybody from my office. That's just not how it works.
I think we need to talk about that a little more. I'm not sure that that is accurate. I think that if personal service is required, then personal service is required. If service by mail is allowed, then delivering it to the address where that person or entity
Correct.
is known to receive mail potentially would be complete service. Because otherwise, then really you're just engaging in an extended effort at personal service. If the argument is, once it gets certified mail delivered to, again, to my analogy of the CEO, the mailroom of the Ford Corporation, right? And the Ford Motor Company, and then it's got to go through 17 hands before it actually gets placed in the hands of the secretary of the CEO. That would defeat the purpose of allowing certified mail of a subpoena, would it not?
Well, the thing about a subpoena that it subjects the actual person to do something, the actual person. So absent some sort of express consent from that person who is named in that subpoena is not, that service of that subpoena is not enforceable. The court does provide some direction on this. In the Edenfield versus State case, it says that the lack of personal service invalidates the legal force and effect of a subpoena. So whether it be hand delivery or certified mail or overnight mailing, that person who is The receipt of those mail is the person who must receive that mailing unless it gives a third party consent to do so in order for it to be enforceable.
What?
Okay. That is my understanding of the interpretation of the statute. And
So by that logic, let's play it out to its natural conclusion. The DA was not in the state of Georgia on Friday, when I think someone has told me that Friday which was Friday the 13th, how fitting. That Friday the 13th was when these subpoenas were mailed to, or delivered in the mail to the district attorney's office, right? Is that correct?
That's correct.
Okay. And so by your logic, because Madam DA Willis was out of town on Friday, that subpoena could never be served on her because she wasn't here to receive service of a certified mail.
Good question.
Mailing to her office where she routinely receives mail.
Well, that's assuming that it was sent to her office. And that's correct. If she was not there to receive it in person and she did not provide express consent for it to be received on her behalf, that is not proper service.
Wait, hold on.
Okay.
I don't know about that.
And also too, I failed to mention in the first part of my argument, in terms of the substance of the subpoena. If the court can recall, there were 2 subpoenas served, actually three subpoenas that were issued by the plaintiffs. In that the first one was for a slew of production of electronic communication regarding critical mention. Then we have an alleged witness subpoena, which never took place. There was no witness subpoena. There was only a subpoena for the production of documents. And that was something that I raised at our last hearing.
Right.
And we had some discussions about whether or not we were going to incur additional costs as to effectuate service on those subpoenas. And I did raise the challenge that what plaintiff was alleging to be a witness subpoena was not in fact a witness subpoena. It was a subpoena for the production of documents. Now, with a witness subpoena, you're supposed to provide scope of testimony. In either cases where, in any of the subpoenas.
Not necessarily. So a 30B6 deposition notice or subpoena, you have to require, you have to provide a sort of a list of areas of inquiry so that the entity can make sure that it's got one or more people sufficiently prepared to testify on behalf of the entity. But here, the scope of the questions are limited by what's relevant in the context of the case. Now I understand it might have been accompanied by subpoena requests for documents, but the scope of the testimony that might be offered or expected to be offered by any individual under subpoena is, controlled by the scope of the case.
Okay, so to that point, which leads me to my next point, you have subpoenas for the request of documents that are not the same as the underlying open records requests. They do not mirror each other at all. Yes, there are key terms such as critical mention, forfeiture report.
That's the other lady said that,
but they're not the same exact requests or searchable items. So we're essentially, what plaintiff has done here is opened up a whole new compartment of information that originally she wasn't entitled to. And so now we have a slew of subpoenas to what started out as from 16 individuals to now 11. That's harassing. That is harassing within itself. When you know that there are designated individuals,
Can you
officials.
clarify that for me? Because
Yes.
Ms. Merchant represented when she first started arguing that there really still are only 6 people. And yet I've heard the number 12, I've heard the number 11. I don't know, but I would love to know the answer of, are there 6 or are there 11?
Okay, so from what I can recall, and I believe this is all part of the court's record, but there was a notice of filing of subpoenas. And I
Yes.
do believe that there were a list of somewhere around 16. Don't
Yes,
quote
and
me, I would have to just double check
That is part of the record. It is, for my benefit, I'm going to say this. There was a notice of filing subpoenas filed on August the 30th. It's docket number 48 in my record. So yes, and there were a number of individuals, all of whom I don't know if it was that they were provided to plaintiffs and they filed them, or if defendants filed them, but it looks like Bond, Willis, DeSantis, Bailey, Dilligard, Armstrong, Kerrigan, Murray, that is the list, but they all filed some sort of response and objection to the subpoenas that were served on them.
Yes, Your Honor, I was the one who filed those objections.
Thank you, okay.
And also those responses, hoping that it would resolve it. However, it became a moving target where, oh no, we're not talking about critical mention documents anymore. We're talking about all these other things, rebranding, promotional materials, list of attorneys in their hiring dates. If you compare, and this, once we get to the hearing, Your Honor, we'll be able to view the open records request individually, precisely as to what was requested and how they were responded to. And also, we can also compare them to the actual subpoenas for production of documents to see what was requested of these individuals, why these individuals were even selected to request these things. I mean, I have a subpoena from Ms. English, and she's someone I didn't even file a motion to quash for, because at this point, it was just completely out of hand. But I said, you know what, her testimony or getting her here, I do believe is irrelevant as it pertains to the subpoena, all because she missed one email. To have her be subject to a subpoena I've never heard of that type of practice before. But this is how the plaintiffs have decided to practice in this matter, by subjecting all these people to subpoenas who they know that do not have access to that information. Ms. English, who is a member of External Affairs, she does not work for the DA's office. She wouldn't have any information regarding the DA's bank accounts. I have a subpoena in front of me here where she's asking from checking accounts from critical mention, contracts, NDAs from the DA's office. Why would Ms. English have that information? A member from External Affairs. This is why I say it's harassing. She's asking members.
I don't know the answer, but I think my review of the initial requests were that these individuals are people who would have handled or been involved in branding and media relations such that they might have knowledge of documents that existed that have not been produced by the DA's office. Even though, again, I agree with you, probably not their job to be in charge of those documents. But if they know that they exist because they had them at some point because they were sent to them, or maybe if it's External Affairs, if it's your job to send that out into the world, right? But now,
but what about what about forfeiting documents? What about attorneys hiring dates for hiring? Like, why would someone from External Affairs have that information?
So
it seems like nobody has it, but everybody does.
I don't disagree with you, but that's not a reason to say that they're not subject to subpoena.
No, I'm saying that because they're not. I'm sorry.
That's a reason to say the scope of what they're asking this witness is excessive. I want you to say they can only ask them X, Y, and Z. And what I've said, I think a couple of times relative to various witnesses, and certainly Madam DA Willis, is that you kind of have to trust me that I know what's relevant in this case and that I'm not going to let people go on a fishing expedition. That I'm just going to say, ask them about the open records. And if that witness, if they get asked a question about bank records and you stand up and object and say, this witness works for External Affairs, she would have no knowledge, and I'm going to sustain your objection. I mean, so much of this is subjective about how this evidence is going to come in and about what is relevant to the scope of this hearing, this proceeding, which is, are the records public records? Were they maintained? Were they requested?
That's
what
it.
efforts were made to provide that?
That's it.
I completely understand the court's position. I guess because we're so closely tied to this case, we know the ins and outs of it. And we know that if your sole purpose is to obtain information, there's a comportment, there's a posture in which you do so. And the plaintiff has not taken that posture. In fact, they're using this as a platform to create a show. This is not about gaining information. This is purely about harassment. And I'm not shy to express that to the court. And I understand how the court may differ on this point.
It's not that I differ. It's that all of you are talking about the fishing expeditions and the harassment that I can, and the gamesmanship that I can see on both sides. But what I am telling you is the law does not support that as a basis, right? The questions that a court is to consider on an open records enforcement action is, are the records public? Were they requested? Were they produced? And if they were not produced, why were they not produced? Why the person wants them is not a relevant consideration, even if I think that the only reason the person wants them is for harassing reasons. That's not a relevant consideration. And so I understand your frustration, but again, I think we are wasting each other's time by continuing to talk about the gamesmanship and the harassing nature of this exercise, because I kind of agree with all of you that this is both frustrating and gamesmanship on all sides, and probably going to be used for some harassment or whatever on the back end. But my concern legally within the structure of an Open Records Act request is, are the records public? Which doesn't seem to be in dispute. These are public records that would be subject to the Open Records Act. Were they requested? Yeah. Also doesn't seem to be in dispute. And were they produced? That is in dispute. And if they were not produced, why were they not produced? Also in dispute.
That's it.
And now if we narrow ourselves to those issues, then it just feels like we can move this case forward to actually consider the substance rather than.
Or just give the records.
This.
Or just
which
give the
seems
records.
To be, they're trying to harass me, so I'm not going to agree with anything they ask me, and vice versa. They're not agreeing, they're putting up roadblocks, so I'm not going to agree to anything, right? And that is not the way that we all want to conduct ourselves.
I understand, Your Honor. Just to
Just let it go.
In terms of, Your Honor, we're not trying to belabor this point any further. We do understand that we have a hearing to get to, and we have individuals here who can testify to the merits of this case in a way that is efficient, in a way that is substantive, and in a way that can bring this case to a speedy close without all the extras. And those two individuals are Dexter Bond and Shalana Miller. We stipulate to the point that that documents weren't provided initially, and as what the hearing will display, it will get into the request, it will get into receive the request, it will get into how the request was processed and how the request was responded to. But I would just ask the court, in the interest of judicial economy, and to make sure that we are actually getting information that will be helpful to the court to consider, so the court can have an easier job in hearing the case on its actual merits versus the narrative that the plaintiff wants to produce to the court.
Okay, so thank you, Ms. Monroe. A couple of questions I have for you before you have a seat, and then we will move on. Essentially, same question to, and it may be to Ms. Alavi, I'm not sure, but I think I understood that for the limited purpose of moving this forward, that Mr. Bond would be willing to waive that insistence on formal service and be available to testify today. Did I understand that correctly?
Yes, Your Honor. I would ask this court to reserve ruling on my motions until such time that Mr. Bond does testify, and see if that settles your mind with regard to the other individuals, non-party.
And that was my intention. My next question is, what about Ms. Miller?
Yes, Your Honor. She's
willing to.
Absolutely. We did file a motion to quash on her behalf.
Okay, just want to make sure. Okay, thank you.
Thank you.
Ms. Merchant.
Yes, very brief.
Since it was your burden, I'm going to give you a chance to reply, but please be brief.
I promise.
We've been beating this horse for 2.5 hours.
I understand.
This horse is
First, Dexter Bond was personally served of the city, so didn't know that was a big dispute. Should have brought that up earlier. We have his return. So he was served. So I'm not really sure why they're arguing he's not served. We have the return.
It doesn't matter because his counsel on his behalf has said he will waive service to the extent it was defective in any manner and testify today.
And Judge, I always have been calling Dexter Bonds first and calling Shalana Miller second, and then calling Jeff DeSantis, and I can enunciate exactly why I believe Mr. DeSantis, and if we get to it, Ms. Willis, would be relevant. The critical mention piece is there was a private password and a private app. Dexter Bonds was not involved in that at all. Never had it, You can tell from the emails. If you look through the emails, he did not participate in that. He signed the check, but he did not participate in that. And you can see that through some of the email traffic where he's talking to Jeff and he's like, I don't even know what this is. They're asking about critical mention. What are they talking about? Jeff DeSantis is the one that had that account. He can answer the questions about the maintenance of the reports. Dexter Bond, I don't believe he can. Maybe he can, but I don't believe he had personal knowledge because the only two DA employees that actually had access to critical mention are Fonnie Willis and Jeff DeSantis, which is why they were under subpoena. So I think that he is relevant for that reason. I think that will become abundantly clear when Mr. Bond testifies. Bond did not have access to those reports, those types of things. That was not part of his job. So Mr. DeSantis would have that. The other thing is, I just wanted to clarify for the court, the same thing with the reports and the analytics for critical mention. The only people on those reports and on those emails are Fonnie Willis, Jeff DeSantis, and then a former employee who does not have access anymore, Robin Yerty. And so those are the only two. There's an email specifically, it's at Merchant 0095, June 4th email, where Ms. Willis is emailing Mr. DeSantis and Ms. Bryant, talking about she's waiting on things from critical mention for a book. And they're the only people on that. So I can't ask Mr. Bonds about what stuff they're waiting on from critical mention, what documents exist. Mr. DeSantis is the only one, and Ms. Willis, that I can ask about that. As far as the motion to enforce the subpoena, I understand the court's not happy that we filed that preemptively. The reason that we did, just to clarify, is because recently there was another subpoena issue, and the court's order in that case said to preserve the right to call that witness, you had to move to enforce the subpoena. So out of an abundance of caution, as soon as Ms. Monroe said, Ms. Willis is not showing up, we moved to enforce the subpoena to preserve that right. Once they let us know that. As far as, the only other thing that seems to be a theme is that this is oppressive and harassment. These are all the same things we've been asking for since January. They're not oppressive and harassing. I just keep hearing that term without any explanation as to how they are oppressive and harassing. I'm asking for documents that are public records, taxpayer-funded records, and we've made concessions. We've been asked to make 2 concessions on witnesses. We were asked to release Miss English. I agreed. I said, I don't think I'm going to need her. Can she be on call? And we don't care if she comes by Zoom because I don't think I'm going to need her. They asked me that. They asked if Mr. Kerrigan could have a substitute because he's at a conference. That's fine. I told them exactly what the testimony would be that I would be questioning so they could prep that witness. We've not been unreasonable. I emailed every single witness that we subpoenaed and said, talk to me. Most of them emailed, if they did email back, just telling me, no, thank you. But if there were any questions, we've tried to be accommodating. So the only request we had, we even were willing to accommodate Ms. Willis to testify by Zoom once we found out she was out of town, and we were told no thank you to that as well. So we're not trying to harass people. We're just trying to find out where these documents are and why we're not being given them still to this day. So I just hope we can move forward, Judge.
Okay.
Oh, and Judge, we've got all the subpoenas if we need to reserve them. Because the lobby said, I have copies of them. She's emailed. She can have my originals. I can hand them to her right now. She said she'd take notice of all of them. So we can hand her all of those. Previously, Ms. Monroe had said she and I would just state also for the record, when I did reach out to witnesses, I was told in no uncertain terms that Ms. Monroe represented them. So we didn't serve as a Ollie because we didn't know. This is the first we heard when she filed this. So I had no idea. Like Ms. Monroe was the one that was representing them. We served Ms. Monroe with all of them. We copied her and everything. We haven't talked to any of these witnesses without Ms. Monroe being copied. But I'm happy to hand those back over. Additional copies of these witness subpoenas. Happy to.
Okay. I think I've made it pretty clear what my thoughts were in reviewing the filings by the parties and trying to get to what are the merits of a very narrow issue, which is, are these public records resolved? Were they requested? It appears they were, but maybe if there was some confusion about the nature, I can hear about that. And if they were requested, were they produced? If not, why? It sounds as if we have agreed that we can try to move forward with Ms. Miller and Mr. Bond regarding the merits of did they receive requests? How did they get processed? What did they do to comply with the requests? And what did they do to produce? And then as Ms. Alabi requested, I will reserve ruling on the motions to quash the subpoenas of the other witnesses unless and until, and that includes the subpoena to Madam DA Willis and the motion for contempt for her to not appear, because I think those motions are premature unless and until those witnesses are called to testify and I say, yes, I would like to hear from them. Because it's possible that Ms. Merchant might say, I want to call insert name of other witness. And I say, why do you want to call them? And I then am allowed to say, I don't really think I need to hear from them because I think it would be immaterial or cumulative testimony I've already heard. And so unless and until she calls a witness that may or may not be under subpoena formally, and I say, yes, I want them to take the stand, I don't think I need to rule on either the sufficiency of the subpoena in terms of its service or the scope of what was requested in the subpoena, unless until that issue is presented to me. So I will accept your invitation, Ms. Alabi, to preserve or to reserve ruling on those motions to quash until such time as I have to, until I think they're right. So it is 12:30. We've been going since this morning. What I'd like to do is take about a 45-minute break so we can all refresh ourselves and clear our minds and maybe get some food so we don't fall over from hunger, and then get started at 1:15 with actual substantive testimony and hearing. Okay?
Thank you.
Anything else I need to address before we adjourn for 45 minutes?
No, Your Honor. Thank you, Your Honor.
Thank you.
Oh my goodness. All right, let's see where we are. All right, I think they are done over in YSL land. They still going. Let's jump over them real quick. Yo, thank y'all for rocking with us today. This has been amazing. I didn't think today was going to be this enjoyable, but we are here nonetheless. All right, so real quick. Oh, then you play. You got
349 Cleveland Avenue, southeast or southwest? I'm not sure if it's southeast or southwest, ma'am. It's just crystals on Cleveland Avenue. The police been right across the street. All right, sir, we're going to get the officer out. It's an emergency call. Like I said, they're coming to you, okay? All right. Bye-bye.
Okay, so thank y'all so much for this.
Thank
This
you,
has
Ms.
been a lot
Latner.
of fun.
Your Honor, no further questions by the state.
Thank you. Defense attorneys have questions for this witness? Go ahead.
Here we go. Let's see what they talk about. Atkins got the squeaky chair, by the way. What's up, House? What's going on? Matthews.
Good afternoon,
Good afternoon.
Ms. Latners. Ms. Latners, I want to ask you some questions concerning various matters here this afternoon. I'd like to begin, Ms. Latners, with an October 1st, 2020. That's going to be a CAD report that's been put into evidence as two Papa.
This is a 911 operator. She is a 911 operator.
Do you have that one before you, October 1, 2020?
Yes.
Okay. Now, you testified numerous of times in this case this year, correct?
Correct.
And we have heard today numerous 911 calls, right?
Yes.
We've heard numerous 911 calls throughout this trial, correct?
Yes.
And the callers that are calling in, they are giving information to the 911 dispatcher, right?
911 operator.
The 911 operator, correct?
Correct.
They're giving a story. They're telling a certain story of what they say happened, right?
Correct,
Sometimes it's true, correct?
correct,
Sometimes it's not true, right?
correct.
Okay. Now, I want to direct you to October 1st, 2020. That call began at 22:50 hours. That would have been around 10:50 in the evening, correct?
Correct,
Nighttime in the state of Georgia,
In the
right?
right time.
correct.
Okay. Now, I want to direct you to page 2 of that CAD report. Specifically at 10/120 at 10:51, it says 44V. You've testified that that would be a robbery or carjacking or something of that nature. Is that correct?
44 is a vehicle robbery, right?
A vehicle robbery of a gold Buick LaCrosse, according to the report, right?
Correct,
The caller indicated that his name was Gary, correct?
correct,
This caller says that the person involved was a dark-skinned, tall black male. Is that right? According to the CAD report
yes,
and according to the information that was given to the 911 operator, right?
correct,
Okay. Now, during the course of this CAD report and the officers being out there, there was an officer who responded, right?
correct,
And according to the report, the officer that responded was a officer Revillis. Is that right?
correct,
Okay. This CAD report documents a time frame from 22:50, 10:50 hours to 23:26 when it says it's clear, correct?
correct,
Little under an hour, right?
correct,
So that tells us that the officer is with the caller, Gary, during this period of time. Clear,
Objection,
correct?
objection, Your Honor, calls for speculation.
Sustained.
Now, Ms. Latners, let's talk about the entry where it has on page 2, 10/120, 11/12. It says raised robbery, correct?
yes,
That means that Officer Revillis is raising up or calling a robbery detective. Is that right?
that's right,
Okay. Now, when that's happening, there's an entry in the CAD report that then tells us on 10/120 at 11:26, look at the jury and tell them what it says with regard to that particular entry.
unit advised, caller not being cooperative at 11:26 p.m. hours.
Ms. Latners, tell this jury, how long have you been doing this work?
34 years.
You are set to retire this year, correct?
Again, yes.
Until we let you go.
No, I'm retiring.
Okay, that's right. Now, tell this jury, you've seen this entry on numerous CAD reports, is that right?
Correct,
Tell this jury, based upon your experience, your 34 plus years of doing this kind of work, coming into a courtroom and talking to a jury and giving us information, caller not cooperating. Tell this jury what that means.
Objection, Your Honor, relevance and compound.
Sustained.
I'll break it up. Ms. Latners, can you tell this jury, based upon your experience as a 34-year employee with the City of Atlanta Police Department as a custodian of 911 calls and CAD reports, when this particular entry is in there, What does it mean?
It means 911 operator only can receive what they get from the caller. Once the officer get out on the scene, he investigates and he advised his dispatcher to change the call to a different incident.
Okay.
And she does what he asked him to do.
Okay. Now, the responding officer, he raises up robbery, right?
Correct.
So he's talking to a robbery detective, correct?
Correct.
All right. Now, when he's talking to a robbery detective, the Officer Aviles then goes to a code of a 44V. Tell the jury one more time what 44V means.
44V is vehicle carjack.
Now, we have gone then on this report within that hour from a vehicle robbery. Tell this jury what 39 means.
Objection, Your Honor. Asked and answered.
Overruled. I mean, it may have been, but I'm gonna permit it.
Tell this jury what 39 means.
Information for the officer. That means that he gathered the information that he needed and he changed it to a 39.
So the officer who's on scene, correct?
Correct.
On the scene with Gary, correct?
Correct.
On the scene getting information, correct?
Correct.
It starts out as a robbery of a vehicle, right?
Correct.
On the scene at that location, the officer and the raised robbery detective, they change it from an armed robbery to an information. Is that correct?
Correct.
And information is not a crime, correct?
Correct.
Now, we heard a call, a 911 call associated with the same 10-1-20 incident, correct?
Correct.
We heard it for the various number of minutes that it took place. We did not hear at any time the name Delmisha Coppage, did we?
No.
We did not hear that she was robbed, did we?
No.
We did not hear that her vehicle was stolen or carjacked or robbed, did we?
No.
Did we hear any description of any vehicle other than a 2016 Buick LaCrosse?
No.
Did we hear any description in the 911 call other than strike that? Ms. Latners, let's move to a different report. Ms. Latners, let's move to April 26, 2019. That's going to be one Oscar. You tell me when you have it.
Okay.
You have it, Ms. Latners?
Yes.
Okay. You didn't prepare the report, right?
Yes.
You didn't make any of the entries, correct?
Correct.
The report started out as a possible person shot, correct?
Correct.
It was downgraded to no one being shot, correct?
Correct.
Now, there was no description of a perpetrator on the report, correct?
Correct.
It stated that there was no information or a tag number given to this vehicle that is alleged to have been involved, correct?
Correct.
And this entire time frame was from 12:39 a.m. to 5:06 a.m., correct?
Yes.
Now, I want to direct your attention to page 3 on the CAD narrative. I wanted you to go down to April 26, 2019, 12:49 a.m., 7:07:08. You see that entry, Ms. Latners?
It says gate code 478.
Gate code 478.
Correct.
Can you tell this jury, gate code 478? Tell this jury what that means.
It means the apartment had a gate around it with a code.
So that tells us that in order to get into this particular garage, it requires a gate code to enter, correct?
Objection, Your Honor. Calls for speculation.
Sustained.
Based on your training and experience and doing these particular CAD reports and testifying about them, have you seen gate codes in other CAD reports?
Objection, relevance.
Overruled.
Ms. Latners, you can
You
answer
actually
the
have I
question.
seen it in other CADs?
Yes, have you seen gate codes in other CAD reports?
Well, it all depends on where you live and if the apartment have gates and have a code for it.
Okay. The 478, does that,
Grace and peace.
is that an internal number that's used for CAD reports? Or is that the code to this particular gate in this garage?
That's the code for this garage.
Okay. So the person, so if you punch 478, you will gain access to this particular, according to this CAD report.
Objection, Your Honor. Calls for speculation.
Sustained.
Did you see gate code in the CAD report that we talked about for the 10/1/2020 CAD report?
No.
And this was are you familiar with 741 Morosco Drive, Ms. Latners?
No.
Okay. Your Honor, thank you.
All right. Do any other defense counsel have questions for this witness? Nope. All right. Any redirect?
Very brief,
All right.
Your Honor. Ms. Landers, just a few seconds ago, we were talking a lot about this gate code on 1 Oscar. Is that at 12:49 a.m.?
Yes.
What is the line 3 minutes after that gate code line?
Person left in a black Ford Mustang.
Does it say perp or person?
Perp left in a black Ford Mustang.
Now, Ms. Latner's going back to
What's the purpose of this?
was there more than one person identified in a robbery? In the robbery?
This car right here?
Yes, yes, ma'am.
I don't see any.
Does the caller indicate, is there anywhere in this CAD report that has any information about how someone entered a parking garage or location on that CAD report?
No.
What are you trying to say?
Is there any information at all about, is there anything else other than just that line of the gate code 478?
That's it.
Is there any information about whether you need a gate code to walk in?
Well, no, if there's any information overruled.
Is there any information about whether that gate is broken?
No,
Is there anything in this CAD report that indicates whether the robber was visiting someone in the complex?
What?
no,
And Ms. Latner's going back to Papa. When a call comes in on cross-examination, you were asked about some information's true, some information's false. Do you recall that?
yes,
Is there any way to know when someone, before officers arrive, what's true or not true about what a 911 caller is stating?
no,
And from the 911 dispatcher's perspective, do you try to determine if what is being said is true or not true before you respond?
it's not their job.
And is the initial officer's perspective of an on-scene victim the end of any further investigation?
You can answer that if you know that from your personal knowledge.
Repeat the question.
If an officer, do you remember on cross, you have discussed about the 44V being changed to 39 info for officers?
Correct.
In Atlanta Police Department protocol or procedure, if you know it, does that stop a case? Can no for
Overruled. Based on your own knowledge.
Can you complete the question, please?
yes. Can
She ready to
further
retire.
investigation by the Atlanta Police Department be done on a case where the initial officer changes the call to 39 info for officers?
Overruled.
Yes.
Goodness gracious. Okay, I don't know where he's trying to go with that. This guy's name is Atkins. This is ADA Atkins. I forgot his first name. I don't know where he's going.
Ms. Ladders, when the call is changed to a 39 for investigation, does that mean that the 39 for information?
Wow.
I misspoke, Your Honor. My apologies. When a call is changed to 39 information for officers, I misspoke and said investigation, which I believe is 12. But all that aside, Your Honor, and Ms. Latner, more importantly, does the investigation stop? Does that mean the investigation is over?
Objection, Your Honor, has been asked and answered.
Sustained.
No further questions, Your Honor.
All right, any recalls? All right, thank you for your time and you are excused.
Enjoy your retirement.
All right, it is time for us to break for our lunch. So we'll do that and we'll plan to be back here. It's almost 1 already. So let's say 2:15.
Yeah.
See you then.
All right. Woo.
All right.
Let's see what they talk about. Let's see what they talk about. All right, we got a couple things to talk about at lunch. I'm supposed to let y'all go to lunch. Girl, get to. That does not look confusing. Oh, wait. That's Shibe is here.
Sarah, you're back in a little over an hour and 15. Yes.
Shibe is here. Uh-oh.
Shad is here.
Is it, can we take it up after? I'm trying to get somewhere.
Okay.
All right,
Darn it.
see you at 2:15.
Oh, I wanted to hear what he's going to say. Darn it. All right. I have no idea what that was about. Man, I hope nothing happened to Zachary because that's going to come back and bite them in the posterior. Wow. Okay. Today's been wild. I did not have that on my bingo board. That Ashley Merchant, Fulton County DA thing. Wow. That was really good. And hey, I think most of this has been a big giant nothing burger in the YSL trial. I think they're calling witnesses that they're filler witnesses. This is just my theory. They had filler witnesses in the system that, hey, if this person doesn't come up, or if this doesn't pop off, then we got this person to come in and kind of give us a little cushion so we can keep moving, keep it moving. I think most of these people that have been calling have been filler witnesses. That's just me. Um, so we'll see. We'll see emphatically if that's the case. I can't say that I'm correct. Lord knows I can't say I'm correct, but I can say that that's what I believe is the case based upon information and belief. But before we get in here, because I want to talk about this video and I want to give you a little explanation real quick. First of all, thank you everybody for the very kind, very gracious super chats. Let's see real quick. Rebecca, bless you. Thanks so much. She said, good morning. She tweeted something to Doug Weinstein, what y'all said about the girl being on social media, and he liked it just now. I got the clip. It is pretty wild. So I'm going to actually make a whole video of that. So don't worry, you'll see before the day's out. Fonnie versus Ashley trial fund. Thank you so much, Donna, because I'm gonna probably need it. Thank you so much, Mr. You Don't Know Trek. He says, that's the honorable sir. It's not incumbent on the state for the subpoena service. Plaintiff has to do that. And that's fair. That's fair. I just think that, as you heard it in the Judge Cross said, there's a lot of gamesmanship. I think there's a lot of gamesmanship going on. Like, oh, you didn't send it to the right office. I guess we can't do that. There's just a lot of that. Just go ahead and give the information and be done with it. It's not like they're asking for information that is not public information. That's the problem. That's why I think while we're here is they're treating it like it's their own personal information. Going to surrender the information because it's the people's information. It's not mine, it's not yours, it's the people's. Give them the people's information. But then he goes on, continues, this is an illegal fishing expedition, sir. Okay. I don't know how asking for information pertaining to the media matters information or the NDAs or, who's allowed to still work here? Like what happens? I don't know how that's a fishing expedition, but please, I kept asking the question, would this level of roadblocking happen if the news had asked for it? And would this level of roadblocking happen if there wasn't something to hide? Those are my two questions just to consider and just to think about. But I appreciate the supers nonetheless. And then the last one here is Demetra says, best live chat on the planet. And that's y'all. Thank you all so much for being, again, the best live chat on the planet. I appreciate y'all. Now, I want to talk about something. We don't talk about this very much. And this is going to be our little lunchtime discussion. I want to talk very quickly about the law of unintended consequences. And as a former teacher, most of y'all know, I'm a former classroom teacher. I enjoyed teaching for 15 years. It was a lot of fun. And one of the things you notice with education is that education is an ongoing, whoa, stop. Don't give away my goods yet. Okay. Education is an experiment. I say this all the time. They're constantly always trying something out. The way our parents were taught is not the way that our grandparents were taught. And good gracious alive, the way our kids today are taught is not the way their great grandparents were taught. So there's a lot of experimentation. There's a lot of just moving things around. There's a lot of times when they really don't know what they're doing. They're just trying something out. Now, one of the problems though is that you'll try something out and there will be a consequence that maybe you didn't anticipate or maybe you didn't think about. And I don't really truly care about Kamala Harris's life as really anything that she did in California. However, this one right here, I'm going to talk about. Most of y'all know I don't say much about her California history because I don't think it's relevant. I think there's enough meat on the bone for the last 4 years. You don't even have to go west of the Mason-Dixie. I mean, west of the Mississippi. You can talk enough about what she's done in DC and you can be there for a long time. However, I am going to jump over there. We're going to run back real quick to California and we're going to look at the law of unintended consequences. Kamala Harris instituted an idea that if a student was tardy from school and enough, the parent of that child could be arrested. Now, I'm gonna make some real blanket generalizations. I'm gonna go on a limb and say a kid, and as a parent and as a former classroom teacher, I can say this is pretty anecdotal. A kid who has a good home environment, a mom and dad, a kid who has all of their basic material needs met and a little bit of the opulence, a kid who has all of their supplies, that comes to school with a full belly, goes to bed every night in a clean bed. Generally speaking, their attendance at school is relatively high. Sure, maybe mom and dad will take them out of school early to go on a ski trip to Vail, but for the most part, they come to school all the time. What tends to happen, however, are kids that don't have good home environments, that don't have a steady living environment. They go to bed hungry. They go to bed in dirty clothes. They wake up in dirty clothes. Go to school in the same clothes they had on yesterday. Those kids tend to skew toward having bad attendance. Okay, and we didn't even talk about healthcare. So kids that generally mom and dad are taking care of, the kids usually are taken care of with their health as it relates to getting checkups and so on and so forth. Kids that don't tend to not. Now, I didn't use any ethnicities. I didn't bring up any race issues, but I think you probably could see in my analogy here, it's very possible that certain people groups might skew toward being maybe they're maybe not as affluent in a certain area, a certain metro. They might not be as affluent, and that might not be a rash generalization. But on the same note, there's other people groups that, yeah, they might be a little bit more affluent, and you can make that generalization. So what we're gonna do is we're gonna watch this video. You may have already seen it. It's an interview with a woman who actually got sent to jail because her daughter has sickle cell. And I thought that was really interesting because we're going to be talking about sickle cell as it relates to the YSL trial. And I've had a student who has sickle cell. He actually had pretty good attendance, by the way, but his family did not come from opulence. He was a single parent. She had 3 kids, and I had the second grader, and he had sickle cell. And he had pretty good attendance as far as I remember. But I want to bring this in just to show you the law of unintended consequences. Because if a student doesn't have good support system at home and they're absent from school, well, you realize what's going to end up happening if you arrest the only parent. Just think about that. And let's bring it in and let's go.
I intend to fight for Black Lives Matters. I intend to fight.
If Black Lives matter to her, why didn't I matter?
I don't agree what Kamala Harris did to my mom. And I don't agree with what she's done to other parents as well.
My message to all Americans, especially Black Americans, do not trust Kamala Harris.
I'm so proud of you right now because you walked all the way down here and I wasn't expecting you to walk.
My daughter, Shayla, suffers from sickle cell anemia, a chronic, painful genetic disease.
As a prosecutor and law enforcement, I have a huge stick.
It's a very sharp stabbing pain and it hurts a whole lot. Like from my chest all the way down, it hurts, including my side.
So I decided I was going to start prosecuting parents for truancy.
When Kamala Harris was the California Attorney General, she had me arrested and prosecuted because my handicapped daughter was sick in the hospital and had missed some days of school.
I spent a majority of my time here at the hospital.
Kamala's horrible policies hurt mothers like me and the Black community. My name is Sheree Peoples, and this is my story. I am a single mother. I've worked as a certified nursing assistant and a caregiver. My daughter Shayla was born in 2002. When she was born, she was diagnosed with sickle cell anemia. It affects all major organs in the body and also causes extreme pain. Her whole life, she has been on medications like morphine and Dilaudid to help her control the pain. In addition, she had to undergo blood transfusions every 3 weeks. My lifestyle became taking care of her almost full time. It is pretty typical for kids with Shayla disability to miss a lot of school.
I just got out of school. I've done 3 full days this week. Oh, I'm so tired.
And for years, the teachers were aware of her condition and her absences were all excused. California schools get their state and federal funding based off of average daily attendance. Schools are paid about $30 per student per day.
In San Francisco, we threatened the parents of truants with prosecution.
I first heard of Kamala Harris when she got elected California Attorney General.
We are putting parents on notice. We are going to make sure that you face the full force and consequences of the law.
She wrote a report saying truancy was costing California schools $1.4 billion a year in funding.
Because of truancy, California public schools lose $1.4 billion a year in funding. I want money.
Kamala then wrote a law making it criminal for parents if their kids miss school time. Kamala even wrote a book called Smart on Crime.
You can read an excerpt from the book that she just plugged shamelessly. It's called Smart on Crime.
Talking about arresting parents for truancy.
I sent a letter on my letterhead out to every parent in the public school system.
In 2012, like all California parents, I received a threatening letter from Kamala Harris saying we'll go to jail for a year if our kids even miss 10% of school days. It was like a crazy intimidation tactic.
I'm going to start prosecuting parents for truancy.
I thought, wow, this woman doesn't have any empathy. Is it because she's not a mother? I also thought, how could she not understand it would disproportionately affect people of color, single Black mothers? But honestly, I didn't imagine it could affect me. Her teachers had her medical records from the Children's Hospital. I even had a 504 plan, which was an agreement between the school district and the parents to provide care for students with disabilities. It was April 18th, 2013, in the morning. I'm in my pajamas. I had just fed my daughter, gave her medications, sent her off to school. Little did I know, there was a warrant out for my arrest. All of a sudden, the police is outside my house and they started banging on the door. I opened up my door and 2 officers entered my home. They told me I was under arrest for my child missing school. They said I was going to jail. I was shocked. I said, but my baby is sick. The school knows that. And they said, go talk to Kamala Harris. Place your hands behind your back.
My mom did nothing wrong. We did everything we were supposed to. I was always bringing doctor's notes, always calling the school to let them know that I was in the hospital.
Then they handcuff me. So they take me outside for what you call a perp walk. And oh my God, the TV news was there. The newspapers were there. You could swear I had killed somebody. It was degrading and humiliating. I was taken to the Criminal Justice Center. They took my mugshot. I was fingerprinted like a criminal, and I was terrified.
And it felt like I caused her so much pain because in reality, it is because of me, even though I know it's
That
not
music is
directly
something
my
else.
fault.
I'm not doing that. That's them.
Sorry.
The next day, the Orange County Register showed the pictures of my arrest.
Oh my God.
They even had a close-up picture of my hands in handcuffs to show here's a Black mother being arrested.
It was a truancy rate at over 2.5 times that of white students.
Everyone knew most truant kids were Black. I think Kamala Harris wanted me as an example to threaten other single Black mothers, like, this can happen to you if you don't get your kids in class. The police even put out a press release naming me and other Black single mothers like Toya Daniels who got arrested the same day.
Dude, that's
But
crazy.
my hell was just beginning. They gave me 2 charges: failure to supervise and encourage school attendance, and contributing to the delinquency of a minor. I couldn't believe it. They framed my daughter as a gang member and basically charged me with neglect. I spent the next 2 years in court fighting these charges. Kamala assigned her nastiest prosecutors to my case.
My homicide prosecutors, my gang prosecutors. And they went over there and I said, when you go over there, look really mean.
Like 10 different prosecutors. They kept pressuring me to plead guilty and spend a year in jail. But I kept refusing because I did nothing wrong. All the time I had to spend going to court, I was struggling to care for my Shayla. I lost my job and couldn't pay rent, and we got evicted. I became homeless. We had to move into a motel.
And I ended up being in the hospital a lot during her trial. And in that hospital stay was when I had my stroke.
I had a stroke about 4 or 5 days ago, and right now I'm doing pretty good. My hand is doing okay, I guess.
In 2015, after 2 years, they finally just gave up and dismissed my case. In 2018, the Supreme Court of California ruled that truancy cannot be punished by incarceration. It was unconstitutional. The courts finally stopped Kamala Harris' abuses. When I look back, I ask, why did Kamala Harris arrest me? Why was Kamala Harris so insensitive to a Black woman with a handicapped child? Well, first, I learned that Kamala Harris has no common experience with Black people. She grew up with an Indian mother. I remember she kept saying she was Indian.
To become the first Indian senator in U.S. history, which would be quite an accomplishment.
Not good.
What we're going to cook today is an Indian recipe.
Yes.
Because you are Indian.
Yes.
And I learned she grew up in Canada, not in the United States, and went to a wealthy high school. I think in Canada, she must not have been exposed to American values, which respects the rights of individuals. When Kamala Harris ran for president in 2019, they asked her about arresting people like me, and she just lied her ass off.
The truancy program got a lot of criticism too. Did you actually lock anybody up?
No, we never locked anybody up. We never sent a parent to jail.
And no parent went to jail.
And we did prosecute some cases, but far few, only about 20.
It's ironic because Kamala helped raise money to bail out murderers, rioters, and thieves. But she thought I belonged in jail because I had a handicapped child. To me, Kamala is fake. She just repeats stupid things like unburdened.
What can be unburdened by what has been? What can be unburdened by what has been?
I can imagine what can be and be unburdened by what has been. You know?
I found out she only became Attorney General because she was a mistress to the married San Francisco Mayor, Willie Brown.
Are you his daughter? No, I'm not.
And today I see she tries appealing to Black audiences by putting on fake urban accents.
And we're gonna do it again in 2024.
Black people are very down to earth. This is insulting to us.
You better thank a union member for vacation time.
Kamala, how stupid do you think we are? And I saw Kamala's Twitter photo. That's from like 20 years ago. She's 60 years old today. Even with the heavy makeup, you can see she's 60. I seen her pretending to be talking on the phone, avoiding the press. She's a terrible actress. She was calling young people stupid.
What else do we know about this population, 18 through 24? They are stupid.
With Kamala, we can't even say Merry Christmas.
How dare we speak Merry Christmas? How dare we?
The laugh is so insincere.
You think you just fell out of a coconut tree?
We have to stay woke. Like, everybody needs to be woke.
And yeah, I am radical.
All this woke and radical stuff doesn't do anything for me as a single Black mother. All it got me was inflation that hurt me and my kids. Grocery store prices are crazy. I can't pay for food on my income.
I am in favor of saying that we're not going to treat people who are undocumented across the border as criminals.
Black people has been in America for 400 years, but Kamala pushes us to the back of the line behind illegals. Why? As borders are. She just filling up our schools with kids who don't speak English just so they can get more government money. Illegals get free health care, but I have to pay. They get free housing, and I'm struggling to pay rent.
Are undocumented immigrants that are the least likely to commit a crime.
And it's more dangerous in our neighborhood. We don't need Venezuelan gangs.
To this day, at 22 years old, I suffer from full paralysis on my right arm and partial in my right leg.
Kamala Harris owes me an apology and my daughter an apology for what she did to us.
Let's be clear, my values have not changed.
Look, I am not a political person, but I want people to know what Kamala Harris has did to me. If she do it to me, she will abuse anyone if you give her the power.
All right. So shout out to We Watch YouTube, sent me that link again. So I dropped the link down in the chat. That's what I believe is the law of unintended consequences. You put something in place that maybe you think is good. Like, let's just put it in perspective. If you were a principal or over a school district and you saw lots of kids not come to school, you want to hold somebody accountable. You want to say, hey, we're going to hit these parents in the pocket. So we're going to give them a fine every time the kids don't show up, or something of that nature. You're trying to do something that you perceive as good. I'm going to assume that what she thought was good in arresting these parents. However, the unintended consequences is that if your only parent, the only breadwinner, is in jail and fighting a court case, how are they going to get the kid to school? And that's a healthy kid. We're not talking about this baby. That poor baby was needing some real care. But she seemed to have a good attitude, though. So shout out to her. But the unintended consequences, and that's the thing I say about education. A lot of the time they don't think about, if you go heavy in one area, you're going to go light in somewhere else. And there's going to be this exchange that happens that you don't see happening. This right here was very bad. And hopefully you all enjoyed that. It was, I thought it was really interesting. So again, thank you. I had a couple people send it to me. I had some people way out of the woodwork send that to me. So, but shout out to We Watch YouTube, because they put it, they sent it to me this morning. I said, you know what? I'm going to do that right now. Okay. I'm looking at somebody sent me an email, but I think Ashley Merchant and them are back. Good gracious, man. We going to get no rest. There's no rest for the weary here. They are back, but Judge Cross is not here. Hold on. Let me just pull in just in case, because I know you all enjoyed Ashley Merchant. Who knows? Maybe they'll be done and they will go jump back to YSL. I don't know, man. This is crazy today. Today's crazy. Is this it? This is it. Let's go. And the mic is on. Oh, now they're looking at the ceiling. Well, as they get settled in, let me do this. While they're getting settled in, I'm gonna mute it just for a second. I want to say, hey, thank y'all so much for tapping in today. Almost 300 of you all, 248 actually now, that are watching. And I'm glad that you all are finding value in this. We are still doing the YSL trial. However, there was a lot going on as it relates to Ashley Merchant suing the Fulton County DA's office for Freedom of Information Act. And it was very informative. So I thought it would be good for us to all kind of jump in and kind of check that out and see what's happening. And there was a lot of, they had another 911 operator in the YSL trial. And she was on there for a while. So I think a lot of that was just kind of, again, I think they were just kind of slow dragging to wait for the next witness and whatnot. Now, I do want to know, and I will jump over at 2:15 is when YSL comes back, because Zachary's attorney was in the house right before they went to lunch. And Judge Whitaker said, man, we gotta go. I got somewhere to be. Come back after lunch. I still want to hear so I want to know what he was talking about. So I know we just got jumping around today. Hopefully you all won't be too disappointed. I don't want to get you dizzy and give you vertigo. But once he comes back, I do want to jump in and see what he had to say, because it looked like something important. He looked like he really wanted to say something to Judge Whitaker. I'm hoping and praying that everything is okay with Zachary. But if he's having a crisis like this young lady is, that's going to be problematic. Oh my gosh. So there's a lot happening today. We're going to turn DWC into a 24-hour live stream channel. No, we're not. We're not going to do that. All right, let's bring this back. All right, so we got John Merchant right there. We see Ashley right there. The young lady with the bun back there, her name is Murdoch, I believe. I don't know who this gentleman is right here, though. I don't know who this guy is. He's new, and I don't know who this young lady is right here. But, yo, thank you so much. Amethyst has been a member for 4 months. What does she say? Fonnie's office motto: if you can't dazzle them with brilliance, baffle them with bovine excrement. Go Ashley, and YSL defendant state is sunblind. I agree. I will say, I personally believe that Fonnie Willis's team watches. If you ever watched the movie Chicago, where Richard Gere is this big attorney, and he's trying to get his client off who's guilty of unaliving somebody, and he says, "Give him the old razzle dazzle." And that's what I think Fonnie Willis's team does. They try to razzle dazzle him, but lo and behold, it's not working. It is not working. So, okay, somebody walked in. I thought it's not Judge Cross. Judge Cross is representing today. But what's going on, President Not Perfect? Good to see you, sir. Grace and peace to you. Yeah, definitely praying for Quez that everything is well. I don't want them. Look, the man was trying to do his life, live his life. I want him to live his life and do whatever he needs to do outside of this courtroom. But hopefully y'all saw that yesterday. That was so vile. How easy they were just like, oh yeah, it doesn't matter. It doesn't matter. And mind you, and I'm sorry, Judge Whitaker is wrong on that. She did not take the word of Little D's attorney who talked to the doctor. She took the word of Adrian Love, who wasn't there, who was told this information by an investigator who wasn't in court yesterday, who talked to the doctor. So there's like 2 layers rather, when she could take the word of Mr. Zachary's lawyer, who Mr. Zachary's lawyer translated as, he's going to be on Oxycontin. He's probably not going to be as the most lucid, and it's not a good look. She goes and asks Adrian Love, and Adrian Love says something totally different, and she wasn't there. Sure, Captain. Real quick, my email is as follows. There's my email in the chat, my brother. Yes, sir. Yes, sir. There you go. So yeah, that was really interesting. I thought they were going to be back at 1:15, but maybe Judge Cross is she might be having a little delay. Okay. Well, everybody else is back, so that's cool. Shady dealings. Shady dealings all day? Shady deal day? Is that what we're doing? I like how you did that, because it's like, yeah, I see what you did there. Or shade all day. That might be shade all day. I'm sorry. Y'all, I can read. I promise you. I really can. Hey, there goes my buddy Mo Justice in the building. She took the word of an officer of the court. Zachary's attorney needs to file a motion with supporting documents. But isn't Zachary's attorney an officer of the court too, though? Does that make him what makes Love an officer of the court, but Zachary was named Scheib? Mr. Scheib, not an officer of the court. Okay, here goes. Judge Cross is here.
Reconvened. Madam Court Reporter, are you still with us? Yes, ma'am. Thank you. And are you ready to reconvene? Yes, ma'am.
The court reporter is on Zoom.
Started whenever everybody's ready, right? It looks like we're missing somebody.
No, we're not missing anybody, but I did want to make a note that the court reporter would have to leave by 4 p.m. Is that going to be an issue?
I think we'll probably have to decide at 4 p.m. But if we're going to lose our court reporter and we for some reason still need to go on, and as I've mentioned, we will just continue the hearing into the morning, and we'll reconvene in the morning.
And I'm officially cleared until 5 now. Sorry about that.
Okay. Hopefully, I'm really hoping that we're going to limit the nature of the examination of all of these witnesses to very narrow issues associated with the Open Records Act so that it wouldn't take 3.5 hours, but one never knows.
And Grant, I would just know that I actually have an issue at 4 o'clock as well, related to child care. Kidney.
Okay.
I was 4.
Okay, so just this 4 o'clock is coming up now. We were asked before the break to take witnesses out of order because Ms. Miller needs to leave by 4, and we agreed to take them out of order to accommodate that. But if everybody has to leave by 4, then we would prefer not to take them out of order. We were doing that to accommodate her, but she needs to leave by 4. But if we have to end at 4 anyway, then we can take them in the order that we wanted to.
Okay.
That makes sense.
I feel like that makes good sense if we're gonna need to end by 4 anyway, to let the plaintiff call whatever witness they want to, since if we haven't reached Ms. Miller yet, everybody will be leaving at 4, and then we can reconvene tomorrow, and hopefully we're not gonna have a conversation about when and how that will be until and unless we need to. Okay.
And Judge, just, we will be here tomorrow. I have an appointment a doctor's appointment, a medical issue at 2 that I will be gone for, so Mr. Merchant will continue. If we're in the middle of a witness, I just wanted to let the court know that we will try to not break a witness up or anything like that, but we did not plan on tomorrow. We will definitely accommodate, but I
completely understand, and I hope that all of that is an only what if and doesn't actually come to fruition anyway. So let's go ahead and get started.
Great, okay, so we would call Dexter Bond into the stand, and we would invoke the rule of sequestration.
Okay. So the rule of sequestration has been invoked. That means that anyone who is expected to be called on as a witness, I see that Ms. Miller is stepping outside.
And Judge, I think this could make things faster. The county or the defendants indicated that in some of our conversations about that they may be willing to stipulate that our open records were received and that they were not responded to within 3 days, according to statute. If that's the case, I can remove a lot of my questions. But if the court wants that testimony, then, I mean, I think the question is when they were complied with, but I don't think anybody's arguing they were complied with within 3 days. So if that's the case, I can remove a lot of my questions.
Ms. Monroe or Mr. Bowman, who am I going to hear from relative to this
You'll be
witness?
hearing from me. So, what I did say that I was going to stipulate to is that the information wasn't provided initially, but as far as the 3-day window, I would have to double check because there are several requests before your Honor. So I'd have to double check which ones, in fact, were not responded to within 3 days. So I can't make that confirmation. If I just have like 2 minutes to check my notes to see which ones were actually.
I think that is time well spent because that 2 minutes might save us 30 minutes. So if you will take a moment to do that, that would be much appreciated, Ms. Monroe.
Thank you.
And regarding as a moment ago, I was talking about the rule of sequestration, just right now, it looks like we're only gonna be having Mr. Bond and Ms. Miller as an initial matter, but I just always ask, y'all know who your witnesses are and what they look like way better than I do. So if somebody wanders in, please keep an eye out. Also that applies, I'm sure I don't need to say this, but it bears repeating to anybody that might be watching on the Zoom or on the live stream. If you anticipate that you might be called as a witness in this matter, you should not be observing these proceedings. Thank you.
All right. So hopefully this will get cranking. Look, Judge Cross is like, look, I don't want to be going past 4 o'clock. What y'all talking about tomorrow? What do you mean? What do you mean? She said she's not having that. So she's gonna move them along. Hopefully they'll they'll be able to get a lot of those questions off the radar and off the docket. That'll be good. Oh, we know Fonnie watching. Fonnie's up in the chat. We know that. We know that she here. Let's see. Am I missing anything? Am I missing anything? All right. Looks like good conversation going back and forth. Love it. Love it. All right, here we go. Is this him? I think so. Let's go.
Careful. I'll give you the same spiel. So be careful of the ledge to your left there, because that chair is on wheels, and I have actually had a witness take a tumble, and I don't want that to happen.
That's not cool.
That would not be number two. I appreciate it. Thank you, Your Honor.
All right, here we go. You haven't missed anything yet, Gemini. We're literally just getting settled in. There's a little bit of horse keeping and horse trading, but really, it's just really getting started right now.
Tell you what, since Ms. Monroe, since Mr. Bond is here, if you'll continue to keep looking, but also let Ms. Monroe see if she can at least start with some of the preliminaries. And it may be that even I'm sorry, Ms. Merchant, it may be even that Mr. Bond can confirm what you're trying to confirm. I appreciate the effort, but just in the interest of time.
Yeah, of course.
Mr. Bond?
Yes.
If you'll do me a favor and raise your right hand, I'll swear you in. Do you swear the testimony that you're about to give the court will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, thank you, sir. You lower your hand. Now, if you would, for the record, state and spell. There's musical accompaniment. I don't know. I was surprised I know it was there.
Brother.
I thought it was a document too. I'm like, I've never happened before. Okay.
Wow.
Okay, so I think you already, or I was asking you to please state and spell your name for the record, and then I will deliver it over to Ms. Merchant to begin her questioning.
My name is Dexter Q Bond Jr., B-E-X-T-E-R, middle initial Q, Bond. I am a junior.
Great, thank you so much, Mr. Bond. Can you tell us what your job title is?
I am the Deputy of Operations for the Office of Fulton County District Attorney's Office.
Does that include being the records custodian?
Yes, among many things.
And before we get into the documents, I want to talk to you a little bit about the portal, how that's set up. If first, let's talk about at the time that I made the request in January of 2024. Was there a website link on the DA's website for open records at that point in time?
In January, yes, there was a link on our website, yes.
And when a person clicked on the link on your website, it took them to the county attorney's open records portal, correct?
Yes.
And there was a drop-down box if they went to that open records portal to request records from the district attorney's office.
And I can't speak to that because I don't request records from the district attorney's office.
Okay. So at some point in time from then till now, was that landing page from the DA's office website removed?
I don't have information to that. I don't know.
Do you know if the open records page, the page that the public would go to, if that link was ever altered?
Are we talking from, give me a time frame.
From January until now. So what we just talked about was in January. If I went into the DA's office website, I clicked on open records, it took me to the portal.
Yes.
A month ago, if I went on the DA's website, clicked, and there was no open records link at that point.
I cannot speak to that. I do not monitor that site on a daily basis. I do a lot of things for the office, but that is not one.
Okay, so you cannot speak to whether or not there was an open records portal site or portal link on the DA's website?
No, I answered that question. There is an open records link on the DA's website. You will click the link, you can go into the portal, you can request open records request as you do. Oh,
So there was one in January and there is one now, right?
to my knowledge, yes.
Do you know if it was removed at any time over the last 9 months?
I cannot speak to that.
Okay, thank you. Who could?
I don't know. I don't maintain that particular website. Once the information is placed in the portal, if necessary, it will be elevated to me, and I do my job as the business records custodian. But as it relates to it sounds like, forgive me if I'm wrong, but I'm interpreting your question to be a little bit more, I don't know what you're asking me, but
I'm trying to ask how the public asks you for open records.
And I'm saying that the DA's office has a website, as you know. The DA office has a link that you can use. The DA's has once you click that link, it goes to a portal, which you have used several times. And once you go into the portal, you can put in your request. That's what I'm saying.
Are you able to testify over the last 10 months that process has been in place?
I don't object just based on the fact that the availability of the link in the portal is not an issue in this case, and it's not an issue pertinent to whether the records were provided by them.
Ms. Merchant, is there a reason, is what you're really trying to get to that for the entirety of the last 10 months, Mr. Bond or someone else would be tasked with and subject to complying with open records? Or are you really trying to ask if there's an actual portal button on that website for the whole last 10 months?
I'm trying to figure out if they've had, so once I made my request in January, I had to make follow-up requests and it went away. And I wasn't able to continue to make those follow-up requests, which is part of what, when we continue to make those requests. Okay.
Forgive me, I'm gonna reframe your question and you make sure that I'm not reframing it appropriately, right? Your time frame at issue is from January to the present.
Yes.
And you are asking me at any time, did that particular process view?
Yes.
The answer is yes. May I explain?
Please.
Because of the cyber attack. I do know, if I'm familiar, that you received the open records request saying that, hey, we are under a cyber attack, this will require a delay. And I do know that this portal is not maintained by my particular office, right? I think you and I can agree with that they made some modifications. So if your question is, look at 10 months, did something change from the routine? The answer is yes. The reason why is because it was a cyber attack.
I'm just gonna interject very briefly. You're like me, you're naturally a fast talker. And for the benefit of the court reporter, she's already asked us once to slow down. So if you'll try to be more conscious about speaking slowly so she can take it down, okay?
Yes, Sean.
Thank you, sir. Go ahead, Ms. Merchant.
And I just want to make sure I understand. So it changed because of the cyber attack. So that portal link was at some point disabled or not available?
So you asked me, did something change? I reframed the question to make sure that we were on the same page, right? I told you, yes, something did change. I gave you an answer as to why that did change, and that was as it relates to the cyber attack. Again, the framing of your question was from January to the present for the last 10 months, right? And enter in your question, you asked me something about the last 10 days. So forgive me.
10 months, I'm sorry.
You said 10 months, but you also said 10 days. I asked you a follow-up as it relates to the framing, right? I've answered that question from January to the present. I have told you that the reason why that has changed is because of the cyber attack. I've also told you that I do not maintain that website on a daily basis.
My question was, how has it changed? You said it's changed. My question is, how has it changed?
I cannot answer that question. What I can say is that from 2021 to the present, the DA's office has had access that allow constituents like yourself to request open records. That link is displayed on our website. Once you click that link, you can go into the county's portal. I've also told you that I do not monitor that website on a daily basis. So if you're asking me how, I cannot answer that question. But if you telling me, look at the last 2 months, if it has changed, I am telling you, a cyber attack has required a lot of things, including open records, to change.
Do you monitor the open records portal?
Do I monitor it on a daily basis? No.
Do you monitor it at all?
Yes.
How often do you monitor it?
On an as-needed basis.
As needed.
Yes.
How do requests come to you?
You go to the link, you put in, it goes into the portal.
Oh, sorry, and just to save time, I'm not asking how I do it, I'm asking how they come to you.
Once a staff member on my staff, a designated staff member for open records request, receive the open records. If it's standard, like the many of you have supplied, we can go ahead and give you a responsive record, right? If it's not standard and it requires an elevation of some sort, then it is elevated to me by a staff member.
Elevated to you?
Elevated to me by a staff member.
So the first sort of triage is the staff member reviews it, determines if they can just answer it quickly.
I would say that, yes.
And then if it's something that's more elevated, can you describe what something more elevated would be?
I'll do it the opposite way if I can. If you're looking for an invoice, a particular invoice, and that invoice has been commonly requested, my staff knows that this is a particular invoice. And for efficiency purposes, we get that responsive document to you as quickly as possible. And then if you're talking about something that is exempt or possibly exempt, that's an example of something that's going to be elevated. And not in this particular case, but in some cases, my exemptions include open and active investigations. So in those particular cases, that'll be elevated.
Were my requests elevated?
You have to be more specific. You know, you gave me about 40.
Were any of my requests elevated?
Yes, ma'am.
Were any of my requests not elevated? Narrow down.
I'm going to say yes because 40 was not presented to me. I know that you are a frequent open records requester. I know that we have responded to open records requests. I am familiar that you, I would say dozens, and I would not say that all dozens have been presented to me. Those have been closed out based on my monitoring. So I am comfortable saying that all have not been elevated to me.
And you said I did 40 open records requests?
I said dozens, maybe 40. I feel comfortable saying dozens. I know.
They're maintained on the open records portal, right?
Yes, I'm pretty sure they are. So maybe 40, maybe 30, but I know it's a lot.
Would it surprise you that it was less than 12?
Oh yeah, I think I'll be surprised with that.
Okay, well, let's go through them in a minute. We'll go through the specifics.
May I ask a follow-up? 12 an issue or 12 total?
In total.
Since when? January to the present?
Correct. Since Ms. Willis was DA.
That would surprise me. That would surprise me.
You all have an employee manual that you use at your office, right?
Yes,
Right. And that governs, it also talks about open records requests.
I believe so, yes.
And if you want to look, we've got, these have been admitted previously. This is merchant 0602. I believe you're, the county attorney supplied this, I'm assuming from your office. Does that look like, you can look at it on your screen, part of the employee handbook that's given to new hires that Ms. Willis created? Or updated.
Mr. Vaughn's eyes maybe better than mine, but you might need to make it bigger, because
Okay.
my screen's pretty small and I'm struggling.
Yes, I agree.
So that's okay. Thank you.
So does that look like the section regarding open records compliance?
Yes, at first glance, yes, 6.6, Open Records Act compliance.
Okay. And it says that all open records requests submitted by members of the public will be handled by the open records officer. Is that you?
It will be handled through the portal, so no, not necessary. It will be handled under my leadership.
Okay. And so handled under your leadership, but through the portal. It also says that DA employees should consider all communications that occur on county email, cell phones, and other county-owned technology to be considered open to a FOIA request.
Subject to no exceptions, yes. So I think that's consistent with the Open Record Act. I would agree with you.
Okay, so subject to no exemptions, county email and cell phone communications would be something that you would provide open records.
General rule, but I think you and I can agree certain things, exception. I work with 385 staff members. Of those 35, about 150 or so are attorneys, and we know that there's exemptions. So anything that they're working on as it relates to attorney work product or confidentiality work product are exempt. So yes, this is the general rule, but I don't want the general rule to be mistaken as the norm.
Right, I understand, definitely, there's statutory exceptions.
You and I are same page.
The statute's the
And to
statute.
be clear, the employee handbook, while it is helpful guidance, doesn't change what the statutory obligation is one way or the other, so.
No, just, and the reason I'm asking him is the process in their office, to try and understand this process.
And if I can clarify, I think the second sentence is certainly important, right? I know that our employees, again, I alluded to the size of the office, 385 approximately. We want to make sure that staff members who receive open records requests know what to do with it. So that, I think that was the angle.
Okay, so the employees receive this and they are told that they need to forward it to legal counsel of the district attorney when they get something.
At the time of that writing, yes, legal counsel.
This is the current handbook, though, right? I'll represent it's the one that your office provided earlier this week through Ms. Monroe.
I would say yes. If your representation is correct, I would take that as this is the correct one.
And legal counsel, right now it's Ms. Abbasi, I don't want to say her name wrong. Alabi, Ms. Alabi is legal counsel now. It was Mr. Armstrong before, correct?
Yes, he was at one point.
Okay. So according to this, Mr. Armstrong or Ms. Alabi would be copied on all open records requests received by employees?
So no, let me deviate. The answer to that is no. The reason why is we had several different legal counsels since 2021, and based on their strengths, weaknesses, or expertise would determine whether or not legal counsel will handle that. I had legal counsel before. That was his expertise. He felt comfortable handling it. I cannot say if Kevin Armstrong handled open records. So I want to be clear. As it relates to Andrea Alabi, a dynamic attorney, however, open records is not something that she handles.
So if a member of the public was reading this and at the time they made their request, Kevin Armstrong was legal counsel, it would be reasonable for them to think that Kevin Armstrong would be apprised of their open records requests, assuming this is followed.
No.
No.
No, I don't think so.
Okay. This also, let's see, if we go down a little bit more, it talks about emails. Let's see, email communications. This advises employees that emails are monitored, and essentially that means that you're telling them you have access to emails, or the office has access to emails, correct?
You have to tell me the line. The way that I read that is, my district attorney, Fleming T. Willis, requires us to look at emails. So 3 times a day is our standard.
If you look under section 6.9, the third line, it says to ensure compliance with this policy, computer and email usage may be monitored. Does that mean that the district attorney's office can monitor computers and emails?
Not necessarily. Well, can we? Yes.
Can, that was the question.
Yes.
Okay, so you have access to emails?
Yes. I do have some. Let's be clear.
Some.
Some emails, yes.
Access to county files? On county computers or county phones?
Yes.
So on a county computer file email system, you've got access to emails.
When you say you.
Your office, I'm sorry.
Okay.
I mean, when I say you, it's been represented, and we can pick a term if you want, but as that you're the man for open records. You're in charge of all of this. So
the answer to your question is, as a you, as in Dexter, right? Yes, I will have access to that.
Okay.
Or I will request access. Is that better?
yes.
Okay.
And so this also, if you look at, let's see, after where it says only those who are directly supervised by the district attorney can send emails directly to her. So is that the policy that someone who's not supervised by her is not permitted to send emails directly to her?
We have a strict chain of command, so I think that is true.
Okay, so it's reasonable then for a member of the public who is trying to see emails to assume that emails would go through a supervisor before they went to the district attorney.
That would be a general practice. I think so.
As an open records custodian, part of your job is to be familiar with the rules with record retention, right?
Yes, to a degree.
Okay. And so you've got to, and that's actually in the, if you look on the same page, if you go up a little bit, there's a policy for record retention, and it says that all records are maintained in compliance with the state of Georgia's retention schedule. Would you agree with that as the policy of your office?
That is the policy.
So any records that the public is trying to access, they can assume based on the policy of the office that you're going to retain them based on the state of Georgia's retention policies.
That is an accurate assumption based on this policy.
Okay. While we're on this document, if you flip to the next page, 0603, it talks about county cell phone policy. It says that all investigators or attorneys are required to have a county cell phone, and that text messages, recordings, and photos within that cell phone are the property of the county. So that means that if someone did an open records request for those types of documents, that's in the county's property, right?
This is what get here. As it relates to Fulton County's property, the answer is yes.
So it says they're required to have a county cell phone. So an attorney is required to have a county cell phone. Let's use an example. Jeff DeSantis is required to have a cell phone, county cell phone, correct?
He doesn't work as an attorney in my office. If we're going through your analogy, give me an attorney. I can't speak for Jeff.
And I'm looking, it just says all investigators and attorneys.
And Jeff isn't an attorney.
He's not an attorney?
I don't, in the capacity of my office, no, he doesn't act as an attorney.
So.
ADA, yes, is required to have a cell phone. An investigator.
Are you saying that Jeff DeSantis doesn't have a county cell phone?
No, I'm not saying that.
What are you saying
The
then?
analogy that all investigators and attorneys are. I understood your analogy. You gave an example of Jeff DeSantis. If your analogy is investigators and attorneys, I want to keep you honest, and I'm letting you know that in the capacity of Jeff DeSantis, he doesn't fall in either category. So I'm following you, and I offered you an opportunity to present someone else.
Why is
and I
it so
gave you
combative?
an idea of an ADA, because the ADA fits with your example.
Let's back up for a second.
Okay.
Jeff DeSantis, and I was just using him as an apparently unfortunate example. He is the deputy district attorney, correct? That's his job.
His working time in the office is public relations.
Can I personally research? Sure. Thanks. Showing you a printout of the district attorney's website. You take a look at that and see if that refreshes your memory as to what Jeff DeSantis' official title is within your office.
Deputy district attorney,
Thank you.
overseeing the media relations unit.
Thank you. So the policy that we're looking at, county cell phone, says all investigators and attorneys are required to have a county cell phone. You're saying that not all attorneys and investigators are required to have a county cell phone, is that accurate?
That's not what I'm saying. You gave me an example of Jeff DeSantis. I could not speak specifically as it relates to Jeff DeSantis. I'm not arguing whether or not this policy exists. All investigators and attorneys are required to have a cell phone.
Okay.
That is correct.
Okay, so all unnamed attorney has a cell phone. According to this policy, if that unnamed attorney on their county cell phone is messaging on an app on their county cell phone, and they're recording things, and they're taking photos, screenshots from an app, that's subject to the open records request.
If there's no exceptions, yes.
If there's no exceptions, thank you. Okay, let's move on to one of the requests that I want to talk about, and I have a couple different identifiers if you need them, but it's the critical mention media monitoring. Oh, do you know if Jeff DeSantis has a county cell phone?
No, I do not know that.
You do not know that. Okay. Who would know that? I'm assuming him. Anyone else?
I don't know.
Okay. All right, so let's move on to critical mentions, media monitoring. If you need me to tell you the request, the open records number request, or exhibits or anything, I'm happy to do that. Just let me know. Okay. But I'm going to globally refer to them as critical mention media monitoring.
Okay, I'm gonna stop you here. I know that we have a lot of critical mentions. So I would prefer, for the clarity of this court, to make sure that we're specific on critical mentions, because I know there's multiple.
Not a problem.
So
There are
don't-
two.
So my ask is don't globally refer to them as critical mentions. if
I
that's
will
okay
not
with
then.
you. Okay,
Can you pull up merchant 0027, please? There are two requests. This one, just for your clarification, ends in 010924. This is my first open records request. On January 9th, I requested any and all correspondence, as you can see, to or from critical mention, including copies of contracts, payments, analytics, reports to or from critical mention in any member of the district attorney's office. Would you agree this request is pretty clear and concise?
Based on my reading, yes.
And I submitted it through the Fulton County Open Records portal.
January 9th, yes.
And it was received January 9th. It says, if you scroll down a little, it shows it was received that day. That's when they return it with the reference number, that is saying that it was received.
That is correct.
Can you repeat what page you were referencing?
I'm so sorry. Yes, it is a merchant 0027. And it acknowledges receipt of the open records request, correct?
On January 9th, I received that via the portal. We acknowledge receipt because you have a reference number. The answer is yes.
Okay. It doesn't say anything about whether responsive records exist.
Not on January 9th. That's the day I received it.
Doesn't say anything about proposed costs or when the records will be made available.
On January 9th, when I accepted it, no. I think that you have requested several open records requests. You have given them, you've been giving all the records, right, that we closed out free of charge. So there is not anything that from my office that would have a cost because I did not charge you on any open records requests that you provided.
I didn't ask that. I asked if it provided any proposed costs. Does this provide any proposed costs?
On January 9th response, this document that you put before me, January 9th, I acknowledge that it is a receipt number for tracking purposes. It is an acknowledgement of receipt and it's a description of the records you requested.
If you would scroll up, so on January 12th, someone wrote back, or I wrote, thank you, and I followed up saying I was asking for the analytics, the contract, and the analytical reports. And I was asking, following up, when I could receive them.
3 days later, yes, it appears, I don't know, Ashley Merchant wrote, thank you, in follow-up. I also asked for, yes.
Okay. And then on January 11th, someone, either from your office or the county, said, please log into the portal and see attached emails, correct?
January 18th.
January 18th, I'm sorry, if I said it differently.
So January 18th, based on this email, we gave you attached emails, and included in those emails, there were several different documents. So yes, I responded to this open record request on January 18th.
Did you type this or did someone else? Please log into the portal.
I did not type that.
The attached emails, did you provide those attached emails?
No, I did not.
Who provided those attached emails?
A member of my staff. A member of my staff. I do not know who provided that on January 18th, but I do know that this particular request, as you said, was pretty straightforward. So we responded and it was closed out. This wasn't elevated to me.
So you never saw this request? You were not involved in this request at all?
On this particular request based on the portal, I don't recall this being elevated to me on January 18th, no.
So you can't tell us what searches you performed looking for these documents?
I can tell you that.
You can?
Yes, this was a general request. It wasn't elevated to me. Critical mention is something that was always asked. I have several requests that are very similar to this. So I'm pretty sure, not this particular one, but one of critical mention was elevated to me and we responded the same way we did with most critical mention.
Who did you ask?
I'm sorry?
Who did you ask in response? You said you did ask somebody about these records. Who did you ask?
So with critical mention, you ask, based on this search, you will look and you will reach out to Jeff DeSantis. Hey, do you have any emails related to critical mention? After that, you will go to the IT department to confirm.
Okay.
See if there are any responsive records.
Fulton County IT department.
Yes.
Okay. So Jeff DeSantis and Fulton County IT are the two. Okay.
Especially when you ask it for emails, the answer is yes.
But you don't know if you did that in this case.
I know that I did that in critical mention. I have 1,000 cases. So as it relates to this specific request, I cannot tell you that this particular case was elevated and this was on the top of my list.
And once someone makes a request like this, what steps do you take to ensure that the documents they're requesting are preserved?
Repeat that?
When someone makes a records request like this, as an example, what steps do you take as the records custodian to ensure that the documents they're requesting are preserved?
They are placed in a portal. Once the portal is sent to you, I think that you have access to that, and I think that that is something that the portal does and make sure that it is reserved. And I can have a copy if I needed to go back to those specific documents. So as it relates to you, this is when you and I are going to make sure we're not splitting the baby. But as it relates to the portal, they are reserved.
And we'll use this as an example and sort of walk through the request. So once you get a request like this, whether it's elevated or not, what are the steps your office takes to make sure that the documents I'm requesting aren't destroyed?
Typically, once documents that you're requested are placed in a portal, the portal, right, will maintain those particular documents, right? You have an email version, electronic file of those versions, so that's in the portal. So, and
maybe I wasn't clear. So you're telling me how you maintain the documents you give me. What I'm asking you is when I ask for critical mention documents here, okay, and you get this request and you give me some of them, how do you make sure that they're all maintained?
So
do you all maintain them?
I'm going to answer your question. I'm going to make an assumption if I may, okay? I made a comment and I said that there was 40 open records requests. You looked and it appeared, assumption, emphasis on assumption that you was going to go see how many open records requests you had.
Right, it's all there.
Yeah. So the answer to your question is it's in the portal, it's all there.
No, that's why I didn't know if you understood my question. My question is not.
I just repeated you.
Hang on, don't talk over each other because the court reporter can't take it down.
My apologies.
That's okay. Ask your question and then you are free to respond in any way you wish.
I'm not asking how you preserve what you tell me you have. What I'm asking is how you preserve the documents inside of your office that I request, not the ones you give me, but the ones I've asked for.
If you ask for 5 invoices, right? I'll take those 5 invoices. Those 5 invoices is given to a staff member to provide to you. So the original copy of those invoices maintain wherever they are, right? You have a copy that's filed electronically, right? It is given into the portal. So if I understand your question correctly, 5 invoices. The 5 of those invoices are sent to someone on my staff. A copy of those invoices are uploaded to the portal. Those 5 invoices, the original copies, wherever you came from, continue to stay there. Did I answer your question?
Yes,
Okay.
so the originals continue to remain wherever they originally were.
It depends on the particular document. If you, in my example, I gave you invoices.
Right.
We do know that invoices are electronic, right? Well, I like to think that most invoices are electronic. So in those particular invoices, wherever they are on my particular file, they stay. A copy is employed to my staff member and then uploaded to the portal.
And let's go through some specific things that you gave me, and then we can sort of go back to that question because it might help.
Okay.
If you look, let's see, if you can pull up merchant 0029, on January 18th, there was, I received this packet that we talked about of emails uploaded to the portal. What you're looking at is the beginning of that packet, and it was 44 pages. That was in response to my original request discussing critical mention. You said you did not produce this document, correct?
No, I don't believe so.
Did you assist in retrieving these documents?
For these particular documents, no. These documents appear to be responsive to your open records request. It appears to be delivered to you on January 18th, and it appears to be responsive to your request.
You can look at 0055. If you go down a little on this one, see where it's after Melissa Fritz, it says Fonnie Willis critical mention search. It's a different font, and then PR value for the week, and then there's a couple other things. This, and we now know because we have the actual emails, we now know this is 4 or 5 different emails that were pieced together. did you participate in the cutting and pasting of these documents?
Objection, Your Honor. Objection, Your Honor. It presumes that he cut and paste documents, and that was never established by his testimony, so we're objecting to that.
Okay, well, for now, I'm gonna sustain your objection to the characterization of the cutting and pasting. But you can certainly ask him if he participated in the creation or generation of this document that was produced to you, however it came to exist. So your objection is sustained to that extent, Ms. Monroe.
And Judge, I thought it was Mr. Bowman's witness. I might be mistaken, but I prefer not to tag team.
Well, I do agree. I apologize. Who is going to be examining this witness?
I will.
Oh, okay. Well, then fair enough.
I didn't know that was a thing.
Well,
I mean,
Mr.
generally-
Bowman had objected, so.
Yeah, generally speaking, whoever's going to be examining the witness is the one who should be controlling the objections. And I think Ms. Merchant's expressed concern was she thought Mr. Bowman was going to question this witness, which would make your objection problematic. But since you're going to be examining the witness, it's fine.
That's fine.
I'll frame for the Your Honor.
Well, usually I just ask that you whisper in your partner's ear so they can then say the thing that you want them to say.
And I showed Mr. Bowman the documents because he had made the first objection, so I just was assuming that was the path, but I will check. Okay, so this document, however it was created, did you assist in the creation of this page?
No, I think you and I agree that the first request was straightforward. I don't think that this was elevated to me. On January 18th, no, it was not elevated to me.
Who compiled the document in the form that we see it in here today?
A member of my staff. That's an assumption. A member of my staff.
Okay, so you're assuming, but you don't know who compiled this?
Specifically,
Yes.
on January 18th, yes, this is a designated employee, yes.
You're positive it's a designated employee?
Well, okay. Yes, I'm positive I know who that is.
Who is it?
Erica Willingham.
Erica Willingham. So Erica Willingham is who we would need to ask, not you as the records custodian, about how this document was created.
I cannot answer that question. Let me explain why, right? Typically, emails are compiled in a certain kind of way, right? And those emails are compiled by IT, by staff. It may be compiled by going to reach out to various different persons. I cannot speak to that, so I cannot tell you if she personally, if the question was, did she compile? I do not know. I do know that she handled it as a member of my staff. I do know that she responded as a member of my staff. I can tell you that.
So you can't say as the records custodian that this is an accurate copy of an original document. Let's put it that way. You really don't know anything about this document.
I do know something. I know it was responsive to your request. So yes, I know something. I think you and I can agree on that.
Okay. Let's take a look at, I'm gonna jump out of order, I apologize. If you, let's see.
I also know, if I may, that it was provided to you on January 18th. I also know that you received this particular document on January 18th. I also know, as you mentioned, that there was a second critical mention document. In that second critical mention, I know you referenced this before, right? I also know that once you referenced this before, you renewed a second critical mention document saying, hey, you gave me this on January 18th, I'm looking for A,
Yes,
right?
and we're
And
there.
that's why you and I on the same page, didn't want it to be global. So I do know information as it relates to this particular request.
And we can actually go there right now. So I filed a second request because my initial request was closed when you all provided this 44-page document, right?
Yes, on January 18th, it was closed.
So on January 18th, I refiled my request and I specifically referenced the original one and said, why are you closing this? You didn't give me everything.
If I can,
Yes.
I like the fact that you presented the first one and allowed me to read it. Can I read the second one?
Of course, it is, let's see. I don't have the number off. The second one is. Merchant 0011. Can I take a minute? Oh, doesn't take a minute. There we go. So this one, I said in regards to my prior request, and I referenced that number we just talked about, and I said I requested the critical mention documents, and I say the number. I said I got a set of emails, but I asked for the analytics and the documents that are clearly referenced and attached to those emails. I said reports with analytics were provided to the DA's office monthly. It appears from the emails that Jeff DeSantis, Fonnie Willis, Jeremy Murray, Pallavi Perkasa, Robin Bryant, and Rita Kepler may all have access to these reports on a regular basis. They're public media, paid for by public funds and subject to open records.
Yes, I did receive that. This was elevated to me, and
Yes.
I did respond to you.
Okay, so this one was elevated to you, and you definitely did respond. Before we get there, let's talk about what we were just talking about a minute ago about I don't want to use the word cut and paste, the document, and I'm going to call it Merchant 55, that appears to have a compilation of several other emails contained within it. Okay, that document we were looking at a minute before, and you said you don't know who prepared that document, right?
I do not know who compiled that. I know who handled the file. I know who sent you the responsive document.
And you don't know where that person got the responsive documents. But you assume it was Jeff DeSantis, is what you said earlier.
I did not say that, ma'am.
You said you would reach out to Jeff DeSantis in Fulton County IT.
But he certainly wouldn't compile any documents for me.
Oh, okay.
Okay?
So who would compile them? Who would, and let's just look then. So you've seen, and can you show him again, Merchant 0055, just take a look at this document. So I'm gonna ask you to compare it to a different one.
Okay.
So just to make sure I'm clear, I thought that Mr. Bowen said that he believed that Erica Willingham was the person who compiled the response at Merchant 0055.
I thought he said that she did, but that she would reach out to Jeff DeSantis and the county. First, he said he didn't know who provided it. He said that they would reach out to Jeff DeSantis and Fulton County IT.
Well,
and then
that's
later,
actually why I'm asking for clarification, to make sure we're all having the same conversation, because I understood you to be asking him about who compiled the document that was provided to you, not who obtained the information that was then determined to be responsive and compiled into a document that was provided to you. What I understood Mr. Bond to be saying was, this type of request, I would have reached out to DeSantis and maybe County IT, and then it was compiled by this particular employee and provided to you.
okay. And I'm not sure. That's the ultimate question. So let me try and be a little more clear then. This document, number 55, okay? It looks as though it's a compilation of other emails, okay? If you look after Melissa Fritz's name, it says Fonnie Willis critical mention search, and then PR value for last week, and then there's that middle section that we're talking about, middle section right here. There's no header to, from, or dates here. There's no header to, from, dates here. There's no header to, from, dates there. That, they all look like different emails, right?
I would agree with you.
Okay, so not using the word cut and paste, someone took these parts and put them all in one.
Objection, Your Honor. Is that a question, is a statement? I mean, if it's a question to the.
Well, he's an adverse witness, so she can cross-examine if she wants to, number one. Number two, the reason I said we were not going to call it cut and paste is that assumes facts that are not yet in evidence. Now, you can ask questions about assumptions that you're drawing from the appearance of the document, but that's why I said we're not going to call it cut and paste. Now, I think the witnesses called it a compilation, so why don't we call it that for a while until we decide that it's something else?
So this appears to be a compilation of several different emails into one.
I agree. Compilation, yes.
Okay.
Go ahead.
No, that's okay. We're here to learn from you, tell us. What were you going to say?
No, I'm agreeing with you. That does appear to be a compilation of emails.
Okay. And can you pull up Merchant 0167? So there's a redacted section here, and then you can see under that, I sent a story via critical mention a few minutes ago, directly below. Okay. So this, and this were removed from that email. It just starts with I sent a story via critical mention. All of that is not in that compilation document, right?
As it relates to the headers.
As it relates to the
This.
Yes.
It does not appear to be so.
So this was all removed. And the document just starts right there.
I cannot tell you if it was removed. I think my testimony, Your Honor, is that this particular request came in January 8th, right? We responded on January 9th. On January 18th, we responded to the documents, right? Once we responded to the documents, you accepted it. What I need you to hear is we closed that particular file. It was not elevated to me. Your second one was elevated to me. Let's call that critical mention 2, if I may. That critical mention 2 referenced the first critical mention, right? In that critical mention 2 that you just displayed to me, it had only one specific item. I am looking for analytical graphs. I responded to that request. So as it relates to anything that from the first time I gave it to you, it was responsive because this is me as the business record custodian. Once I received the second critical mention reference that referred to the first, you and I can agree that the first had, let's just say, 5 things. You only made mention of one thing in the second one. I assumed 1, 2, 3, 4 was resolved, that is closed. And I responded on January 26th to the remaining issue. So as it relates to compilation, I want to be very clear. It was sent to you. It was responsive to your request. I moved on. You referenced it. Once you referenced it, it was elevated to me. The elevation was one specific item. So I assumed that the first matter was resolved and the only outstanding issue related was analytical drafts embedded into something, which I responded to you on January 26th. Is that clear?
No.
Okay.
And so let me break it up because there was a lot. So I tried to take notes. First, you said I accepted it. So on January, whatever the date was, 18th, I accepted it. When you said I accepted it, you sent me a document and I accessed it and it was immediately closed. So you're saying that's an acceptance of the open records response?
I am saying that we sent you the open records response that's responsive to your request.
Yes.
All right. I'm also saying that you opened up another open records request. In your second open records request, that's why it's very important we do not refer to this as globally. You make reference to the first. Yes. You said here in court that the first one was very detailed, in which I agree. Okay? I let you know that I did not have anything to do with that. You gave responsive records. Once you respond to me in reference to the first one, and there's one thing outside, I am a reasonable person, that's the word that you use, will assume that the first is over. It's done. It's complete. So I am assuming, reasonable or not, that you accepted the open records request because you said, here's a second one. I did this. I'm referencing that, and here's a small section.
So you assumed I accepted it and
it was delivered.
Hold on.
Is that better? It was sent to you on January 18th.
Yes.
Y'all, there is no reason to argue about semantics of what we're talking about. It is not a dispute that on the whatever day it is that the Open Records Act portal sent you a batch of documents. And then I don't think it's in dispute that that request was closed and then you followed up on it, which the county or the Fulton County, whatever we're gonna call it, treated as a new request that referenced a prior request. We don't have to argue about whether it was accepted or received or acknowledged or whatever. The facts are what happened. Let's move on.
So you said that that was responsive to my request, but it didn't completely respond. It only partially responded to my request, the first one. The 44 pages weren't all that you had.
Yes, Your Honor, is that a question or a statement?
It's a question. The 44
Okay,
pages.
hang on. When there's an objection, let me deal with it. We're just gonna put a question mark on the end of Ms. Merchant's statements because technically that's what they are, but they are allowable cross-examination questions, so.
I want to put the witness in the best position to answer the question. So if it's not posed in the form of a question, I think that's the onus is on her to pose it in the form of a question as opposed to a statement.
I think that right now I'm gonna, unless I believe that it's being deliberately confusing, which so far it is not, I'm going to allow Ms. Merchant to question the witness. And I'm gonna overrule your objection for now. Go ahead.
Thank you.
You have to repeat your question, I'm sorry.
The 44 pages that you sent me on January 18th, you said that they were responsive to my request, but they were not complete. There were additional documents. Now we have 197 pages. So the 44 were only partially responsive. Is that correct?
Okay, I have issue with your question, so let me break that down, okay? As it relates to you, I have testified that on January 18th, a member of my staff responded to you and provided you responsive documents, okay? So you as in Dexter Bond did not give you anything, okay, on January 18th. The responsive request for your records that sought 5 things were given to you on January 18th. The answer is yes. On the next day, as you just testified, a new open request was opened. You made reference to the first request, right? Of that, again, the first request was 5 things. You only asked about 1 thing. The first one was never elevated to me, okay? The second one I responded to on January 26th.
Okay. So my question, to answer my question, the 44 pages that you provided, your office provided on January 18th, that is not all the documents that were responsive to the original request. It was only partially what was responsive. Correct.
At the time on January 19th, I couldn't answer that question. I don't know. I don't know.
So you gave me documents, or your office gave me documents, and then you have now certified 10 days ago that 197 pages are the actual.
2 different things.
Yes.
So I'm glad that we was able
And
to talk.
hold on. So now we've got 197 documents.
Okay.
Back then we had 44.
Let me,
Okay, hold on. Those 197 page documents, those existed in January when I made my request, correct?
I cannot say that.
You don't know if they existed?
May I respond?
If you answer my question first, I'm happy to allow you however much time you want to respond.
Okay.
Did those documents exist in January? The 197 pages? Your business record certificate?
I cannot answer that question. May I explain?
Why you can't answer it?
No, let me explain why I cannot answer it. That's correct. Let me explain. Your open records request that you presented asks for certain things, right? I'm assuming that you are talking about the production of documents that you gave on August 30th, right?
Yes.
All right. And you, in that production of document, I'm assuming you're saying that that was 197. What I am saying that I cannot correspond, because it's my assertion that the open records request that you received on January 18th is different in scope from the subpoena you requested. And because there is a difference in scope, because your subpoena was more specific, I cannot tell you if the two are correlated. So I cannot answer your question.
So you can't tell me if the 197 pages that you provided on August 30th, that those existed in January?
Yes, they would have existed. The 197 pages should have existed. However, I cannot tell you, let me be very clear, that the 197 pages that you received on August 30th as a response to your subpoena was responsive and should have been included in the 44. I'm afraid that you are looking at an open records request that you received on January 18th, accepted with no reservation. You're convoluting a subpoena. There's 2 different scopes. There's 2 different, your search terms were different. So yes, the 197 did exist in January 18 because the scope in which you asked for was from January 2021 to the present, whenever the subpoena came in, right? We did that through IT. Those documents you could certify. I cannot tell you if those 197 were responsive to the 44 because your open records requests and your subpoena are different. Your subpoena is more specific.
Okay, so my open records, my first one said that I was seeking a copy of any and all correspondence to or from critical mention, copies of contracts, payments, analytics, and reports, okay? So correspondence, that's emails. Correspondence is emails.
And I gave you emails.
The 44 pages versus the 197 pages. Would you agree with me that there are a lot of emails in the 197 pages that were not contained in the 44 pages? A lot of emails. We can go through them page by page if you'd like.
If that's what you prefer.
It is not. It is definitely not.
What I am telling you, and I need to be very clear, that your subpoena that produced 197 pages, right? It required, look at this particular email to and from, right? As it relates to these particular search terms. So your subpoena was filled out and given to the Fulton County IT department, and those 197 pages were given, researched, and provided. Let's look back at your open records request. There were no search terms. If I am not mistaken, and you may have to bring it up to reflect my memory, you just wanted something about to and from the vendor or something like that. They are two different things, two different scope. So if you're making an inference of 44 versus 197, I cannot buy into that inference because I see logically why 197 and 44 could be different.
And I'm trying to break it down simply so that we can just get through one item at a time. My original open records request, we're only talking about correspondence. You and I agree correspondence includes emails, correct?
I agree.
Okay. And would you agree that the 44 pages did not contain a lot of emails that the 197 contained?
I can concede that.
Okay. The next classification is contracts. Okay, so I asked for contracts between the DA and critical mention. Okay, would you concede that the contracts I got in the 44 pages with my open records request did not contain all of the contracts I got in the 197 pages? Would you concede that?
No, I cannot concede that. You have to show me that.
Okay, that's not a problem.
You
Which
have to show
one?
me that.
So we'll break it down even further. In the 44 pages, the original request, you only gave me a contract for the first year of critical mention, correct?
Show me.
Okay, let's see. Okay, the 44 pages start at, just so everyone knows, they start at merchant 0027. And that one may take a few more minutes to get up because we didn't have that one queued. Oh yeah, 0027. And if you want a hard copy of the documents, I can give you that as well. Okay, in response to that, if you go through the next couple of pages, is it easy to pull up the next couple of pages? Yeah, let me give you the exact page. It's actually the next page, 0028. And I didn't have that one queued up, but we'll have it in a minute, sorry. Or I can just show you.
That's fine.
It's 0028. That's the February 2021 contract for critical mention. Oh, there we go.
I'm glad you said that. I'm glad you showed me this isn't a contract.
No, this is not. This is part of it, and if you go through.
You and I just had a conversation about emails. I conceded. Now you're talking about contracts. I told you to show me. Now you show me an invoice. Which is it? Do you have a contract?
Judge, I don't care if you ask me questions, but I don't really think it's appropriate if you ask me questions.
Well, I'm not, you're not obligated to answer the questions he asks you. I would just encourage everybody to try and maintain a tone of civility and let's move on.
Yes, Sean.
So, we'll back up. The 44 pages. I'm gonna give you the 44 pages, okay? So you can just look at those. We don't have to go.
Are you gonna point out the contract in 44?
Give me 1 second.
Oh, okay.
Okay, so my open records request to you asked for contracts. Okay? That was one of the classifications we just talked about, right?
Yes.
Okay. Show me where in there you gave me contracts.
I did. I don't believe it's in here. You could not show me. So do you want me to go page by page? Because you said that you was going to show me. You gave me an invoice, right?
Okay.
And then I said, all right, the 44. So now I can go through here to determine the contract. So you put, I'll do it.
So
but you said that you was going to show me.
I'm going to show you the one you gave me.
Okay, no.
But that's in the second
You were talking in the context of these 44 pages. You told this court that I gave you a contract. I said, show me. You approached me with the invoice.
You gave me that
told
invoice.
you-
Okay, stop. Both of you. The question I think is pending that will actually help us move forward is that Ms. Merchant asked if any contracts were produced in the original 44-page production.
Yes.
And while none of us will necessarily enjoy that endeavor, it is perfectly fair for a witness to say, let me review the 44 pages and then I'll answer your question. And so if you would like to do that, you feel free to do that. But the question is, was a contract produced in the initial production of 44 pages? Because I think we had agreed that contracts were requested.
Yes.
Okay, go ahead. Mr. Bond, if you want to go through the documents, or if you want Ms. Merchant to direct your attention to something, we can do that, but the 44 pages is entirely fair for you to say, let me look at these documents before I answer your question.
Yes, I would like for you to direct my attention, as you said you could.
I'm asking you to answer the question the judge just asked you that I originally asked you. That I asked you if you gave me a contract in January. We agreed that I asked for a contract, okay? So we agreed I asked for a contract. I want you to show me where you gave me a contract. Or if you didn't, tell me you didn't.
Okay, allow me to review.
Great.
This invoice. Based on what you presented to me, assuming that there are 44 pages here, no, a contract is not in this.
Okay. In the 197-page document that has your sworn certificate on it, did you provide me with a contract?
May you direct me to that contract?
I'll give you the 197 pages. It's your sworn business record certificate that you swore to the court was accurate and complete. Give me a moment to reorganize. Let's see. Would you prefer it on the screen or in person?
In person, please.
I'm going to give you one of them as an example. May I approach this?
Yes, and you don't have to ask for time.
Thank you. It's called a renewal of work. What's happening?
Ms. Merchant, I'm sorry, I can't hear you when you step away from the podium very well.
Sorry, thank you for reminding me of that.
The renewal statement of work, if this is in my file, who you are, this is a contract.
It is. Okay, so what I just showed you was the contract, one of the contracts for critical mention, correct?
You showed me a renewal statement of work.
And that was not provided in January of 2024, correct?
It does not appear to be so.
I'm going to show you another, I'm sorry.
And if I can, before I know you're about to move on,
I'm not.
we agree, right, that there were some emails, right? We also, as it relates to the contract, you said that you that there were some documents in that particular file that you have in the 197, okay? You also can agree, I hope, that on the second open records request, you brought forth, that was elevated to me, hey, Dexter Bond, I'm only missing with the analytical. So you and I can agree that any contract or anything was not in your any open records request. We can agree to that?
No, we cannot. Can you pull up Merchant 0055, please? Oh, sorry, wrong one. We just had it up, I'm sorry, 0008. I am seeking a copy of any and all, including copies of all contracts. That is my original request.
Yes, but you received this on January 18th. On January 19th, you said, you referenced this same open records request, right? And you said, I am only looking for, I received your request, you acknowledge receipt. I am looking for the analytics inside that.
I'm not talking about that yet, and we're gonna be here all day if we go and talk off track. The first open records request, this one, first one, I asked for contracts, okay? I just showed you a contract that you gave me on August 30th. That contract was not provided in response to this open records request, not a follow-up, in response to this open records request, correct?
The answer is yes, that contract was not provided in January 18th.
And here's a contract for critical mention for 2021 to 2022. Can you take a look at that?
Yes.
That contract was provided August 30th, but was not provided in response to my open records request, correct?
This statement of work appears to be provided in August 30th.
And you certified the documents that you provided August 30th. Do you have any question about them?
No, I certified the documents on August 30th, but what I need to be clear is once the matter on January 18th was not elevated to me. I think that we're clear on that. When it came to January 26th, you requested 5 things. There was one thing in your second open records request that you brought to my attention. That was elevated to me. I assumed that on the 44 pages, everything else was responsive because you do a good job when you don't get something, bringing it to our attention. We do a good job of responding to you. So yes, you asked for 5 things on January 18th. My staff gave you 44 pages. When you brought forth the second critical mention open records request, of those 5 things, you brought forth 1. That one thing was elevated to me. So we make mistakes. If I did not give you a contract on January 18th, I would have loved, as I often hear from you, to get, hey, you're missing this, just like you did on the critical mention analytics scribe. You did not bring that up.
Judge, this is not responsive to my questions. I mean, at all. Not even close to responsive.
I generally try to let the witness answer the way that the witness wants to answer. I will, however, say that I think we are getting bogged down in what previously did or didn't happen based on people's characterizations and understandings rather than, and I think one thing that would help, Ms. Merchant, is if you would ask short, clear, direct, factually based, and not argumentative questions. And then Mr. Bond will do his best to give short, concise, factually based responses that are not argumentative. Because I understand that both of you have a position that you wish to vindicate about what you did or what you think did or did not happen here, but we need to set that aside. Go ahead, Ms. Merchant.
Just asking you about my first request. We're on to the third category, payments. I asked for payments. How critical mention was paid, correct?
You asked for contracts in or payments, on January 18th.
In this open records response, did you give me payments for critical mention?
I gave you 44 documents that I believe was completely responsive to your request.
Mr. Bond, you did not give me a copy of the payments for critical mention.
And when I reviewed the 44, I did not see a payment.
And you also did not give me any analytics, correct? In response to this one, just this one.
On January 18th, no, I do not believe. When you say analytics, I don't even know what you're talking about. Are you talking about the graph that's embedded in the critical mention? I don't know what you mean by analytics. Let me make sure I'm clear.
The critical mention analytics reports.
The same analytics reports that you asked for in the second critical mention request?
Only asking you about the first one.
So no. The answer is no.
Okay.
Not in
Did you
January.
give me any of the critical mention reports in response to this request?
The answer is no.
Okay. So the 5 categories, correspondence emails, contracts, payments, analytics, and reports. You did not give me any of those 5.
I gave you 44 pages.
So now we'll move to the second request. So when I got those 44 pages and was not happy with the response, I filed a follow-up open records request. Do you agree with that?
Hang on, Ms. Merchant, to my point about argumentative, right? This is further complicated by the fact that you're also your own witness. And so your questions are not only tending to be argumentative, but filled with facts that haven't been established yet. So
Okay, and that was
on that.
And I was drawing from what you said about me.
Then reference the document. I think that'll be a cleaner way to keep the record clear. That way we know it's a fact that's in the record.
That same day, January 18th, now I'm talking about that second open records request. I followed up and asked for more documents, correct? I'm just asking if I followed up and asked for more documents.
May I answer this question this way? You pointed out the 5 categories. Thank you for doing that, okay? In your second open records request, you asked for not more, the same documents in one. To me, that was interpreted as you have satisfied my open records request, so I cannot say if you was unhappy. However, of those 5 things, there is one thing in here that you're missing. Can you respond to that one thing?
So let's talk about that second open records request. So I submitted another open records request and asked for more items, correct?
You asked on that second open records request for the analytics graphs. That was also asked for in the first open records request.
And was not provided in the first open records request.
It was not provided, well, based on my review today, no, it was not provided.
And it was also not provided in response to the second open records request.
So in the second one, a response was provided via the Open Records Act. That response on January 26th, footnote 1 reads, no, on January 26th, I don't know what subsection said, I don't, essentially, forgive me legal terms, I don't know what you're talking about. Your response, your ask is not reasonably calculated to put me, the business records custodian, in a position to know what you're talking about. At that time, I did not know what analytics graphs were. I didn't know what you were talking about. So you can reference my letter, which I addressed this second open records request personally because it was elevated to me.
I will in a minute, but let me re-ask my question.
Okay.
Did you provide me any analytics in response to my second open records request?
I provided you a response.
Did you?
In my response,
Hang on. She's asked you a yes or no question. I think you can answer it and then explain.
Yes, ma'am.
Thank you.
No, I did not give you any documents. I did give you a response. That response said, pursuant to OCGA, Open Records Act, that it is not your request, as stated, is not reasonably calculated to put me in a position to know what you are talking about.
On January 24th, I sent your office a letter talking about this open records request again, the critical mention media monitoring data. And that's at Merchant 0083. If you want to take a look at it, we'll have it up in a minute. Do you recall receiving that letter?
I recall receiving a letter from you, but I do know that that letter was not exclusively for critical mention.
That's correct.
Okay.
That's
Just
not my
making sure.
question. My question is, do you recall receiving that letter?
Yes.
Great. So let's look at what section of it talks about critical mention. I was following up, and this was asking to please not have to go into a lawsuit, right? That's what this letter was.
I don't know what this letter was, but I do recall seeing it. I don't know if it was a please not going into this lawsuit.
So it was entitled Numerous Outstanding Open Records Requests and Notice of Potential Official Complaint and Potential Civil Action. Do you recall that?
I don't recall the title, but I do recall receiving the letter.
Okay. And you recall generally the contents of the letter?
Yes.
And specifically, let's talk about the critical mention. I asked, and this is on Merchant 0083, I outlined again what I had been asking for, and provided even more context in regards to these emails, analytics, things like that. Do you remember receiving this?
I do.
Okay. And you responded, and this would be Merchant 0087 if you want to pull it up. This is the letter you referenced earlier. So this is the letter you're saying is from you, correct?
Yes.
It's not signed and it doesn't have your name on it, but you're saying that this is your letter.
Yes.
You drafted this letter?
Yes.
And
What was the page number of that? I'm sorry.
Sorry, it's Merchant 0087
Thank you.
through 88. The only name on this letter is Bonnie Willis, correct?
You have to show me that.
You can scroll. Is the only name on this letter Bonnie Willis?
Are you referring to the letterhead?
I'm referring to someone who received this letter would think it came from.
Okay, well, I'm gonna stop you there because that calls for speculation, but if you could go to the bottom of the document, maybe we could see who signed it. Thank you.
And we just talked about nobody signed it. On the next page, 8.8, you know that you did not sign it, correct?
I will have to see the second page.
You can pull up the next page, it's 8.8. Here,
I believe it was the Open Records Unit or Division or Open Records, sincerely Open Records.
Okay.
So did I sign it? No. But did I draft it? Yes. Is it from my team? Yes.
Looking at these 2 pages, the only name from your office, someone reading this would see is Bonnie Willis, correct?
You would see the only name in her letterhead. Yes. It's any correspondence, I believe, that comes from the portal, any letter is going to have her letterhead on it.
My question is just, that's the only name that's on that.
I feel like the document is what the document is. Let's move on.
Okay, thank you. This is your response that you were talking about, and just in regards to critical mention, well, actually not just in regards, let me back up for a second. This letter, you said, despite consistent communication that I was implying that you were still in violation of the open records and you disagreed with my disingenuous implication.
Because it was. Yes, I made sure that I let you know that you are disingenuous in any implication that I violated the Open Records Act was as such. That was my word choice.
Okay, so the first request, the 5 things I asked for, you didn't give me any of those 5 things, and we've established that.
When you say you,
your office.
My office gave you responsive documents on January 18th.
Right, some responsive documents with the 5 categories, and we agreed to that, 5 categories. You said, no, you didn't give me the contracts, no, you didn't give me.
When you say you, my staff gave you responsive documents, okay? We have already said that certain things get elevated to me. You received the records. When you did a second open records request for critical mention of those 5 things, as we have said, you have addressed one. That one thing was brought to my attention, and I handled that one thing. So my assumption, okay, to be clear for the record, was that the first open records request, you received everything. I did not know what was in the 44. You did not, when you brought it up the second time, you did not make mention, right, of anything outside of those 5 things. You only made mention of one. So I dealt with that one thing.
Okay, so let's go down, look at, if you can make it a little bit bigger, where he's referencing the actual numbers. So the open, yes, there we go. If you look at number 4, those 2 request number, the ones that end in 101924 and 011824, those are the 2 critical mention open records. You cite both of those, correct? All I'm asking is if you're citing those.
109244 or 44, yes, I'm citing 2.
Okay.
2 open records requests.
And we can agree those are the 2, we've already gone through the numbers for the record, those are the 2 open records in regards to critical mention, correct?
Yes.
Okay, and you said in regards to those records, you cannot produce the records we seek, correct?
I also said, as it relates to your request, those 5 things to view electronic communication, let me see, as written on January 24th, is not reasonably calculated to locate the records you seek. Can I explain why? Okay, go ahead.
Ms. Ron, I'm gonna ask you about the second question, but I was gonna ask you about the first one first, I was trying to finish that. And if we can stay on track, I will let you answer whatever you want.
Perfect.
The first line says, as such, we cannot produce the records because you do not maintain responsive records. I'm only talking about that line, okay?
Yes.
That's what that line says, right?
Yes, that's what that line says.
You wrote that line.
I wrote that line.
Okay. So when you wrote this, you were telling me that you did not maintain responsive payment records.
That's not what I'm saying. No.
You did not maintain responsive contracts.
That's not what I'm saying. No.
You did not maintain responsive analytics.
That's not what I'm saying. No.
Okay. You did not maintain responsive emails.
That's not what I'm saying. No.
Now let's go to the next one.
May I tell you what I am saying?
I assume you're saying you do not maintain responsive records.
Well, instead of assuming, why don't we let the witness do what he wants to do and tell us why?
Great.
So we said that you gave me my first critical mention open records request, right?
I'm sorry?
You gave me my first critical mention open records request that I responded to on January 18th.
No.
On this, that you got on January 18th, the first open records request, the 5 things.
That's the second one. The first one was January 9th, the second one was January 18th.
The 5 things, critical mention.
Yes.
You accepted, you received those documents, that file was closed out. The second one, we're on the same page? You said, hey, I need an analytics graph. Based on this, number 4, I am telling you, I gave you all responsive documents. In the second one, you did not bring anything else up. The only thing that you brought up was analytic drafts, to which I responded in the second sentence, I don't even know what you're talking about. So again, when you gave me the first request, I responded. When you said the second request, you brought one issue. So the first sentence is related to the first one. I gave you responsive documents. I assumed that you had everything that you needed. When you gave me the second one of those 5 things, you only brought forth one thing. That one thing is addressed in the second sentence, which says, I don't know what you're talking about. So that is how I handled number 4.
We've agreed. This request asks for 5 things, right?
For the record, you're referring to item number 4 on that
Yes.
document on the screen?
I'm referring to request that ends in 010924, the first critical mention request. That request, I asked for 5 things, correct?
Yes.
When you wrote this letter, I still had not received those 5 things. I received part of them, but not all of them.
I did not know that when I wrote that letter.
Okay.
What I did know when I wrote that letter was based on your second request for the record, last 3 digits, 824. You made mention of the first one, which only talked about analytics graphs. So I assumed the first one was complete. You had everything that you needed. The first one being last 3 digits, 924, done. The second one, 824, I assumed that was the only thing at issue. I addressed that 824 in the second sentence.
So you assumed that this was completed, but you did not know.
Let me tell you why I assumed it. The answer is yes. The reason why I assumed it is because when you brought forth 824, you referenced 924, and as you stated, there were 5 things you were looking for in 924. In 824, you only sought one thing. I would assume, I hope I'm not giving you more credit than you deserve, that if you was unhappy with 924, just like you said as it relates to 824, I'm missing analytics, you would have brought forth those things in 824. You didn't. I assumed 924 was done.
Is it possible that I believed that you had complied with 010924 and given me any existence payments, contracts, and that I believed that they clearly didn't exist because you didn't give them to me?
When it comes to
I asked if it's possible.
It's pretty argumentative, but I'm gonna let him answer. Go ahead.
Thank you, Your Honor. When it comes to you and what I think you believe, it can be anything, Ashley Merchant.
Okay, listen, everybody, we need to dial all of this back. The questions are, I feel like instead of being educated, I'm listening to an argument, and I'm tired of listening to an argument. I would like to be educated about the processes that Mr. Bond follows to perform his duties, and about what you believe, Ms. Merchant, to be the shortcomings of whatever those processes are, but I'm not getting that. I would also remind everybody that I can read quite well, and that most of what we're arguing about is reflected in written documents that are part of the record that I can review. Now, to the extent that the parties wish to understand what was meant by those words, those are fair questions. But half of our time has been spent getting people to agree that the document says this, or that the document says that. And I feel like if we would try to take off our, let's just, everybody take a deep breath, and please try not to continue to argue with one another. And that applies to both Ms. Merchant and Mr. Bond in terms of trying to answer the questions so that the court can understand what processes are followed and whether or not they were followed and should have been in this case. That's what I'm trying to figure out.
Ms.
Go ahead.
Fox, when did you first learn that I had not received things in my first request?
The first critical mention request
Yes.
on your January 24th letter. That's when I realized, no, let me be very clear. On the first request, on the January 19th email, when you had made reference to the first one, you said that I am in receipt of your records. These things are outstanding. That is when it was elevated to me, and that's when I became aware that you was missing analytic graphs from critical mention.
When did you first learn that I had not received the contracts that I requested in my first open records?
This lawsuit.
When did you first learn that I had not received the payments?
This lawsuit.
When did you first learn that I had not received the emails?
You did receive emails.
All of the emails. When did you first learn of that?
This lawsuit.
When this lawsuit was served?
No, during this preparation for this hearing.
So this lawsuit was served 7 months ago? Is that when you learned that I hadn't received any seconds?
Objection, Your Honor, was asked and answered. That question was asked and answered.
I'm gonna rule objection. I'm just trying to, I don't understand you to be making an argument, she's just trying to direct the witness' attention to a particular date. Go ahead.
When you say you learned about it when this lawsuit, was it when the lawsuit was initially filed?
No, during the preparation for this particular hearing.
So just recently?
Recently, as it relates to critical mention and the lack of compliance, as you allege, with the first open records request. Because again, I resolved that matter. And again, the second one was brought up to me. And of those 5 things, you only made issue of 1, which I responded to on January 26th.
And I'm gonna go to merchant 0011, if you want to go look at that. So this, when I got at the top to please log in and view the letter attached. That letter was from the office of the county attorney. Did you have anything to do with the drafting of that letter or this entry into the portal?
I don't know what letter you're referring to, I'm sorry.
It's at 0362 if you want to pull it. So, and just so the judge, so we can educate her for a minute, because I have the one sorry. When this says that on the portal, I get this email, and then I have to go to the portal to see the letter, right?
I take you at your word.
Okay, well, we'll let you guys do this one. All right, so this letter. This letter that was received, and you can see it's got the open records requesting against merchant 0362. This letter that comes from the office of the county attorney, it says to please log into the portal to see the letter attached. The request is being extended for research. That was sent on January, I think it's January 25th, January 25th. Did you have anything to do with this letter?
No.
And if you go to 0364, this is the next letter. This is February 7th. It says due to widespread outages, the request has been extended. Did you have anything to do with this letter?
So it's gonna be hard for me to explain. At this time, it was a cyber attack. The county attorney, because we use the same portal, gave us a template letter that we all use. So I can't make reference to this particular letter, but I do know that we, my office, had to send all requesters, including you, an update because of the cyber attack. And that letter appears to be a letter that I sent for all open records requesters at the time.
So this was sent February 7th. This was after you sent me the letter that said you didn't have your responsive documents.
I cannot speak to this particular letter. You said, look at this letter. I know that this is a template that so many people use. So I don't know if I did not send you anything on February. I don't know. That letter was sent to everyone around that same time on February saying, hey, it's a cyber attack. Things will be delayed because we have limited access. and things will need to change. As referenced earlier in our conversation about why the portal may change, and I alluded to cyber attack, this was a cyber attack. This is a general letter that wasn't just sent to you, it was sent to so many different other people because the cyber attack impacted how we handle open records and what we can do, how we can research and respond.
You can skip ahead to merchant 0167. This is a document out of your business record certificate from August 30th. Did you redact that redaction that you see in the middle of the page?
No, I did not.
You certified these records and signed a certificate and affidavit, correct?
I did sign an affidavit that is correct, assuming that this record is in the 197 that I certified.
Yes.
What's the question?
Did you certify these records as complete and accurate?
The 197?
Yes.
The answer is yes.
Yes. And you did not need this redaction, and who did?
My counsel.
Your counsel did this?
As it relates to this particular, yes, I'm pretty sure.
Miss, legal counsel for the DA's office?
No, Ms. Allaby did not do that.
So who did it?
I don't know. Let me clarify, because I'm not sure the line of question. I think that you received documents from me on my team that was redacted information. Typically, redactions are consistent. Do I do them? Yes, sometimes. Did I do them here? I don't think so, but I don't.
Before preparing for this hearing, did anyone reach out to you about the complaint we filed with the court, the open records policy?
This one, my counsel.
And you've been the open records officer this entire time, correct?
Entire time since when?
Since January of 2024.
Yes.
I'm talking about the critical mention payment. If you've agreed that we ask for invoices and payments and things like that. So I want to look at one of them. If you could pull up merchant 0371. Does this appear to be a payment voucher for the for critical mention service to be paid in 2021?
Fulton Board. I'm gonna say yes. It's not the voucher that I typically look at, but this does look like a payment voucher.
Maybe look at the next 2 pages. See if that looks more familiar.
Oh, yeah, there we go.
That looks familiar.
Mm-hmm.
And so this
Just for the record, that was a
Yes,
yes.
yes, I'm
Thanks.
so sorry.
So this document, for the record, thank you, Judge, is merchant 0372. This would be a payment for critical mention, correct?
This will be a payment voucher for critical mention, telling the county to, or informing the county that this particular payment is good to go.
Okay. And can you pull up merchant 0290? Do you recognize this document?
I have been presented to this document. Yes, yes, yes.
You've been presented this document. Do you recognize it?
Yes, yes, I'm sorry.
Did you sign this document?
Yes, that looks like my signature.
And this is the check from Fonnie Willis, DA of Fulton County.
It appears to be so, yes.
Okay. And you've never provided me this document, correct?
If it's not in my 44 pages, the answer is no.
And who maintains this checking account, this bank account? Who maintains the records?
Who maintained?
Is it a DA's office checking account?
Fonnie Willis, DA of Fulton County.
Who maintains this? You signed it. Who maintains this document, these documents, this record?
I do. No.
And so you're the one that maintains checking account statements and this payment receipt, canceled checks.
The count, I'm not sure I'm understanding the question. When you say,
checkbook. Is that?
You said what? This is
Your check, like who retains it? Who has the checkbook?
The office.
And as the records custodian, you have access to this checkbook.
Yes, I can, yes, that's correct.
What steps did you take to obtain a copy of this canceled check or bank statements to provide me to show proof of payment to critical mention?
Your first open records request, I gotta go back to it. I gave it to you as it relates to the response, and it was not elevated to you. Based on this particular lawsuit and preparation for this hearing, the steps that I took was to pull into our AMS system. Our AMS system looks like a PDX, right? Similar to what you.
Hang on, sorry. You just throw out a bunch of abbreviations. I have no idea what either of them mean. So if you could educate me, I would appreciate it.
This is the education process. Forgive me. So, standard protocol, if you're looking for payment of vouchers, I would not go to a particular check, right? I will go to, in my AMS system, my financial records, our purchasing department, to say critical mention has a vendor code. Let's say for the purposes of this conversation, vendor code 123. I will go into AMS, I will look and say vendor code 123, how much payment has been calculated. So it would look as if it's the original PDX. Before to come,
PDX is
payment voucher, I'm so sorry.
Thank you.
So vendor code critical mention 123 was paid $10,000 and paid from this particular funding line, X123. To me, based on your, not necessarily your open records question, the first one, but based in preparation for this litigation, that's what I would have done. Go to AMS to show you, hey, here is the proof of payment.
This check would not be in there, though, correct?
No, typically no. No.
Because this did not go through the county payment voucher vendor process, correct?
I cannot say that.
So my question again was, what steps did you take to obtain a copy of this check?
I did not take any steps to do this check. As I understand the subpoena issue, right? Preparation for litigation, you wanted payments and or proof of payment. My proof of payment would not have been this form. Instead, I'm trying to explain, my proof of payment was to go into a financial system to show critical mention vendor code 12345 was paid $10,000 in dispersed from the county on this particular date. That's typically my process.
Well, you didn't provide us that. We've never been provided whatever this process is you're talking about, that proof. So you've never provided us that, though, but you're saying that that exists?
If it was not in my 44 pages, no, I did not respond. I thought on the first critical records, everything was resolved. I only moved forward from that first one with one issue. So as it relates to payments on anything, I have not moved forward with that because I thought it was resolved. So to answer your question, no. Now let me be very clear. As it relates to any checks for that matter, as I understand what you were seeking for, it was proof of payment. I would have did proof of payment a different kind of way.
Would you agree that this is proof of payment?
That is one type of proof of payment. The answer is yes.
A canceled check, you would agree, is proof of payment?
I would agree that's one type of proof of payment, yes.
And we talked earlier about records retention and that you have to follow the Georgia records retention. One of those policies is for your office to maintain for 5 years all canceled checks.
If that's what I'll stipulate to, if that's what the law is, yes.
And you comply with that law?
Yes.
So you would have had a copy of this canceled check?
I would also have various, yes, the answer to your question is yes, along with other various different forms of payment. The answer is yes.
Okay, and none of those were provided to us in response to our open records request?
If it was not included on 44, the answer is no, it was not provided, as I thought it was, as I assumed they were.
I only have one other question about critical mention, and then we can move on. Do you have a critical mention account login, or have you ever had one?
No.
So you would not have access to the online portal for reports and things like that for critical mention?
No, no one would. Now we don't have critical mention on that.
Okay,
So,
you've never had that?
but no, I've never.
So if there was an open records request asking for information that someone obtained in that portal, that's not something you would ever maintain?
So I cannot say that. Critical mention is something that just like LexisNexis or something like that. I don't use my username and password often, but if there's a record, I have several different databases as the business record custodian. If I have access to it, I can pull it. So
You didn't have access to it. Right?
I can get access. I think you and I discussed as it relates to the employment manual, right? And then you made a reference, and you did very well, saying, hey, every investigators and attorneys, they have phones and text messages. You brought that up. Then I said, hey, yeah, if they have it, I can have access to it, right? So the answer to your question is yes. If there's a system as the business records custodian and pursuant to the employee manual that you introduced to this court, yes, I can have access to it.
So if someone had the critical mention software or out on their computer or their phone, and they were running reports, you would be able to access that information and provide that in response to the records request.
Not to your open records request, because on January 1st, 2024, or whenever you requested this analytics, one, I did not know what you were talking about, right? And then two, the critical mention did not exist. So no one on my staff right now can go into critical mention and provide any data because critical mention does not, we do not have critical mention. So no, I could not provide you at the time the open records received responsive documents that you see, nor can anybody else in my office. What I could do is look at, like you gave me for subpoena number 2, which is more specific to your first 2 open records requests. I can use those particular search terms, and then I can give it to the Fulton County IT department, who has the ability to reach and try to find out information, which I did, right? And then which I provided to you. I think you referenced it as the 197. So that's what I could do, but I cannot go into critical mention. Neither myself, let me be very clear, or any other employee go into critical mention to pull anything.
Right, the people who actually had access to that at the time, those are the people that would have to pull that.
So I think that you and I can agree that open records records exist at the time the open records received. We made a lot of mention here that the first critical mention open records request came in January 8th, 2024. I think you and I can agree that on January 8th, 2024, we did not have critical mention. Based on the renewals that you showed me, we did not have an existing contract. So my position is neither myself or anyone with a login. The login is irrelevant. You could not get it because at the time your open records were received in January 2024, both of them, we did not have critical mention.
The law that we agreed earlier that you have to follow says that all records created or received in the performance of duty and paid for by public funds are deemed to be public property and shall constitute a record of public acts. Would you agree that reports paid for by public funds would be a record of public acts and public property?
I cannot answer that based on the framing of your question. I'm afraid it's misleading. Can I respond? My response is critical mention is something that is a database. Maybe we can educate on critical mention. Critical mention is a system that you can, an app, as you say, and that you can go in to get stuff, right? We use it for investigative purposes, if there is for various different reasons. Because HR is under me, I use it for morale. If one of my employees do something great and someone reports to that, I want to be able to let my team know, hey, this is what we're doing in the DA's office. That's how it is being used. Now, what I need you to understand is once that system is gone, that contract is gone, I cannot maintain, preserve, the system is gone. So I hear you as it relates to your assertion, as it relates to the retention act, but I need you to understand that this app is somewhat, it's not a file that I will have in my office that I will have to maintain with the retention act. Am I clear on that?
Yes, you have to actually actively want to maintain it to maintain it. You have to print it and actively do something to try and maintain it, right?
If you have to want to,
you have to, It's an app, and if you want the reports to be retained, you have to download them, or you have to print them. You have to somehow do some act to make them be retained, correct?
I can go with that particular argument if there's but you have to also understand, just like any private company, and I think that you've seen in one of those emails, the 197 emails, that they're always saying, hey, look what critical mention can do. Hey, look what, so it's one of those things that I don't think that I'll just show my age a little bit. As it relates to, I'm not going to an app, Instagram, to print to retain. It's not one of those systems. I think that the court needs to be educated on what kind of system it is if you're going to implicate or try to infer that we was responsible for maintaining anything in that database under the Retention Act. I'm not gonna let you make that correlation.
But you were never the person who actually went in and did the reports and stuff. That was other folks. That wasn't your job.
Oh, I have staff that can do things like that. I don't.
Okay, and the people that had the records would be Jeff DeSantis, Fonnie Willis, and Robin Bryant.
No, that's not true.
Who else had passwords to critical?
Jeff DeSantis had a password. I do remember, I recall Robin, who's no longer with our office, had a password. I believe that password was sent to someone else. But I can assure you right now that District Attorney Fonnie Willis did not have a password. She can't work a printer. So that's not her. That's not her gift. She's blessed at a lot of things, but she would not have a password for that.
That's undisputably not you, and definitely Jeff DeSantis does.
Yeah, I would think that Jeff DeSantis would have a password, and undisputably not me, and undisputably not District Attorney Fonnie Willis.
I'm gonna move on to the confidentiality agreements.
Okay.
So we have another open records request, and we've got it up ready for you. It's at merchant 0345. Would you agree that on January 9th, I requested any and all documents that employees, staff, or independent contractors, and I include agreements, are required to sign regarding speaking to the media and/or confidentiality? Would you agree that I made that request?
January 9th, 2024, yes, you did make that request.
And that request was clear and concise, correct?
Not necessarily concise, and I can explain why, but based on this reading, I understand. I understand the open records request. My interpretation of this was that she was looking for statements to exclude people from talking to the media.
It clearly says confidentiality on this document, is that correct?
It does, yes.
So would you agree that that was clear and concise as far as confidentiality agreements?
As it relates to speaking to the media and or confidentiality, just looking at this, I would agree that this is clear and concise, just looking at this.
And it was submitted through the Fulton County Open Records Portal?
That's correct.
And it was received, it shows it was received the same day, January 9th. That's the return with the tracking number, so that's proof that it was received, correct?
That is proof that it was received by our office and we acknowledged it via the Open Records Act, yes.
And then on January 18th, it looks like I got a response that said to please allow for 10 business days for a response, correct?
That's pretty standard, yes.
So would you agree that within the 3 days of my filing this open records request, I did not get anything that said whether responsive records exist, correct?
Based on this, you got an acknowledgement of we received it and you got an R. So I don't know outside of this, and I would have to agree with you that you did not receive whether or not responsive records exist in that 3 days time. So I would agree with you.
Okay. And I didn't get anything that says when they will be made available or whether they will be made available, correct?
If you could scroll down, I can tell you exactly what you did receive.
Oh, no, go back up to the proposed. Yeah, that's it.
And if you go down to.
I asked within 3 days, so you can definitely.
So for January 9th, this is what you received. Thank you for submitting your open records request. Here's your tracking number. Here's your description of records.
So, and going up on January 18th, that's when I received a response that said, please allow 10 business days, correct?
That's when you received a response through the portal. I do know that you and I, as well as my staff, exchange emails. I cannot tell you if you received a response anywhere between January 9th and January 18th. But just off this record, you received a response on January 18th. Please allow 10 business days for a response.
And while you mentioned that, your staff would email me for clarification if they thought anything was confusing, right?
My staff is instructed to, if you get an open records request and it's simple, go ahead and handle it, right? And I think you and I can agree on what is simple. My staff also knows we have routine checkups when anything that's elevated come to me and let's discuss. I do have competent people on my staff who sometimes will reach out to people to ask for clarification. I do have that.
And so the letter that was attached, if you can go down to the next page, it's merchant 0346. That's the letter that I received in response, correct?
Once your request has been reviewed, this is a pretty standard letter. I would say that you received that.
Okay. And so this was received 9 days after I made the open records request, correct?
If this letter is consistent with the January 18th, the answer is yes.
And this is from your office, right?
It is from and signed Open Records, although, as you can see in the headline, who it is, but you know it's from Open Records. You do know that, right?
I'm trying to differentiate between the county attorney's office, which we've received some letters, and your office. This is from your office, correct?
Yes, because it has my office's letterhead.
Yeah, if I could ask for a point of clarification on that, there was another letter we saw earlier, it's the one that related to the cyber attack, that it appeared to be on Ms. Miller's letterhead. The signature line said Open Records Team.
Yes.
Is that distinct from your signature line of Open Records?
Yes, and let me explain. And this is what I was trying to get to. The county attorney decided, hey, everybody that's involved in the portal need to use this standard letter for cyber attack. So that particular letter, as it relates to cyber attack, we were supposed to go and say to all our requesters, he is a cyber attack.
Right, no, that's fair. But actually my question is broader than that. It's not about that particular letter. It's about, is Ms. Miller and her Open Records team the same as Mr. Bond and his Open Records?
The answer is no.
Thank you. Okay, go ahead.
And so after I received this letter, let's see, is this, can you scroll down a second? Is this 46? Yes, okay. I followed up with a letter, the letter that we talked about earlier, the January 24th letter. I sent that to your office.
The January 24th letter came. At that time, like you said, there were several different things that was elevated to me because at this time, this wasn't elevated to me. It was interpreted to me at that time of that letter that you wanted any documents that prevented staff or independent contractors from speaking to the media.
Okay. Let's, if you can scroll. Maybe on the next page. And this is the same, that's the same follow-up letter though that I included. I included essentially all of my requests, correct? The ones that were outstanding.
It's more than 12, so I don't know if you said all. Earlier you said it'd be surprised 12, you remember? This looks like more than 12, so I don't know if it's all. That's something that you can clear up for the record. You remember I said 40, you said 12, this looked like in between. So I can't tell you if it's all.
Number 5 on here, if you look at the top, is about confidentiality or non-disclosure agreements, correct?
Yes.
And here again, I'm asking for confidentiality agreements.
Yes, I would agree. I would also say, let's look at the context. Let's read it. It says, district attorney required to sign regarding speaking to the media. To your point, and or confidentiality. So yes, I said signing, speaking to the media, to which I responded. Let's be very clear. You go on. I had no responsive records to any of my staff speaking to the media. That's how I responded.
Can you pull up the employee manual page again? Page, the employee manual, 0602. The employee manual actually contains provision that, if we can get it up here for you, but it actually has a provision about talking to the media, correct?
No employee is permitted to talk to the media. I believe, I'm referencing this.
And that's in the employee manual, though, correct?
It should be, you can show me, but I'm almost certain, because no employee should be talking to the media.
So if you interpreted that request to mean you can't talk to the media, you didn't provide this in response, though, correct?
This wouldn't be responsive to you asked for, let's go back to your open records request, because the two like minds were different. We learned that in law school, right? Look at your open records request. You're looking for agreements signed by staff. This is an employee manual that says you are not to speak to the media. In my professional opinion, based on my years of experience, the employee manual will not be responsive to your request. So the answer to your question is no, I didn't provide it.
And so in that letter, you didn't provide the confidentiality agreements, you didn't provide any of those, correct?
No, you're right about that. Now, I did not provide confidentiality agreements. The way that was presented to me was the media. I knew I did not have responsive records after talking to counsel, right? Let's be very clear. In your subpoena.
No. I'm not asking anything about the subpoena. I don't want to confuse the issues.
Gotcha.
I'm only talking about the open records.
Okay.
We are still in January.
I got you. So as it relates to open records, I interpret this as you do not talk to the media, to which I responded, you're right. I do not have responsive documents as it relates to making my employees sign an agreement that says you cannot talk to the media.
You put,
And that happened in January, that is correct.
just put his letter back up, 0345. I'm sorry, Mike, yeah. So go back up to the open records request, the actual wording. So I asked for documents, agreements, contracts, memos, or any written documents and that anyone's been required to sign regarding confidentiality.
So
It says media and confidentiality, so hold on.
I agree with you.
So in response to this, you did not provide any confidentiality agreements, correct?
The answer is agree to sign, so you know our employees don't have to sign employee manual. So we know that. So we know that that's not responsive. As it relates to the media, I'm agreeing with you, right? You asked for, I interpret this in my staff, you wanted media agreements. I responded and said, I do not have responsive documents, right? After this particular litigation in preparation for this hearing, at that moment, it was confidentiality agreements, right? And at that moment, I believe as we sit here before, they have been provided to you.
So they were provided me 2 days ago, correct?
I cannot tell you when it was provided to you, but I do know that you have them because once I've been informed, hey, this, if I can, this particular has been a moving target. The first one, not perfect. I interpreted it as media. Once I said it's media, it's non-responsive. Later on, it was interpreted as, forgive me, Jeff DeSantis made comments to the media saying that these agreements were destroyed. To which I said, I don't have any responsive records. And then at that moment, it then turned to this most recent, I think, subpoena was just pure confidentiality agreements. So yes, I agree. You narrowed it down to confidentiality agreements and you got confidentiality agreements. My interpretation is that on the onset was media. Based on context that you provided, hey, the DA's office had some stuff, they destroyed some stuff, which I did not have that. And now confidentiality agreements I have. If I have it, you have it. There's no.
In January, in response to my open records,
any confidentiality agreements.
you did not give me any confidentiality agreements. In your letter in January, when we said we're going to have to file a lawsuit to get these if you don't give them to us, you responded. You do not maintain responsive records and cannot produce the records we seek, correct?
That is exactly because I thought that the scope of that was the media. You're absolutely right.
And you actually provided a custodian affidavit with a confidentiality agreement signed by Nathan Wade in his divorce proceeding, correct?
Have to show me.
His, Nathan Wade's, or his business records. Is that? If you don't remember that, I'll get it for you.
As a business record custodian of 1,000 files per year, I don't remember that particular one, but.
It's merchant 0610.
Yes.
That's a business record certificate. Can you put my original open records request back up?
Not via the open record side, yeah.
I'm sorry?
Context you provided, you're going to the open record side. I am not scoped to the open record side. I'm saying context that you provided, because you did provide it.
Right,
But
well,
I'm
we're
not-
gonna put it up. And you can show me where.
But I'm telling you, it's not in the Open Records Act. In one of
So
your,
there's no context in this. Is that what you're saying?
only context is required to sign regarding speaking to the media.
And there's nothing in my letter where I said, if you don't give me these, we're gonna have to file a suit. There's nothing, it provided anything different than this, correct?
That's not true. Not, in that letter on January 24th,
In regards to the confidentiality.
I do not believe that, but there's been emails, right? No.
I'm sorry?
On January 24th, you did not make any mention, you did not provide additional context as it relates to the speaking to the media on January 24th.
Okay. So when we had to file the lawsuit, the open records case here, you had not provided any confidentiality agreements in response to this original open records request.
The answer is
correct?
no, as I thought that your request was limited to the media, so no, I did not have that.
Would you agree that the 22 documents that were provided recently, within the past week, would be responsive clearly to this request?
I agree, it is, as it relates to confidentiality, if it was presented to me as, hey, this, we're looking for media and or confidentiality, I would have gave you those, but again, I interpreted let me take responsibility, I interpreted it as a NDA, a non-disclosure. I discussed that because I interpreted it as a not to speak to the media.
And in regards to this confidentiality request, did you perform any searches in response to this open records request?
This is an example of, I will go to my investigative team. Do these exist?
So in response to this, you went to your investigator team and asked if any of them existed?
Not in response to this, let's be very clear.
What did you do in response to this?
I interpret this as the media. I know that as a business record custodian, as a deputy of operations, I know that we do not have any requests related to employees, any signed forms saying that you cannot speak to the media. I know that to be certain. So I did not do anything as it relates to this open records request based on my interpretation, and my interpretation is because required signing regarding speaking to the media. So let me be very clear. For that open records request, I did not do anything because I read it as required signing regarding speaking to the media.
But you personally thought this was elevated to you for some reason?
This was elevated to me, and when it was elevated to me, it was presented to Mrs. Merchant want media statements. Do they exist? No, they do not exist. To which I responded to your open records request, they do not exist.
Were all of my records requests after January 18th, were all of those elevated to you?
No, I don't. You have, again, we disagree on the number. We know there's a lot. If you have asked for my office back from September, a lot of standard things, all of which we responded to in a timely manner. I hope you can agree to that. So I don't see all of your requests.
Did you sign a confidentiality agreement?
No,
You've
I don't
never
think
signed, you've never signed one?
I don't think so.
You don't remember?
I don't remember, I don't think so. I do not think so.
Do you believe that only 22 employees of the district attorney's office have been required to sign a confidentiality agreement?
I don't have no belief, I don't have a position in that. I know my staff, I could speak for my staff, no. And what I think I gave you were,
I'm sorry, you think you gave me?
No, I can speak for me, I don't believe I signed one. I know that my staff, my direct reports, they have not signed one.
Your direct reports have not?
As it relates to my direct team, I did not administer, I did not facilitate the signing of those particular documents. So I cannot speak to that.
So at this point, the 22 that we've received, I heard testimony of 150 lawyers, 300 or something staff. Is it your testimony that in response, and we now don't have any semantics confusion, right? Like it's confidentiality agreement. Is it your testimony that only 22 confidentiality agreements exist from Fonnie Willis as a district attorney's term?
Based on my research and based on me asking around about confidentiality agreements, I provided that.
All right, let's talk about your research then.
Okay.
What did you do to respond to this request?
Security team, do we sign confidentiality agreements? This is executive assistant, do you have confidentiality agreements? Chief of staff, do we have confidentiality agreements? Oh, we do? Who? Why? Okay, get these, let me give these to the council. So that is a standard, when you get a request, hey, I'm looking for confidentiality agreements. I think that you can respect the fact that, hey, do we have them? Do we have them? Let me show due diligence. Do you have them? Do we do them? Do we have them?
So you did not do that in January, you did that recently?
That's correct, because in January, as I stated, I thought it was limited to the media. I know media doesn't exist, so I did not very clearly do it in January. I did not.
And in response, you asked the security team, the executive administration, and the chief of staff if they had any of these non-disclosure.
Hey, remind me, these was maybe done 4 years ago. Is this something we did? Do we have them? Who have them? Are they made? So yes.
What I'm trying to understand is if you're saying, swearing under oath, that 22 are the only 22 that exist.
I cannot tell you that.
You're
I can tell you.
custodian, right, for this office?
So I can tell you what I did. When I got this, when counsel presented to me and said, hey, media, let's go, instead of looking at it from a narrow scope for media, let's look at it from a confidentiality agreement. Dexter Bond, as the business record custodian, what did you do? And I'm answering the question as what do I do? Now you are looking at my efforts at what I did, and you're trying to conclude that my efforts yielded to a totality result. And I cannot confirm that. I can tell you what I did in good faith.
Did you send out an email to all staff saying, who has signed a confidentiality agreement? Please respond.
I didn't do that. No.
Did you send it out to all supervisors?
No.
Did you send it out to all attorneys?
No.
Did you send it out to anybody?
I'm not sure if I sent the email. I don't know. I made some calls, and I had my team make the call, so I don't know. But I know only a handful of people can do all DA. I can tell you that right now, so I know that.
You can now, right?
You said what?
You can.
Oh.
So if you wanted to, you could send that out.
If I wanted to, I wouldn't have. Yeah, if I wanted to.
So,
But also, if I wanted to, yes, let me tell you why I wouldn't though. I think you can respect that I get probably 500 to 1,000, maybe 1,500 emails a day. There's no way that I would have sent an all-day email and I would have had to transport, hey, put this in this portal, so I would not have done that.
So how did you get the 22 that you gave us?
I think I answered that question. I told you I called the chief. I answered that question.
As to how you got them, like literally how you got them.
I believe it was scanned to me.
Who
It was
scanned
provided
it?
and scanned to me. Kendall. I signed this.
I'm sorry?
I assigned it to someone.
Oh, who did you assign it to?
Probably my team. Hey, I need to do this. Can you take the steps? In a staff meeting, I cannot tell you who specifically did it. And I made some calls. That's why I know I had an email. Do we have this? Do they exist? Is this familiar? And that's what I did.
So you asked some staff, and you don't know who that staff person is, to make some calls to see if these exist.
So when we're in a staff meeting on Tuesdays, right, I have several different people that sit around the room, right? And then I would say, hey, these are outstanding issues. This is my elevation time. Like, if there's an issue, let's elevate this. And hey, you need these things for open records. Hey, can you take the lead on this? Take the lead on this. Take the lead on this. Report back to me on Thursday as it relates to what we did, how we did. In the meantime, I'll make some calls to figure out where we are. So that's my routine practice on open records.
And that request was done roughly within the last 2 weeks?
Oh yeah, that fairly recently, because again, when I first got the request, I thought it was related to the media. As my astute counsel said, hey, let's look at confidentiality agreement and let's make it a little more broad. I followed those instructions and I did, and I told you what I did.
Is there any way that I could have been more specific without using the terms actual confidentiality and agreement?
If I could, to be honest with you, no. Now, because this was elevated to me, I wish that this was a request that I would have read myself. and not allow it to be paraphrased to me, because I thought that this was required regarding speaking to the media. I blamed it, okay, speaking to the media, and then I went ahead and said, hey, listen, I don't have it.
I'm sorry, who paraphrased this to you? I thought this one was elevated to you.
When it gets elevated, it's a series of things that get elevated. Hey, these are things I look. There are certain times that I'll look and I'll read. I don't know what you're talking about. Let me read this. There are other times where it's just like, I'm looking for X. I will briefly look at it. Oh, okay, let's go. So I just want to be the elevation process. Let's educate. On Tuesday, we sit around the room. We have open records conversations among many things. Once that happened, if there's an elevation process, it was, hey, here are 15 open records items that we have. Do we have this? Do we need this? Is this an exception? Do I need counsel? Do I need to research? Do I need to redact? That's how it happens. Some of which are, hey, do we have media non-disclosure agreements prevent staff from media? That's a paraphrase. Or, hey, this person is asking for such and citing the law and such and stuff. I don't. Those are ones where I'm like, hold on, wait. So I want to be very clear.
I want to be very clear too, because I'm a little confused now. So if it gets elevated to you, that's when you talk about it in these meetings? But otherwise you don't?
If it's a standard invoice, I thought I answered that. If it's a standard invoice or something simple, it doesn't get elevated to me. It gets handled by my staff.
Okay, so only elevated ones get talked about in this meeting?
In this meeting, or hey, Dexter, I need you to look at this. I need you to weigh into this. Yes, it needs to be brought to my attention. But if you're looking for something as you have, a specific contract, if you're looking for something specific and it is clear, it cannot be interpreted any differently, then yes. Well, my staff has full reign.
So you don't personally review the request when it's elevated? It can be paraphrased?
There are times where if I have a 20 open records request that needs my attention, there are some that I can go through. I will take a quick gander. There are others that will require me to, hey, I need to make a call. I need to do something. I need some consulting. It's hard for me to tell you there's one way to handle 1,000 open records requests in a year.
And other than Erica, who you've mentioned, who else is on this team?
It depends. For example, if it's a big redaction project, I have to add someone. If it's a media project, I have to. So it varies based on staffing levels, workloads, and actually what I need to do.
Well, I don't want to blame the point, but you were saying that some unknown staff, you can't identify who it is that would paraphrase this. Who else is
No. Okay. As it relates, I have one designated open records person, right? That what she has the authority to elevate. As it relates to handling matters, then I, because she's the only person, have the authority to say, based on the totality of circumstances, I need you to handle this redaction.
Okay.
I need you to look into this particular exemption. I need to. So let's be very clear. I got one person that open records is all they do. But as you know, sometimes redactions, exemptions, interpretations, those things can be out.
I want to try and get through the last couple areas. The next request I made, and this is at Merchant 034 in case we need to look at it, was for, I specifically said, I am seeking personnel records. That's the first.
I would have to look at that open records.
No,
Oh, okay.
it's Merchant, for the record, Merchant 0340. On January 8th, I said, I am seeking personnel records. And then I said, I'm requesting a list of attorneys with their names and date of hired by the district attorney since Ms. Willis became district attorney. And again, I stated, including the date of hire. This request was clear and concise, correct?
No.
It was not.
No. I'm seeking personnel records. I think you and I agree. What personnel records? That's a little overbroad and stuff. Then as it relates to the second part, I'm requesting a list of all attorneys with hiring dates, hired by Ms. Willis, the district attorney, Bonnie T. Willis, and to which I responded. So the first sentence, I'm seeking personnel records. I didn't know.
You didn't know what?
Personnel records, that part right there. I'm answering your question, was it clear and concise? The answer is no. Based on the first sentence, I'm seeking personnel records. The second sentence, you say that you need three things. A list of attorneys. Those attorneys need to have a hiring date, and that hiring date needs to be hired by Bonnie T. Willis. That's what you're seeking. To which I responded, I don't have responsive records.
So if you did not think that this was clear, did you reach out to me for clarification?
No, and I won't reach out to you.
and I think we agree it wasn't responded to within 3 days. I don't know.
I didn't agree to that. I'm telling you right now that I responded to that open records request and I said I don't have responsive records.
I was asking if we agreed to that, because I know Ms. Monroe was looking to see if she.
Right, but in fairness, the witness
Yes,
didn't
I know, and I was trying to finish that.
the conversation we had before. Ms. Monroe, did you ever have it? I know we decided to go ahead and get started, and it seems like it's a good thing that we did. Do you have any insight as to whether there can be a stipulation about whether whether the responses that are at issue in this litigation, the requests that are at issue in this litigation were responded to within 3 days?
Okay, so the forfeiture, the request regarding the forfeiture report, that request was submitted on January 18th, and a response was sent for an extension on that same day for 5 days. And then a letter, I'm sorry. And then a response was given back January 28th. So there was a response within the 3 days. It was just for an extension, but not for provision of records.
Okay. So y'all can educate me to the extent you need to, but my understanding is that a request for an extension of time to locate documents can suffice sometimes, but at some point there has to be production of documents within the requested time period, right? So if it's give me a document, within 3 days you have to acknowledge the request and say, here you go, or we need more time to find it, which is okay, but then if you say we need 5 days to find it, you have to give it to them within that time you said for it to be timely.
Right.
Have we followed that trail and determined if we can agree that records either were or were not provided within either the 3 days or the time period requested by the DA's office to comply?
Okay, so as it pertains to the forfeiture reports, documents were not provided within the 3 days.
Okay.
And then ultimately it determined that there were no responsive records. And then in terms of the requests regarding rebranding, promotional materials, that was not in 3 days. And in terms of, there were also no responsive records for that. And in terms of the list of hirees, which she's talking about right now, so that was actually responded to timely, but not with records, but with a response saying no responsive records. So we had the response that was submitted on the 8th, and then on the 9th, a letter, which is the following day, a letter was sent saying that we need 7 to 10 business days to accommodate your request, something to that effect. I don't have a letter in front of me, don't quote me please. And then on the 18th, which is within that 10-day period, there was a letter saying that no responsive records that was sent to the requester.
Okay.
So out of the, sorry, I only gave, how many did I do? 1, 2, 3. And for the final one, the NDAs, the request regarding NDAs, that was not responded to timely, and nor were any responsive records provided within the portal under that request.
Okay, thank you.
You're welcome.
Thank you. Okay, so this was filed January 8th, this record, and the response was lodged January 9th that said you were in receipt of the records and to allow 7 to 10 days for research. Would you agree that the response within 3 days did not say whether or not responsive records exist, correct?
I would agree with that, but it did consistent, as I read, the Open Records Act lets you know what time frame, based on staffing levels and workloads that I'm gonna be able to provide you, and it reads 7 to 10 business days, I need to do research.
And it doesn't say whether documents will be made available.
On the next day that you gave me this document, I could not make that determination. I needed to do research, so I outlined how long I needed to do research on 24 hours. Was it 24 hours? Yeah, about about 25 hours after you received that. I acknowledged your receipt and I told you I need more time.
And then on January 18th, you responded that no responsive records exist, correct?
Let's see, January 9th, I told you 7 to 10 business days. Within 7 to 10 business days, I said, hey, we don't have any responsive records.
So that's correct?
That is correct.
And we're still referring to the personnel records request, is that correct?
Yes. Okay, thank you. What efforts specifically did you do to actually locate these records?
Talk to my HR team, and I know for certain because HR reports to me that I do not have a list of attorneys, 1, hired by District Attorney Fonnie Willis, 2, with their hiring dates. Those are 3 variables that you wanted. I know for certain that I don't have that.
What searches were performed?
I talked to my HR team, and then at that point, I know that I do not have a list of all attorneys hired by the District Attorney Fonnie T. Willis with the hiring date.
And you also then received, after this, so this was on January 18th, I filed a letter on January 24th, again, asking for these documents. You received that letter, correct?
I do. And again, that particular letter had several different open records requests that was outstanding. Can't remember the number. I know it was more than 12. And I think I told you the same thing I told you on the 18th, that there are no responsive records because as I sit here today, I don't have any responsive records.
My question was, you received a letter from me January 24th where I asked for these again, correct? Did you receive a letter January 24th?
Yes.
Where I asked for these again?
I don't know if you asked for them again. I received the letter on January 24th. As we already said, that letter had several different open records requests. Yes, this is probably included in the letter of more than 12 open records requests that I addressed from your January 24th letter.
Give us a minute. Hold on. I have a hard copy. It's 0080. For the record, it's 0080 through 0085. Just give you my copy.
Thank you.
Take a look and tell me if that refreshes your memory.
January 24th letter, I'm assuming, so direct me, you're talking about section 3?
Section 3.
Yes.
So I again clarified, asking if this meant that she had not hired any attorneys or that you just were claiming that you didn't have a list. Okay. Is that correct? Did you receive this?
I did receive this.
Okay. And before we move on, how many number requests are in this letter? You can look at the last one, they're Roman numerals.
Hold on, wait. Well, look at this number 1. You see how many is in here? So how do you want me to handle it?
So each are one request. So if you want to look and see how many requests.
Sorry, Ms. Merchant, I can't hear you.
I'm sorry, here, I'll take it back and go and ask her.
Okay, go ahead.
Sorry, I forgot. All right, isn't it true that we go up to Roman numeral number 10 in this document? There are 10 requests in this document.
Ma'am, look at number 9. That is 2 requests in 9. So you cannot correlate Roman numerals to requests.
2 requests in number 9?
Look at 3, 4. I'm sorry, don't know Roman numerals.
Objection, I'm sorry. I understand that counsel is trying to get to the contents of the letter. At this point, I don't see the relevance in having the witness count the number of requests in the letter, so if we could just get to it.
Just per the argument has been that it's burdensome, that I requested 40 we started with. There's 10. One of them I had to duplicate because it was closed without being responsive. There's 10.
Your letter, I can read your letter.
Okay.
I know how to count and read, right? And so there's no point in arguing about it.
You responded to that letter and said nothing exists,
In
correct?
this letter, you presented 10 Roman numerals that dealt with a lot of different requests that was outstanding, but you so commonly forget that we have had several different open records requests outside of this particular letter, dating from September. So this letter only deals with open records that was outstanding. Each Roman numeral deals with various different requests. Let's be clear.
My question was, if you've sent a letter in response to this.
You asked me that 3 times. The answer is yes. You received it on January 26th.
And it said that you do not retain records and cannot produce.
And I told you that 3 times because as I sit here, I do not have records. I do not have a list of hires from attorneys with the date of hire that was hired by District Attorney Willis. I told you that on the 26th in response to the open records request. I told you that now. And I told you that previously.
One point of clarification, because you've said the same thing several times, and you're putting emphasis on a particular part that I'm curious about. Call it the rule of judge's interest. But I understand, and I think I started this hearing with this discussion about sometimes we know things that don't exist in a document. But you keep saying I don't have a list of attorneys with their hire date who were hired by Attorney Fonnie Willis, the DA Fonnie Willis. Weren't all the attorneys in the DA's office hired by Fonnie Willis?
Oh, no. Where's the DA that was hired by District Attorney Paul Howard?
Well, I'm certain they have worked for the DA's office for a long, long time. But didn't she decide to hire them when she became the DA? And I'm not challenging you. I'm just asking to make sure I understand if there is or is not a distinction.
I see that. Yeah, I can see that.
Okay, fair enough. I mean, but at least I understand better why you were drawing that distinction.
Mm-hmm. Okay. Well, I was drawing that distinction because that's what she asked for.
Okay.
And
No,
I got you.
I wasn't challenging what it said. You were placing emphasis on it in a way that to me seemed to inform how you understood the request. And now I have a better understanding of how you understood the request.
Thank you.
Okay.
Thank you, Your Honor. I will say this, based on this particular request, what I have done is to reach out to the Chief Human Resources of the county to see if I had a list of, hey, here are the list of attorneys hired by District Attorney Willis with their hiring date. And I can tell you right now, as I sit here, I don't have that.
When did you reach out and make that request?
Doing it to the county HR in the course of this litigation.
Okay. So not when I filed the open records request.
I didn't have to at that time because I know I didn't exist. So the answer to your question is no, I didn't feel the need to reach out at that time.
But then in response to the litigation, you did feel the need to reach out and actually ask the question?
Well, once litigation is, I'm like, okay, what can we do to resolve this matter? Is there anything extra? Let me do, I feel comfortable. Let's be very clear. Under the Open Records Act, I did what exactly is required to be a law.
Turn the papers in, man. Stop playing.
Anything possible else that I can do. I did that extra, and guess what? The records still don't exist.
My dude.
I know we already verified that as the open records officer, you were charged with maintaining records under the State Records Management Act, correct? We already talked.
He's triggered.
He's very
early
triggered.
on. That's part of your job.
The Office of the Fulton County District Attorneys seeks to maintain records and consistent with the State Retention Act. Yes.
And that act requires that your office maintain records documenting an employee's work history, case file, including the date they were hired, and if there's no hire decision. And you have to keep those records for 50 years or 7 years following the date of separation of the employee.
Years.
And you're mandated to actually keep them in your own office.
And Doug, thank you again.
To a central agency.
So you read the retention law that I have not read, but I can tell you this. You started the sentence saying as it relates to personnel files. So you said case file date, right? In your open records request, you're looking for a list. I'm afraid you're misleading the court because you're convoluting a retention record that discusses personnel files, but you're seeking via the Open Records Act a list. Those are two different things. So let's not put the list into State Retention Act. They're two different things.
Did you have personnel files?
Go ahead.
Did you have personnel files?
Did I or do I? Yes.
Both. Did you?
Yes.
And you did?
Yes.
And do those include the date that someone was hired?
Yes. The personnel file should have the date that they was hired. The answer is yes. Do I have a list? No. I don't have a list. And if you think that it is reasonable for me to go look at find out who was hired by the DA, pull that HR file, scan that HR file to make a list, I don't think that the Open Records Act requires me to do so. So as I sit here, no, I don't have it, and I told you what I did.
Did you have a question? No. Okay, sorry. Thank you. Your office also produces newsletters with lists of all of the employees of your office, is that correct?
Office morale, yes. We have bi-weekly newsletters, winter reports, we have quite a few.
And it's got something called a directory of
Just look.
attorneys?
Yes, that's the director.
Okay. And so someone has to get this data somewhere with this list of attorneys, right?
She got him over a barrel.
Unfortunately, my graphics does report to me. I don't know if they got a list of that, but I can tell you. Can I take a look at it again?
Sure.
All right.
She got
While
him
you're
over a
looking at
barrel.
that, I need to do a sort of check-in with my attorneys. I understood that the court reporter had made arrangements to be available until 5. Mr. Bowman had indicated he had an issue. Do we need to adjourn? Can we carry on in your absence for an hour? Can you stay? Where are we on that, Mr. Bowman?
Yeah, I can push it for a few more minutes, but I mean.
Uh-oh. What happened?
What happened?
I don't know. All right, Mr. Bowman, we got brought up on RICO charges.
I heard they found Rico earlier.
Yeah, they had RICO.
Oh, there it is.
So,
Oh, he's back.
that's all.
I didn't do it. He's
I
back.
think we're comfortable concluding
Oh, it's
5-5.
So we're just going to continue on at 5 and understood that if you need to go
blurry, though.
for your prior issue, then you're free to leave and you don't need to ask my permission, by the way.
Thank you very much.
Okay. Thank you for the interruption. While we were doing that, the witness had an opportunity to look at whatever it was that you were showing him. I saw it, but I don't know that it was ever identified for the record. I
Oh, I'm
apologize.
sorry, Judge.
Oh, Adrian Love right there.
What is base stamp? It's exhibit 8. It's merchant 0303, and it goes until 0336.
Thank you.
Let me know when if that refreshes your memory.
I have reviewed this directory. I don't understand the relevance, so I'm pretty sure you'll educate me. So, yeah.
This directory is published by your office, correct?
Yes.
And it contains.
Can you repeat that? I'm sorry, I couldn't hear you.
Sorry. This is a directory published by the district attorney's office, correct?
Yes.
And it contains a directory, which is a list of district attorneys, essentially.
This looks like my supervisor too.
That,
So district attorneys, supervisors, yes.
okay. And you guys publish these pretty regularly. The district attorney's office publishes these regularly.
When you say publish, yes, I print out, I hand out, yes. I've learned that staff like to see their faces places, so yes.
And in this, you welcome new hires?
I'm pretty sure that there's a version of, hey, we have some new hires.
And someone gives that data to whomever makes this brochure with new hires, correct?
Yes.
Why couldn't you
So you're
get
able
that?
to give a list of new hires to the promotional people?
I
She
did
got
not say I gave a list, ma'am.
Someone's able to give that data in some form, whatever form it's in, to this people.
We have new student orientation. They can be sitting there typing in the graphics saying, new hire Dexter Vaughn. So if you're telling me that a list exists, I'm telling you it does not. If you are trying to say that a list of attorneys hired by Fonnie T. Willis with the hiring date, which I don't see here, exists, I'm letting you know right now that it doesn't exist. I don't know what correlation you have, but I see your directory, I see it. I see this supervisory, just not a list of all attorneys, I see it.
Your office pays attorneys Bardu's, correct?
Bardu's? Yes.
She ain't playing. She is not playing games with you.
So that's interesting. Do I pay for the training to go to the class? Typically, most cases, but you know, the $12 that you have to go to the bar to say that you have the 13 credits, and then a bar, here's the $12.50 to make your account for the bar, I do not pay that.
Nobody said you
That's
paid
a
that.
particular way of explaining it, but I have several different staff members who want.
He doing
both
the most.
payments, and I really want.
Let me see if I can drill down on this for a moment. I don't think there's any dispute that the district attorney's office knows what attorneys work for it and probably knows somewhere when those attorneys were hired. Is that fair?
That's it.
Ms. Merchant?
I would assume so.
Okay.
That's what she's asking.
As I understand, the disagreement here is that the DA's office understood you to be asking for a list. I think I've seen something indicating their position and some case law that says they're not required to create a record in order to respond. And so I understand that you're trying to inquire about where other lists might exist, but I do want to be clear that you're not suggesting that the defendants should have produced the personnel records of every employee that worked, for every attorney that worked for the DA in response. You were asking for a list, correct?
Yes, well, and so understanding open records and normally, so purchasing, finance, all of those divisions, when I ask for an open records, if there's some confusion about this, they talk to me.
I understand all that. The only thing I'm trying to drill down on here is that you continue to ask questions about things that clearly indicate the DA knows who works for the DA.
Right.
I don't think that's really an issue. I understand you might be trying to get list adjacent. But I want to be clear that you're not saying they should have given you the personnel files. What you're trying to get to is you think there are things that might be a list that they could have produced. Is that correct?
Definitely.
Okay.
When I work with the public defender, there's a list.
That's what she's
for
saying.
workers. There's a list for CLE.
Thank you.
That's what I'm asking for. Yes. The same with these lists, have existed. They have to exist to pay borrowers and things like that. So that's exactly what I'm asking. All right. So the next area was what I would consider rebranding and promotional materials. On January 17th, 2024, I requested, and this is at Merchant 0025, for the record. In that request, I requested any communications or correspondence between purchasing and the DA's office. And some of this was resolved and did not result in the lawsuit, but number two, the promotional materials. I requested any payments, requests for payments, hiring bids, paying vendors, promotional material, including promotional brochures, flyers, or mailers. Like this, promotional material. Can we agree this is promotional material?
What about, no, because no, that is promotional.
Okay, for the record, you're holding up something.
Sorry,
Can you say what it is?
So sorry.
That's okay.
I am holding up what was Merchant 0303, the front page of the Fulton County District Attorney's Office Winter Report 2024.
Well, help me to understand, and maybe I'm not trying to disagree
Ooh,
with you.
come
I'm
on.
not trying to belabor the report, but what am I promoting in there? Why would that be promotional material? Promotional material to me is, our REACH program, helping the youth. Let's promote that. Our records restriction
Promoting
program.
Bonnie's
flyers.
face.
Let's, those are things that could be considered promotional materials. I don't know. I wouldn't consider that promotional material. I don't know what you're looking at.
Okay, so you considered REACH to be promotional material. Did you provide me that in response to this open records?
No, because you said in this particular open records request, any payment request process for hiring, bids, payment vendors, promotional material include. So no, I did not.
Rebranding. So when you walk in the district attorney's office and there's new new advertisement type things, did you provide me any of that?
No, I don't know, because I do not even know what rebranding is. And for the record, remember, we just had a conversation about promotional material. As it relates to this open record request, you can agree. It's just like our first one, right? It's 5 different things. Of those 5 things, I responded. I think you told the court some of this has always been resolved because some of this did not come in. You said that's what you testified to the court. Hey, some of this stuff did not make it to litigation.
Great.
All right. So we also know once I gave you those responsive records, moved on. It was closed. So I gave you what I had as it relates to that. So if I did not give it to you when I responded to you, no, I did not give it to you.
Would you agree that this request was submitted on January 17th through the Fulton County Open Records portal?
It appears to be so, yes.
And it appears also that the request was received the same day?
It looks like I gave you a tracking number, and it was the 17th. That's impressive for my staff, so yes, kudos.
And it didn't say that whether or not responsive records exist or if they would be made available or anything like that, correct?
Well, on the same day, no, I certainly didn't think that you were going to get a response on the same day. So it was acknowledgement of receipt, a description of your records, and a tracking number for you to find your record.
Then on January 25th, you put a response in the portal that says to review attached letter and that the request had been extended for research. Is that correct?
It does appear that that is the letter that I gave you in January, dated January 26th, I believe. And it looks like I needed to do some research. So I agree with what's being presented to me.
What efforts specifically did you do to locate these records?
Well, I think that as it relates to these particular records, I gave you, number one, I guess this starts with 5. This is why things are difficult, right? You gave me 5 things. I responded to some. So as it relates to those particular records, I researched, retrieved records, and gave you records.
You believe you gave me records in response to this?
As it relates, you gave me 5 things in this open records request. Let's go through the first one, right? As it relates to number 1, I think that you told this honorable court that some of these matters have been resolved, right? I gave you those records for number 1. We can agree to that. Is that fair? As it relates to number 2.
No, it's not. I received number 1 in regards to a subpoena in a criminal case from the county attorney's office. I did not receive that from you in regards to the records request. So.
Okay, we're gonna have to disagree. That's not court.
So let's go through this then. This document, 0025. The only response you sent was on January 25th, where it says, please log into the portal to review the attached record. It's been extended, correct?
Let's look at that letter. Yes.
It's, if you can scroll up a little, it's higher up. There we go. Okay. And then the letter that we're referencing is that same letter that you gave us earlier. It's at Merchant 0087.
That deals with a whole lot of open
Yes.
records requests.
Yes.
So let's go to that letter.
And that's
Let's look at 011724.
It's 0087.
00. Okay.
And you wrote, in regards to this request specifically, that this office does not maintain responsive records and cannot produce the records I seek.
Show me.
It's number 5.
Number 5. So that's 01924. Right? Number 5, 0119.
Oh, so the request
you're
should
changing
go.
it. I'm confused.
So the original request is, oh, you go to the next page then. It's 011724.
Zero zero one seven. Okay, you can direct me.
It's number 8. Yes. Number 8.
If that is 011724 related to promotional material rebranding, that's how I responded. Number 8. Yes.
So you never provided any records in regards to this response?
I cannot say that because that is not my contention. You asserted to this honorable court when you started looking at this open records request that this 5 things, some of them have been resolved and there is no longer in this litigation. So I cannot tell you 1, 2, 3, 4, 5 what I didn't do. I will take you at your word to say that some of those things, 1, 2, 3, 4, 5, was provided to you. So I'm not willing to say I gave you nothing when you have said, hey, I looked at it, some of this stuff has been resolved.
Do you have any knowledge as to how some of this stuff was resolved?
Objection, Your Honor. So it's my understanding that as it pertains to this request, that the only issue at hand was regarding the rebranding materials regarding rebranding and promotional materials. So
And the critical mention payment.
Okay. So
Have a seat. Have a seat, baby. Go
tell
have a seat.
me, Ms. Merchant, why in response to Ms. Monroe's objection, why if some of these documents have been provided to you at some point, in some manner, through some method, why is it relevant today that they were or were not produced in response to an open records request that you served or provided to the state?
It's not at all, but he said that part of this was responded to, that he responded to part of it, and that's not accurate. They did not, the open records people did not respond to any of that. It has been made moot
outside of that in a separate litigation, so I didn't include it in the lawsuit. But he is very literal with these words, and so I was trying to, like, that one request is not an issue. It's trying to save time by taking that request out. But then the witness has now said, well, then we complied with it, and they have not actually ever complied with that. So that's not accurate.
Okay.
There you go.
Again, I think we're getting bogged down in semantics. The fact that the information and data or documents that were sought by plaintiffs at various points through their open records requests have now at some point been provided to them is not the same question as were they produced in response to this Open Records Act request, and if so, when? And so to the extent that's the conversation we're trying to have, that's allowable. And with that clarification, please go ahead.
Thank you. And I'm trying to be clear. So in regards to this request, what did you do to actually locate any records?
Received that particular open record request. I went through it. I cannot tell you if this particular request was elevated to me. I do know that I do not know what rebranding is. I do not know that I do not know what promotional material is. I do know that I responded to that. I cannot speak generally about this, specifically about this open records request, but I would have done to this request what I have done in all.
Did you ask for any clarification if you did not understand what the term promotional material or rebranding meant?
I will not, I've said this to the record and I'm gonna repeat this again. I'm not having a private conversation with you, Ms. Ashley Merchant. So no, I would not contact you. I am not going to email you. I am not going to talk to you to look at any clarification. I find you to be extremely disingenuous, so I won't talk to you. And clarifications don't require me to reach out to you. What it does for the open records request is require you to put me in a reasonably calculated situation to give you what you have. But let's be clear. If you think that I'm gonna reach out to you and talk to you, I'm not.
The fourth request, critical mention, any payments, requests for payments, bids, or paying of critical mention. Did you do anything in regards to that request?
So we talked about critical mention.
Because I had to ask for it a third time. And so in regards to the third request, where I asked for the same check that we now have gotten from critical mention, but not from you, did you do anything?
So I'm going to repeat this for the third time. Wow. Critical mention came in on January 8th. On January 18th, I gave you 44 pages. On January 19th, you renewed the request. Again, the first request had 5 different things. On January 19th, you only elevated one thing. I assumed on January 18th, you got everything. Because when you don't have something, you elevated that one issue. I then worked to work on that one issue that was elevated. So to answer your question for the third time, no, I did not give you anything on January 18th. I assumed that the records was responsive and they were complete.
You gave no records in response to this request? None.
According to number 8, I said the Office of the Fulton County District Attorney in its normal course of business does not maintain responsive records. As such, we cannot produce the records you seek. Number 8.
I asked you what you did to locate the records to give me that answer. Mm-hmm. Who did you ask for records, if anybody, to give me that answer?
Let's go back.
Who did you ask, if anybody?
I have to see the request. This request was 5 different things. So if you, again, 1,000 requests, right? What we have discovered right here is all your requests came in from September and a lot came in January, right? So in this particular January, I have to go back to it to tell you what I did on these 5 open records requests. So if you can put those things back on the court, I can tell you.
Well, I'm not asking about 5, I'm asking about number 8. It's open records, number 8. That's the only one I'm asking about.
Gotcha. So we can agree that number 8 corresponds to your open records request. Your open records request seeks 5 things. If you can put those 5 things on the screen, I can answer your question as to relate what I did for 1, 2, 3, 4, 5. Okay. I can make 2 easy. As it relates to branding and promotional, I don't even know what you're talking about. So I told you, let's move on.
Merchant 0025.
Stop. You know what rebranding is. Stop.
If you all are interested, I dropped one of those promotional links in the chat. If you want to see what some of the things that they spend money on, it's pretty interesting. Here it is right here again. This is for 2022.
All right, here it is.
Number 1, outside counsel. That was
I'm not asking you about that, so we can move on. I haven't asked you about that.
Okay.
But in regards to number 2, I know you said you don't know what promotional material means, but what, if anything, did you do in response to try to find responsive documents for this?
Can I tell you what I did specifically? That's a conversation with staff, because my POV may be limited. What are promotional materials? I don't know. So I don't know what I did specifically. I don't know what, but what I did do is say that I do not have any process for hiring and bids for paying vendors for promotional material. I don't have that.
Number 3, rebranding. Any payments, requests for payments, process for hiring bids and paying vendors for rebranding material. Did you do anything in response to this request?
As a person, as a COO of the office, I know about bidding, and I know that there is no hiring or bids related to period. To certain things. And then as it relates to rebranding specifically, I don't know what that is.
Did you do anything in regards to this request?
I reviewed it, I accepted it, and consistent with the Open Records Act, I gave you a tracking number and I responded to it. So yes, me or my staff did something to this.
Did you do any searches or request any records in regards to this?
As it relates, I'm gonna say yes. You don't want to talk about number 1, but I'm pretty sure that I did a search because you have those responsive records. As it relates to number 2, promotional material, I told you I do not have process on hiring bids. It doesn't require me to do research on that. As a COO of the office, I know the answer to that question. As it relates to rebranding, I think the court and I can all agree, right, that this particular matter, I don't know what that is. As it relates to critical mention, I have discussed several times what my position is as it relates to critical mention. And as it relates to TDI, I did respond. There is no responsive records to that. So did I do something? Yes, I responded in compliance with the Open Records Act. That's what I did.
So my question was, what did you actually do to locate the records? Did you perform any searches?
There were no searches to perform outside of number 1. So I'm pretty sure I did a search for number 1. As it relates to number 2, there's no search because there's no process for hiring bids for promotional material.
So tell us what you did in regards to number 1 then, since you brought it up.
What I would do with any payments, because you requested a lot of payments, right? In previous open records, you requested a lot of contracts. That is something that I can pull as it relates to EMS and provide to you.
So in regards to number 1, can you tell us what you did?
Again, Your Honor, this is outside of the scope of what open record requests are at contention here. If we could just focus on the open records requests or the materials that are missing and that have not been provided.
Judge, I think that you deserve an answer though, that nothing was done.
Hang on. I'm gonna save you the time and trouble of making that argument and say, I agree with you that what he provided in response to this request isn't relevant, but the process that he followed, the effort that he made to respond to it versus others, or in a similar way as he made, as a process he followed to respond to others, I think is relevant. And so I'm gonna let him answer the question. Your objections are ruled.
Repeat the question, please.
In regards to request number 1, outside counsel requested a payment, request for payment, process for hiring bids, paying outside counsel, including the reference retraining, which was discussed during the Board of County Commissioners meeting in November 2023. You'll remember you appeared in front of them. There was a big discussion about this. What did you do in response to that open records, number 1?
I cannot recall specifically. I cannot recall.
Do you recall if you did anything in regards to this?
I can speak generally what I would have done. I cannot recall specifically as it relates to this request.
So how can you tell us that it's been fulfilled then if you don't know what you did?
Because as it relates to outside counsel, I cannot specifically tell you what I've done. Generally, for payments, I would have looked to see if there are any outside vendors, which you have asked me for via open records request, and I have supplied to you responsive records to this. So I don't know how to answer your question, and I cannot specifically talk about tracking number 11724.
What did you do to search for information about the retraining that was required during the Board of County Commissioners meeting? And you remember attending the Board of County Commissioners meeting in November 2023?
I do.
And you remember there was a big discussion about the DA's budget for things, printing, promotional material, things like that.
That's not how it was reframed, but I do remember that I was present and I represented the office at that BOC hearing.
And the purchasing department had some concerns because you had quite a few outstanding debts or payments.
What department?
Purchasing.
Purchasing.
Sorry, had concerns about all the spending for promotional material.
That's a mischaracterization of the purchasing department.
Okay, I don't want to get down into the weeds of what, because also there's an official record of what went down at the BFC meeting on whatever day, and if it ever becomes relevant, I can find it and listen to it and know what was said. So let's go.
Yes, okay, what is relevant is what did you do in regards to when I asked for the communication that was referenced at that meeting? Purchasing said they had gotten with you on retraining your office about purchasing. I asked for that communication, it was referenced during that meeting. What did you do to find that?
That particular training was done by me and the CFO. It was a conversation between me and her. So there is no documents related to that particular training. It was done via Zoom. So that's how, again, I cannot tell you specifically what I did with this open records request. If the conversation is about this particular training, I can tell you what it was. I can tell you that your statement of the purchase department is mischaracterized, and I can tell you that there are no records related because that happened via Zoom and we had a conversation about how to proceed forward.
So you did nothing in regards to looking for correspondence about that, setting up that Zoom or anything like that?
I know I would not set up the Zoom, so no.
Let's move on to the forfeiture reports. So on January 16th, this is at merchant 0019. January 16th, I requested reports and itemization for all property and funds obtained through forfeiture.
If you can, don't recall the characterization of that open records request. If you can allow me to see it, I will definitely bring you up to speed. Yes, familiar.
And this was submitted through the open records portal.
Yes, it appears it was submitted January 16th. Good job, staff. They responded. They gave you a tracking number on January 16th.
And the response for the request was clear and concise, correct?
Actually, no, it was not.
So you didn't understand what I was requesting here?
No, I didn't. And I communicated that to you.
You communicated that. How did you do that?
January 26th letter.
You communicated that you didn't understand what I was requesting?
If you can pull up the January 26th letter, I can reference what you're saying.
Sure. The base.
You have a physical copy of that letter you can give the witness for reference to the amount that having to stop and pull it up each time is. Thank you.
Thank you.
So before you go any further, is this the first time you responded to me in regards to this forfeiture request?
No.
Okay, well, you said that what I was asking for was not clear and concise.
That's correct. So, and I told you that, and you gave me this letter, and I'm about to tell you what I communicated. Is that fair?
So you're gonna tell me where you told me it was not clear and concise?
Yes. You want me to tell you?
That'd be wonderful.
Let's look at the letter January 26th. I'm gonna direct your eyes to footnote number 1. Footnote number 1 reads, we believe, emphasis on we believe, you are seeking the office's equitable sharing agreement and certificate. These records were filed in accordance with law, state and federal law. And I want you to, let's go back up to number 6, because you're talking about 011624. I say to you, responsive records are attached. So in this particular letter dated January 26th, I respond to your open records request number 6. I let you know that these records are attached. I give you a footnote, and that footnote lets you know we believe. And if I can, don't want to talk too much, but let me tell you why I believe what I believed. You want me to go there?
No, I mean, if there's something that's relevant to this, but I mean, this is the only response that you're saying you have, right?
For number 1, yes, as it relates to the office's equitable sharing agreement and what I believe that you're looking for, and I can tell you what I did to give you that.
Oh, okay, yes, that would be my next question. Well, that's jumping ahead. Give me one minute to get there. So this response, this one that you sent, and I don't have the date. You've got my copy. It was sent, I believe, January 26th, correct?
Yes, January 26th.
Okay. Can you pull up merchant 0018? So after that, on January 28th, we received something that says apologize for the delay. So after we received this letter, there was an apology for the delay and said that it was still pending.
I'm looking at, what date, January 28th?
January 28th.
January 28th, it reads, this correspondence in response to our response, we apologize for have additional time needed to fulfill your request. January 28th, yes, it does appear that if I can, on January 29th, it says all responsive documents were emailed to you on January 26th, 2024.
So I'm trying to take it one step at a time.
Understood.
My question is, on January 28th, 2 days after your letter, there was an open records response that said they apologized, that they needed more time, and that it was still pending, correct?
That is correct.
So
it appears to be, yes.
All right. Then after that, on January 29th, I received another response that said responsive documents were emailed to me.
On January 29th, and then it says it was emailed to you on January 26th prior. If I met, that was on about where the cyber attack was. So in an effort to communicate to my staff, to all requesters, including you and 1,000 others, we wanted to make sure that everyone has a response that things have changed. So to me, you got a letter on January 18th. I responded to you via email on January 26th. My staff went around this time, hey, let me tell everybody that there is going to be a delay because I don't know what's going on with the cyber attack. On January 29th, it was all responsive documents were mailed to you on January 26th. So I want to clear up that.
Yes, that's where I was trying to get at. So at that point, all you had given me was the equitable sharing summary, and you were saying that's all you had. That's all the responsive documents, correct?
Based on your open records request, that was all all the documents. That's correct.
What efforts specifically did you do to locate the records I requested?
That was, I didn't know what you were talking about, but you said that this was filed with the county and local government authority. So because it was filed with the county and local government authority, I called the clerk. I said, hey, clerk, is there anything related to this particular account that I particularly filed?
So hold on, so you contacted the clerk in regards to this response?
Yeah, I contacted the clerk.
That's the clerk of court?
Clerk of BOC, I'm so sorry.
That's okay.
The clerk of who?
Board of Commission. You said that I had filed with the Fulton County, a local governing authority. So because I'm taking you at your word, if this is something that I had filed with them, I called the clerk of the Board of Commission, I'm so sorry, to say, hey, is there something that I filed with the clerk of the commission?
So when did you do that? When did you contact the clerk?
Probably any time between January 24th and January 26th when I responded to your letter, because I had to get the copy to provide to you on the January 26th letter.
And you spoke with the actual clerk?
I don't recall.
Was it by phone or was it by email?
Can't remember.
Did you use a county phone?
I can't remember.
Were you in your office when you made that call?
I can't remember.
Was it a woman or a man?
Your Honor, objection. The answer was to check with the clerk. That should be it. What is the relevance of the gender of the clerk? This is irrelevant.
It's argumentative.
Okay.
I understand what you're trying to do about what, maybe refresh his memory about who he spoke to, but you've made your point. Let's move on.
I'm trying to find out who it is so I can ask them if they spoke. That's the only way I can ask that. But I'll move on. So you talked with someone at the clerk and they said they don't have anything in regards to forfeitures?
That's not what they said. I said, hey, based on your request, right?
Mm-hmm.
You said that you can we pull up your request so we can read it verbatim?
What's up?
Okay, sorry, glasses off. Can we go down? I'm sorry. It says reports and itemizations that were required by law to be submitted to the county as a local governing authority, showing what was done with all property and funds obtained through forfeiture, including but not limited to reports showing the funds went and who was paid out of funds. That's what you did. What did I do? I called the clerk of court. I said, is there a report, clerk of commission, I'm sorry, clerk of board of commission. Is there something that I file that deals with property and or funds related to forfeiture? They gave me the equitable sharing agreement. I gave it to you in footnote 1. I said, we believe you are seeking the office's equitable sharing agreement and certificate. These records were filed. Again, I say responsive records are attached.
Who gave you the equitable sharing agreement?
I can't remember. I know who I called. I don't know who responded. I don't know, but I recognize that this was something that was filed with the local government authority. It dealt with property. It dealt with forfeiture. I sent it to you free of charge. I do know that.
And did they send it to you by email?
I can't remember.
Were any other searches performed?
No, because at the time I gave you exactly what you was looking for. You looked for reports and itemization filed with the local government authority. I called the county. I said, is there anything filed with this property and seizure? They said it's the equitable sharing agreement. Oh, here we are, responsive. Here you are, free of charge. Item number 6, address closed. So no other searches.
You did no other searches?
No.
So you didn't obtain the document that you filed, that you also had to file, talking about, the equitable sharing is the federal one. There's also a state one for state forfeiture funds. Did you file it? Did you search for anything in regards to that?
You educated me. Say it one more time.
There's a federal forfeiture law and a state forfeiture law. You have to file reports for both.
Did you say that in the open records request?
Did I tell you that you had to file reports for both?
No. You're distinguishing state versus federal, right?
Now, you said you gave me the equitable sharing. Equitable sharing is a federal Department of Justice document. There's also a PAC document for forfeiture. 2 different funds, 2 different tracking.
Received.
Did you give me anything about the state tracking?
No.
You gave me the federal equitable funding.
Because that's what you asked for. You said, give me the documents that was submitted to the county, Fulton County, as the local government authority.
They're both submitted to the county. My question is, you gave me the ones, the federal forms. Did you do any searches for the state forms that you are required to do for the county?
No, I did not. What I did do was call the clerk. The clerk said, I have a forfeiture account based, your open record says local government authority showing what was done with property and funds to forfeiture. It makes no mention of the distinction that you're drawing today. What you're drawing today is completely different. What I did say is say, hey, I have a point of reference, local government authority. Let me call the local government authority. They say, I do have something through forfeiture. I get it. It's responsive. I say in my footnote, we believe you're seeking this.
Okay, my question is, did you any searches looking for the state documents? Any searches?
No.
Okay, can you pull up merchant 0571?
But why would I? No, the answer is no. And I would not have done that because you said filed with the county. So why would I then say, hey, I filed with this county, but maybe she wants to look for the state? I do not. You and I don't think alike, clearly.
Let's back up for a second. The federal forfeiture statute requires you to do a document called equitable sharing.
This news to me.
You file it every year as part of your document.
Objection, Your Honor. I'm sorry, assuming facts is not in the evidence and is also
It's in evidence.
Ms. Marshall,
very,
let her give her objection.
yes, that is my objection.
I'm sorry, because of the crosstalk, I understood. Is your objection, facts not in evidence? Is that your objection?
It's not well, it assumes a fact that is not yet in evidence, that he filed this every year.
Okay, so, I don't really think there's a dispute that the DA's office actually files this document every year because they do, but.
But whether or not he filed it every year.
I was gonna agree with you, right? That whether he has any knowledge of the DA's office's compliance and requirement to do so, I have no idea. But what I am gonna back up to is I think you've asked, and he's answered multiple times, what effort he made to comply with that request. And I think his testimony is that he reached out to the clerk of the Board of Commissioners, and they shared with him information about this equitable sharing agreement. He believed that was responsive to your request, and so he identified it, produced it to you, and that was the end of what he believed was his response. That's what I understand to be the testimony at this point. And let's move on from here.
You look at the merchant 0571, is that your name on the front of the document?
Court, educate me, this document is what? What is this?
All I asked is that your name on the document?
I see two names. Yes, Dexter Bond is on it. Dexter Q Bond is on it. Yes.
And it lists you as a deputy district attorney operations division, correct?
Yes, but the email associated is Natalie Zellner, last name spelled wrong, so. Okay.
Yes. Have you ever seen this document before?
Counsel has presented this to me,
The county attorney?
my counsel.
Okay.
Ms. Merchant, can you tell me why it matters if he's seen that document before?
Yes, because he said this is one of the documents I was asking for. And he's seen it, he filed it.
Hang on. You're asking him if he's seen it and if he filed it.
Yes, so
Okay.
first I'm trying to identify.
Now I understand why, that's all I asked, that's why you're asking, because you believe that document was responsive to your original Open Records Act request and he did not provide it.
Yes.
Is that fair?
Yes.
Okay, go ahead, Mr. Bond.
So, in your astute research, it appears that you show 3 different forms, right? In those 3 different forms, each year, there was a different file, right? So we do know the first year that you received, my name is not on it, okay? The second year,
I haven't asked for that either.
my name is not on it.
Hang on. Sorry, I apologize. She didn't start it with the word objection, but that's what she's doing, is objecting to your answer, so I'm gonna deal with her objection before you continue your response. Yes, ma'am.
It's not responsive. I didn't ask about all those other ones. He didn't have his name on them, so they're not relevant. If we can go through those, we can, but I'm asking about the one that he signed as an example, that this would be responsive, and it doesn't even have anybody else's name on it. So I wasn't gonna go through all those other ones.
Okay, so let me back up. Are we still talking about the document that's on the screen?
Yes.
Okay, you just said he signed it. I don't, Mr. Bond.
Sorry, I'm so sorry.
Let's be clear about what representations we're making. His name appears on this document that, at least to my eye, appears to be electronically generated. So ask him factually based questions about his involvement in that document and its creation, and then we'll be good.
That's what I did, and he was referring to the other 3 documents.
And in fairness, I agree with you, and I've asked you multiple times, Mr. Bond, when she asks you a question, please answer the question she's asking, and then feel free to explain if you choose to do so.
Understood, Your Honor.
Now, let's back up, Ms. Merchant, and ask your question again.
The document that we're looking at, is this something that you file electronically as part of your job?
The answer is no.
No. Do you have anything to do with this document?
Not this document, the answer is no.
Do you have anything to do with the filing of let's see what they call them, the Civil Forfeiture Procedure Act documents?
We're not producing this document, the answer is no.
I'm sorry?
You said, do I have anything?
To do with the filing of these? These are filed with the
The
state.
answer is no.
So you do not participate in these documents being produced?
No.
So someone else would have submitted it under your name?
I cannot tell you what someone else did. I can tell you, and forgive me, I am going to go on a slight tangent, but I never signed my name Dexter Q Bond. And 2, my name isn't signed here. It is typewritten, and I would think that whoever is the signer would have that corresponding email address. That name, Dexter Q Bond, is something I don't go by, okay? As it relates to Natalie Zellner, that is misspelled, that last name is misspelled, and that email address, I would assume if it was an electronic file, I don't do this, it will go back to that particular email. But any indication that I was involved, I can tell you vehemently I was not. And then I can tell you as it relates to a type name that I did not sign, I do not type my name as Dexter Q Bond.
So you've never seen this document before?
I did not say that. I told you counsel has provided me the document.
That's what I meant, before that. Have you ever seen it before counsel provided?
No, I haven't seen that. Because it appears, based on what you said, it was submitted to the state and it's submitted electronically. So that's what it appears. But again, I don't sign it. And what I do know, based on research, and as you know, that in 3 different of these state filings were filed by different employees, none of whom are me.
I'd like to ask a clarification question. So it says Deputy District Attorney Operations Division, and I think I understood your title is Deputy District Attorney of Operations, is that right?
Yes, that's right.
Okay, so even though you might not have done it, is it the job of the Operations Division of the District Attorney's Office to do these reports?
So, I don't know, let me explain. I was presented with 3. The first one was done by a game unit. The second one was done by a forfeiture unit. This one was done by, well, I don't know who it was done by, but my name was on it.
Okay.
So let's be very clear. I would not say based on what you provided counsel, 1, 2, and 3, and based on who in my office did this state electronic input, and it needs to be clear that some of those people are no longer in the office, so I cannot verify, but I don't know.
So is it fair to say that this document does exist within your office?
I would say yes. But it's also fair to say that this document is in response to your open records request.
So it does exist. Did you do anything to search for this document?
Not this particular document, no. Why? Because you asked for documents filed with the county. I called the county. I got the equitable sharing agreement. The equitable sharing agreement deals with the substance of your request. I gave you that free of charge, and I sent it to you on January 26th in the email. So no, I did not do anything looking for the state, because you did not ask for the state. You asked for the local government authority, Fulton County. That's what I did, and that's what the Open Records Act requires.
And just to be clear, my request was what the county you had to actually do, what the law actually required.
That's not what your request is.
We can pull my.
Hey, the request is what the request is. Again, I can read, and I've seen the request multiple times.
Yes. So, if you had sent an email out asking for documents that the county required to be filed, would you have gotten this in response?
If you asked me a hypothetical, if I would have did what, I would have got
You
what?
searched for this document. I'm trying to figure out, and I don't know, you gotta understand, I don't know how the DA maintains documents. These are documents that have to be maintained. So if you had done a search for it, or you had asked people for it, would you have been able to obtain this document?
Objection, Your Honor. This question has been asked over and over and answered over and over. I'd like to move on, if we can, please.
Actually, I disagree with you. I think this is actually a new question, which is where would this document exist if you had searched for it? Would you have found it? And that is a different question than whether he created it or was involved in its
I
creation.
misheard the question.
That's okay. Thank you.
If I received the open records request looking for this, yes, I would have been able to go to a forfeiture deputy or a gang based on how it was filed in the past. But again, this record is not responsive to your open records request.
Do you, as a matter of practice, as the open records officer, do you use email to request open records?
It depends.
So it's not a general practice?
It depends on what you're asking for. If it's something, again, if it's something for a standard invoice, like you have sent to me several times, on staff meeting, I would say, hey, make sure you get this, put this in the portal. So I cannot tell you, it depends on what you're looking for.
So you sometimes do it oral?
Yeah, sometimes I do it orally, sometimes I do it, yeah.
If you sent emails asking for it, would you have those?
If I send emails asking for it, what is it? What are you talking about?
The records requests.
Seriously.
Yes, if I would send email, but sometimes I will have, the emails would exist, if that's your question. Sometimes I would say orally. Sometimes I have my, someone else, hey, shoot this email to so-and-so to make sure, call so-and-so. So I don't, without you being specific, it's hard for me to answer your question because with 1,000 open records requests, there's no one set way onto how to meet my constituents' needs.
And I asked if you use email to request records, and then I asked if you sent, you said sometimes, or depends. If you did use email, my question is, would you have those emails and know exactly what you asked for?
If I, Dexter Bond, sent the email, yes, the email will be on the on my email, my archive, my system.
And so you could provide that to the court so that we would know exactly what you did in response to this request, right?
These requests, you're starting general, then you get into specific. I cannot follow your question, so I don't know. I told you several times, I don't know what I did on this specific request. You're taking what me saying general, and then you're saying, oh, well, you did do these. That's a correlation that you can't make, ma'am.
My question again was
Good.
if you used emails.
If I did do
For
email
record requests.
for a specific record request,
If you used emails for a record request, we would be able to get those and see those, correct?
you will be able to request those, and yes, they will be there. If you're asking, do I delete emails, the answer is no. So yes, they're there.
All you gotta
I
do is
send
say
emails,
yes,
my emails
man.
are there.
Just say yes or no.
Did you ask for any of these specific documents that we've talked about here today by email?
He's not going to admit to anything.
We talked about a lot of different documents, so it's gonna be very difficult for me to say yes or no. Okay? We talked about the equitable sharing agreement specifically. I told you that there was no, I don't know if I sent the email. I told you that. So the framing your question doesn't allow me to answer.
Did you ask for any of these specific documents that we've discussed today by email?
As it relates to critical mention,
Did you ask for any of the documents we discussed today? by email?
I understand what she's saying.
maybe. I don't know.
Is your use of the phone or in person to request documents on purpose?
On purpose?
Yes.
I don't understand your question. What you mean on purpose?
Do you purposely ask for things orally or in person?
No.
On purpose?
Do I do that on? I don't know. No. The answer is no. That I don't do anything on purpose.
Have you been instructed not to put things in writing by email?
No.
Have you been instructed not to put things in writing, period?
By whom? No.
Anyone?
No.
What is the office policy on the use of email and putting things in writing?
I don't understand the question.
Objection, Your Honor. So I'm trying to determine what the relevance is in terms of emails and the protocol for emails in the district attorney's office. What is the relevance here?
I think there's a tiny universe of requesting open records documents for purposes of his compliance. So I'm gonna sustain your objection partially and ask you to reframe that question because I don't know that the general policy of the DA's office regarding email is relevant here. Mr. Bond's understanding of any policy regarding Open Records Act requests by email is relevant. Go ahead.
Thank you, Bill,
Does
for
the
the
Open
$5
Records Act
super chat.
requirements or, disclosure, does that guide yours or your office's policy on putting things in writing?
Does the Open Records Act guide you? The answer is, I don't understand the question. Does the Open Records Act guide I don't even know if there's a policy. So you're making an inference that I cannot, you're assuming a premise there, right? And then you're asking a question. You need to simplify your question. What are you asking? Because you're asking me, does the Open Records Act influence your policy? You have yet to ask me, is there a policy? What are you asking? Ask me what you're asking. That's a convoluted question that I can't answer.
I first asked you, what is the policy on the use of email?
For open records requests.
For open records.
The policy for email, use your email. And there's no policy. Look at the employee manual. You gave it to me that I don't know where you're getting at. I'm not familiar with the specific policy on use your emails this way because of open records. If you're drawing a correlation to two, forgive me, I don't understand. But there's no policy on emails as it relates to the Open Records Act. There are two entities that are different. So educate me on the correlation.
I had just asked you if there was a policy. So I think that's the first step. If there's any policy on the use of emails in regards to the Open Records Act, not to put things in writing.
And I answered that question.
If there's no policy, is that your answer? Because I didn't get it. I'm sorry. I mean, you asked me to rephrase it and then said it was confusing, but.
It's still confusing because you're rephrasing it the same way. What I'm telling you is there is no policy as it relates to emails as it relates to Open Records Act, right? Do you want to talk about Open Records Act? Do you want to talk individuals? What are you asking? But I'm answering your question as it's being framed. It's being framed poorly, so you're getting a poor answer.
Can we take just a couple minutes break?
Very couple of minutes.
Okay.
She said very couple minutes.
Do you have water, Mr. Collins?
I'm sorry.
Do you have something to drink or anything? It's been there for a long time.
I know it has been a long time.
Here, this is actually an open bottle of water.
I appreciate it. Thank you so much.
All right, so woo, has been spicy. It has been spicy today.
Thank you.
So move my face. There we go. That's kind of cool. All right, it's been spicy. What do y'all think about this? Woo, goodness gracious. I am not impressed with this man at all. Good night. Good gracious. This is a mess. He is the male version of him. Absolutely. I've not met an easygoing person out of the Fulton County DA's office. Why they always seem combative?
Sorry, Judge, but I think everything gets picked up, so.
I don't blame you. I'm consistently advising people when Zoom is on, the microphones are there, so.
Okay, almost done.
All right, here we go.
In response to the subpoena to come here today, did you search for any emails?
Okay. Did I search? I sent your search terms because your subpoena to me was asked for to and from emails. It gave search terms. I believe there was 2 search terms, critical mention and social media monitoring. So what I did do is fill out a ticket, as I do with most requests. I sent that over to the IT department based on what you're seeking. Were there any responsive documents?
Hold on, so if you needed to request something from IT, you fill out a ticket for that?
If you give me search terms, so there's 2 different ways, right?
Okay.
So let's say you're looking for documents. And if your document is, hey, give me anything for critical mention, I can then do, hey, do you have these emails? Does this make sense? That's one way to do it, right? Your open records request originally, don't need to be belabor the point, didn't answer that. Your second subpoena was very specific. It was this date to that date. From this email to this email. Here are the search terms. I need these search terms. I can then do a particular ticket, or my staff can do a particular ticket, do it to CIO, the technology department. The technology department can run all emails. And then when they do all emails, they can come and say, hey, based on these search terms and based on my word ticket, here are responsive documents.
Okay. So if you had asked IT for any of our open records items before, there'd be some ticket for that.
There will be some Excel sheet, some requests.
And you didn't bring any of those here today?
Did you ask for them? No, I don't. As I shouldn't.
But those would be available. If you had asked IT for any documents, there would be a record.
I'm not the custodian of IT records. I cannot speak for IT department, so I cannot answer that question and cause speculation.
Okay, let's just walk through the subpoena quickly. I asked for all text messages sent by or received from employees. What did you do in response to that?
That's an IT question. We needed to figure out what the policy was as it relates to text messages. So I would fill out, hey, IT, this is what I'm looking for.
Did you do that in regards to the subpoena? We're talking about the subpoena for you to bring documents today.
The subpoena, yes. And I gave you, hold on, let's be very clear. You did not give me no subpoena to bring documents today. Let's clear up the record. What you did was you gave me a subpoena on August 21st to produce records, right? Those records were produced on August 30th. So there is no requirement for me to bring anything today. And I gave you those documents through my counsel on August 30th. So let's clear up the record. There's no requirement of me to do anything.
Talking about the subpoena for you to appear today. The subpoena for you to appear today had an exhibit that asked for emails and text messages sent by or received from in regards to critical mention. What I'm asking you is
I need
what
to see
you
the
did.
subpoena. I don't
Hang
know
on,
what you're
hang on,
talking
let her, I understand, but let her finish her question. Y'all can't talk over each other.
I'm asking what you did in response to that.
I hear you. I don't know what subpoena you're referring to. What I am telling you is I got a subpoena that was for the production of records for August, and I gave it to you on August 30th. That's what I'm familiar with, so I can speak to that. If you're speaking of a different subpoena, you can hand it to me and I can review it.
You learned about court here today, correct? Somehow, you knew to be here.
So are you not, okay, different question. Somehow I need to be here. Yes, my counsel told me that I need to be
You
here.
gotta be there. Answer
And
the
you received
question.
a subpoena to be here today, whether it be through email or you signed a certificate.
No, I did not.
You didn't get an email with a.
You probably gave me an email. You probably gave me an email.
So
I'm pretty sure you gave me an email.
I'm sorry?
I'm pretty sure you emailed me. Yeah.
And attached to that email, there was a subpoena that included the production of documents, correct?
What subpoena are you talking about? There are multiple subpoenas. I've asked you several times, can I see the subpoena you're referring to? If you're talking about the one to me on August 21st, I can respond and tell you what I did. You are asking about a different subpoena, I need to be educated. I'm asking, I don't know what you're talking about, so I cannot respond. Are you willing to present to me something?
Of course, and I'm certainly not trying to hide anything. I'm trying to ask questions before.
I hear you, and I'm certainly trying to be very, very truthful to the court and clear the record.
Trying to kill time, bad.
He murdering time.
All I'm asking for, if I am under a subpoena, and as you allege that I was supposed to bring something today, that's the allegation that you made among many. I would like to see it. That's all I'm saying.
Judge, his counsel's already talked about that, and I was understanding that he waived any issues with the subpoena to be here today. If that's not the case, I'm happy to show it to him, but without that, without him here.
I mean, so, okay, first of all, it's 4:59, so I need to check in with the court reporter who said she had a hard push at 5 o'clock. Now, I don't wish to interrupt in the middle of questioning when it looks like you were trying to get to a point of being done with the witness, but as you can see, my screen starting to drop off. That's an indicator that my Zoom's about to die. So that's an indicator that we should adjourn. Separately, I will say I agree with you. I think that Ms. Alavi agreed to produce Mr. Bond. That's a different question, though, than whether he received and was aware of the document request. So we'll just leave it at that for now.
And that's fine. I'm happy to answer those, but I know he was sequestered and didn't know what his counsel had agreed to.
Sorry, I can't hear Ms. Merchant.
I know that he wasn't present and didn't know what his attorney had agreed to. And so I just, before we went down that road, I didn't know if he knew that they had agreed that he was here and subpoenaed him.
Well, can I respond now?
You may, and then we're going to adjourn because I have to let the court reporter get on with her day since she's filling in.
I'm so sorry. This is definitely important. No, I'm glad I asked. I did not receive a September 13th subpoena. And let me clarify.
There you go. That's it.
Know this. The subpoenas that you referred to, my name is not even on Exhibit A. So this is the first time, as I sit here today, that you have given me a subpoena that you said that I was responsible for. So no, I did not get this. It does not say when it was delivered. I have not received anything, and I don't know what was mailed. So no, I did not get this, and I'm not responsible for it.
Okay, and Judge, we've already put in the record the, when it was delivered, and I can put the email in where it was served. I'm happy to print that out tonight, and then we can question tomorrow.
So why am I not on Exhibit A? Something's wrong with that subpoena. Something's wrong with that subpoena.
Sir, that's a legal argument that your counsel can make. We've had some discussions this morning before you were called in to testify. And so we can have that conversation tomorrow. But it is 5:02. The court reporter did everybody a favor by rearranging her schedule to stay for an extra hour. I assume we have on board a court reporter for tomorrow. For now, I'm going to excuse Mr. Bond. If you would step outside.
Your document is up here.
Mr. Bond, just reminder, Mr. Bond, that you're still testifying. And so you're still sequestered, right, regarding the substance of the hearing. And I'll need you to return tomorrow. I'm going to discuss with these lawyers in just a moment about what time I'll need you back, but just a reminder, Okay.
Yes, ma'am.
Thank you, sir.
And not to review any of the, stuff today.
Well, I remind him of his obligation under the rules to keep custodian, so he's a lawyer, as I understand it, so I assume he understands.
Wow. Okay. So that was the end of that. Let's jump back over into YSL
Okay.
shenanigans.
Here we go.
Wow.
Screen up.
They just cut it off. All right, let's go. Let's go.
Whether or not you have any experience with collecting and listening to jail reports.
Yes, vast experience.
Yes, sir. Pull that microphone down closer to you.
I think he's talking about me.
Oh, you're talking about
Right.
Miss Love? Okay.
Would you tell the,
That was
would you
crazy.
tell the jury, would you tell the jury what experience you have with jail recording?
Jail recordings are recordings of phone calls placed by inmates at the Fulton County Jail. All calls except for calls made from like contraband cell phones or any other non-regulated phone in the Fulton County Jail are that are placed by inmates are placed from phones that essentially automatically record the phone calls, and the recordings are automatically stored on a server somewhere. Up until very recently, like May of 2024 to be exact, these phones that were in the Fulton County Jail that the inmates would utilize to make these calls were owned and maintained by a company called Securus, Securus. It's now a new company, the name of which I can't recall. But I have access to these jail calls. When it was on Securus, when they're the company that maintained the recordings and the infrastructure that allowed for the recordings, it was there was a website that I would log into. commandcenter.securustech.net was the uniform resource locator, or URL. I had a login and password, and on logging in, I would be able to search for the jail calls using various search terms, using the search form that was provided to me. And then I could listen to any call that was placed by an inmate from a phone mounted to the wall or through a tablet. And they were all voice over IP calls that were placed.
How would you decide out of all of the calls that existed at the Fulton County Jail or from the Fulton County Jail, in any particular case, where to start looking for calls of interest?
Well, that is it. There's a lot that goes into that. Okay. So on a typical murder case, I would start with every inmate. Let me back up a little bit. Every inmate is assigned an account number that they have to enter before they place a call from the Fulton County Jail phone. They then have to follow that account number with a PIN. So they type in their account number, they type in their PIN, and then they place a call from the Fulton County Jail, and it debits money from an account that's been set up so they can place calls, because every call costs money. All right. So what I would do is I would first run a list of all numbers, all phone numbers that the inmate called.
I'm going to object based on relevance, based on bolstering. That'll be my objection.
Your Honor, one, this witness will be talking about certain steps that he took to further the particular investigation of the case that we're here on, and how he did it and the extent to which he, the steps and the extent to which he went to find certain things are relevant in terms of how exhaustive his efforts were. So it'll allow the jury to gauge.
Why don't you just ask him if his efforts were exhaustive?
But Your Honor, I think it's relevant that the jury understand what he did to narrow down those numbers that he.
Okay, well, let's get to that without there being a treatise on all of this.
Okay. All right, Mr. Sprinkle, without the treatise, how do we, can you give us a more, or give to the jury, a more condensed version of how you determine what calls you want to look at out thousands of calls that exist.
Sure. I basically just compile a list of phone numbers that the inmate called, and then I run each phone number individually, and I look at the date and time that the inmate called the numbers, and based on when that call was placed in temporal proximity to something that I deem significant, I listen to that call, and on listening to it, I determine whether or not it was relevant.
And when you say you run each call individually, what does that mean with the Securus system?
You can search for calls based on phone number only. So you can, in the search field in this form at that website that I said that I log into, you can just type in a phone number and a date range and ask the system to return all calls placed to a certain number by any inmate in the entire facility for a certain time period.
Are inmate names always associated with the PIN number, or inmate calls rather, please forgive me. Is a call by an inmate always associated with the PIN number that inmate has been assigned?
No, not at all. It's very common for inmates to utilize each other's PINs accounts, rather, to place calls.
What about when a person is first booked into the jail? Is there an account or a PIN number associated with that person?
No, those calls placed in the booking area, they are not required, nor do they have an account and PIN number to even utilize to make the call. So those calls, they don't need to enter any account information. So the only way you can find calls from the booking area or the lobby area, but for you, you're relevant to your question, the booking area, when the inmates first get there, is to search by the phone number specifically.
Okay. Now, do you listen to, when you say that all the calls are recorded, do you go and listen to calls between inmates and their attorneys, things that are privileged?
No, and ideally the attorney will have registered their number with the system such that the calls aren't recorded at all, but if I ever see...
Overruled. Please go ahead.
Yeah, and if I do see calls from attorneys, then I just don't listen to them, and I just disregard those.
You mentioned contraband cell phones. Would you explain when you said that except for contraband cell phones, you try to listen to the calls that are made from jail?
Well, I can't listen to phone calls made from cell phones that have been smuggled into the jail and the inmates are using unlawfully, because those calls are obviously not recorded. Yeah, I mean, they're cell phone calls. Unless there's a wiretap on the phone, I wouldn't be able to listen to those.
We'll come back to the wiretap, but do you ever have access to calls or cell phones rather that were smuggled into the jail and used illegally?
Occasionally.
Objection, asked and answered.
Overruled.
Occasionally, yes, there will be cell phones that are seized from inmates at the Fulton County Jail, and the contents of them are digitally forensically extracted, and I will review those, yes.
When you're talking about them being digitally forensically extracted, could you break that down in lay terms?
So, sure, a cell phone, as I think we all know, has a port on it, generally that you plug a charging cable into to charge it, but also with most, if not all, modern cell phones at this point, that cable can also allow for the transmission and of data to and from the phone. And so when a phone is seized by law enforcement, there's certain software that law enforcement can use to basically plug the phone up to the computer using that same port that can send and receive data. And this software can make an exact copy of the contents of the phone. It's called a forensic data extraction of the phone. And it creates a forensic image, digital image of the phone. And it's meant to ensure that the contents of the phone are not altered at all in this process. And it allows, through the specialized software that law enforcement utilizes, to read the forensic image that is created from this process, to inspect the contents of the phone, such as the text messages, images, videos that were filmed and photographed by the phone, etc.
Can you do or find social media content on those extractions as well?
You can. There's subsections of the reports. One of those is or not just Instagram, but social media accounts that are registered to various apps in the phone. So yes, those are in there as well.
And do you ever use those extractions to aid in furthering an investigation into the homicides that you received?
Yes.
How do you decide what or how to find social media accounts of interest when you're investigating unindicted homicide cases?
Well, there's a lot that goes into that. Are you saying if I were to have a person of interest or anyone really, and I just wanted to find their social media accounts?
Yes, how do you go about determining what social media platforms and to whom or how a person identifies themselves on social media platforms that you find of evidentiary value?
Well, that can be difficult or easy depending on the person. I suppose I would start by just searching for their name on a social media platform. If they have a very uncommon name, then it can be very easy to find them. But if they have a very common name, they can be a little bit more difficult.
You use things like phone numbers, or do you use things like phone numbers to narrow that down?
Yeah, so there was a time where if you had someone's cell phone number and you ran it through Facebook in the search field, it would actually just return their Facebook profile. Facebook doesn't do that anymore. So that, you're right, that was one method. Most social media platforms today, I'm not aware of any that allow you to find, except for Cash App, which I wouldn't really consider a social media platform. But things such as like Snapchat or Instagram or TikTok, et cetera, I'm not aware of any of those that allow you to search by phone number now.
Do you conduct interviews with your investigators to further any investigation of the homicide cases you receive?
Yes, and by that, I mean, my investigator and I will just go visit people at their homes or their places of business, and we'll interview them and ask them questions that we may have about the case.
And when you do that, do you write up a report, or do you in any way include or somehow memorialize that interview?
So there's a couple of things I do. I'll audio record the interviews, and I will generally write a report summarizing the contents of the interview as well.
Do you end up indicting every suspect that has been arrested or for whom?
Objection as to relevance.
Overruled. Do you end up indicting or presenting to the grand jury every suspect that has been identified or arrested in the homicide cases that you see?
No.
And why is that?
Well, there are times then when on reviewing the case file and
The bolstering.
Y'all want to approach?
Okay, I don't know what happened. I hate that they go to the seal just to have a bench conference. Did you?
Yeah, she wrote that into order 2 days ago.
Yeah.
From now on,
I just
whenever
hate
they
that
go to
they
a
do
bench
it like this.
conference,
Sounds
because
silly.
something got out over a microphone.
Whatever, Heather. Anyway. Okay. The Ashley Merchant, what's his name? Dexter Bond conversation. That was a little spicy. Good gracious.
He got big mad.
He was extremely upset. All right. I didn't get it. I didn't get why he couldn't just say yes or no, but
Period.
to me, right. To me, him not answering the questions only made it worse. Like, just say yes or no.
When you go
Yeah.
over the top explaining yourself and walk yourself in circles like Miss Love, it makes you look guilty.
It does. It does. And this right here, I guess I know what she's trying to do, but
I don't. Will you explain it to me? What's she trying to do?
she just wants people to understand. She's trying to get on the record how they got those wiretaps, and as well by using jail calls. I think that's what they're gonna say. Like, hey, we heard somebody mention Sally Jane or Tommy Tom on a wire call. I mean, on a jail call. So then we got a wiretap in order to continue. That's what I think she's gonna do, but I could be wrong. I could be totally wrong. Yeah, but okay.
But
How
haven't
long is
we
that
gone over
innocent
this?
merchant Dexter Bond tango gonna last?
Haven't we been over jail calls though? I mean,
I think they're trying to. It does seem out of order now that I think about it. They've already done jail calls, but now they have the expert explaining how they got the jail calls. Seem like they should flip flop those.
yeah.
Yeah, I don't know. I'm not 100% certain what they're doing with that. But I know I love Judge Cross though. She was holding it down.
She was. She had her courtroom in order.
Now, granted, I don't know how she would do. Look, I'm not going to ask for it because we don't know what'll happen. She get over here in YSL and lose her mind. But
because Whitaker seemed like she had it together too for a day or two.
For a day or two, like I said, a day or two.
And then she was going home and sticking needles in her eyes. So we don't know.
I know because the wheels on the bus came off on that thing. Yeah, I don't know. I wonder how long this is going to be.
If you got time, if you don't, I've got the Matthews lawyer's argument for him pulled up after this.
You mean Huey's lawyer?
Little D's.
Okay, Little D's lawyer is Shibe.
Yeah.
Okay. I thought you said Matthews. I'm like, well, wait.
Well, his real name is Matthews, isn't it?
Lil D's name is Quandarius Zachary. What's name is, I don't know his first name, last name is Shibe.
Quandarius. Okay, I thought his last name was Matthews.
Quandarius Zachary.
Okay.
And,
Zachary. That's what it is. Quandarius Zachary. Sorry.
That's all good.
Yeah.
I don't know what they're gonna do. Yeah, pull it up. Is this him?
Okay.
Yeah, pull it up. If anything pops off, we'll just jump back or leave it alone, one or the other or both.
There it is. Okay.
Understand somebody, I'm not going to know what he said I wasn't truthful about something. And at the doctors, I asked the doctor a question about my client's mental competency.
Back it up.
Said, will it affect you? The doctor gave me an answer.
Right.
That's it. Anybody who's not going to go over what happened yesterday, but I don't come to the court tomorrow. Understand somebody, I'm not going to go over what he said I wasn't truthful about something. And at the doctors, I asked the doctor a question about my client's mental competency. Right. Said, will it affect you? The doctor gave me an answer.
Right.
That's it. The phone was about 10 or 12 inches away from me, and I asked a question. And once I got that, and I relayed it to the court. I understand somebody came in here and said, what I said wasn't accurate. I don't lie to the court. I've never lied to the court. So that's all I'm saying.
Okay, I appreciate it. And so you're talking about when, and I don't know exactly who was on the conversation, but so the conversation was at your behest with Mr. Zachary's doctor, and I don't know if it was an ADA and an investigator, Abadi, and an investigator, and y'all were all on the phone together with the doctor.
The phone was right here. The doctor was someplace else. My client was here. I was about 12 inches from the phone. Actually,
So the doctor was on the phone, and the doctor was on the phone. Okay, and you and Mr. Abadi and the investigator were all talking with the doctor. Okay.
that was a conversation when I came into the
Okay.
court. I understand. The ADA came into something different. Indicated I was not being truthful.
Okay.
I don't lie to people.
I don't believe that you do, and I appreciate that. And I didn't take it, I mean, I don't think he said anything as strong as you know, Mr. Scheib lied. I think it was just, that's not exactly what got said. And two people can hear the exact same words and take it two different ways anyway. But I appreciate that.
That being said, I talked to Zachary.
Okay.
About 3 minutes.
Okay.
He's at the hospital. He's had low blood pressure and blood scenario. They were gonna release him today. They didn't.
Okay.
They're gonna maybe release him in the morning.
Okay.
But he has to meet a criteria of blood pressure and blood volume.
Okay.
I don't know. So he may be released tomorrow, he may not. I've got 5 courts and 5 different jurisdictions tomorrow, so.
So have you filed a conflict?
No, well, all those are like trial calendars, cases 3 or 4 years old, trafficking and different things. This is, I'm an attorney for a witness.
Right. I know.
And so I think they take precedent. I'm trying to work within.
I mean,
I know.
I would be happy to, given the circumstance of your particular client and the request that, you know, he not be held anywhere and that he get this over as soon as he possibly can. I am happy to communicate with the courts if you'll let me know and see if they can.
I've been here all day, every day.
Yeah,
I
know.
wanna get it done.
I know.
I know everybody else does too.
I
And
know.
then what I was gonna ask for, under 601, is have a hearing to deal with his competency. I think it would be something short as to mental competency because he is on drugs. He is on Dilaudid. And so under 601, the court.
Well, I don't know what he's going to be on when he gets released.
Can't read without, he's on Dilaudid.
Okay, lots of people, and I don't mean to interrupt you, but lots of people can take and do take painkillers every day, and depending upon what it is and the amount and what have you, it treats their pain. It doesn't necessarily make them incompetent or unable to do things. So, I mean, if I am presented with something that makes me believe that there is an actual issue as to his competency, then certainly I can entertain that, but.
That can only be from him testifying, number one, to that issue. The other issue, he doesn't recall, this is 10 years ago.
Well, he may or may not, and he'll just have to say that on the stand. I mean.
And then also we deal with scenario of immunity. We want transactional immunity.
Well, that's something between you and the state.
You can order him up there. I'm not arguing about that, but he's not going to testify unless he gets immunity. Because he was an unindicted co-conspirator in reference to this stuff, and he did prison time.
Have you talked to the state about any of this?
If I may, Mr. Scheib has talked to me, and what he has said has nothing to do with concerns about a legal exposure. What he has said has to do with fear and not fear. It has to do with fear and his client's desire to not testify. Period.
You see, I didn't know until yesterday.
Excuse me, can y'all mic up? Do y'all use the microphones?
Yeah, just walk back to the podium. You'll only be 3 feet further away, and then they can hear.
I'm sorry.
It's okay.
I didn't know until yesterday he was part of this 10 years ago. I did not know. He did prison time, but I didn't know that he was part of this. And as far as immunity, he could be brought in. I mean, as far as conspiracy, and if he gets up and testifies and said, hey, I was involved in this and involved in that, they could prosecute him. I didn't know that until yesterday he was involved in this scenario.
Okay, I don't quite know what you mean by he was involved in this scenario, but.
He did time for some of these acts involved in this.
Well, he certainly can't be prosecuted for anything he's already done time for. I mean, that's double jeopardy.
Well,
And you're,
I don't know if, as far as conspiracy to commit murder and everything, I don't know what he was prosecuted for entirely. I just found out, and the family has told me more today. I thought I was getting involved in, I'm fine on it, getting involved in a scenario where I was going to help him, give him information, whether testify or not testify.
Right.
But it turned out to be, and that's fine. I like this. It's a lot more to it. So I have to protect him.
I understand. So, I mean.
Judge, I don't have any problem doing that, but I just do want to make the record very clear for a couple of things. I don't believe that Mr. Scheib has, and I don't think the court entertained it, so it may be worth nothing, but the competency Mr. Scheib doesn't have, I don't believe, maybe I'm wrong, standing to assert regarding competency, a hearing regarding competency as far as this person as a witness. But second, given, I don't know what all Mr. Scheid knew, but given the comment, given the communication between Mr. Zachary's father and our office,
Right.
I don't know how, and given what I was told, not yesterday, but I think day before yesterday regarding what Mr. Zachary would and would not do and why, I don't know that I don't know how that there was no knowledge of what his involvement in this was. There was specific commentary, and I'm not saying that.
I don't know either. But I mean, Mr. Scheib's right.
He's a grown man. Why are we taking the word of his father? I'm sorry.
Based on the way this case has been indicted, even, I mean, the RICO count seems to be something that if the state wanted to, they could indict anybody on who had any involvement in any of the crimes, even if they've already been, I mean, I don't know that, you know, at least be indicted, whether it would hold up or not, I don't know, but.
So, Your Honor, as in as much as there is a concern, I assume that there is a concern regarding Mr. Zachary, I don't know, implicating himself in something that he could get indicted for. We don't have any problem asking the court to compel his testimony pursuant to the same statute that we have had to compel others. We don't have any problem doing that.
All right, well, it sounds like y'all might need to get some sort of an agreement in place between yourself and Mr. Scheib.
We definitely like something in writing.
I mean, that's basically what you're saying, Mr. Scheib, right? Is that he.
Part of the situation.
And also, I think I ought to make Mr. Scheib aware. I just want to make sure he's aware that part of the requirement for that statute is that he not commit perjury on the stand. And Mr. Zachary is currently on probation for a long period of time. And so I'm gonna put that out there. That's it.
All righty. Well, Mr. Scheib has been a defense attorney for more years than probably he can count anymore. And a good one, a highly experienced one. And so he'll be able to advise his client as to all of the, you know, potential drawbacks and dangers and what have you of such an agreement.
Easy, clear-cut scenario. We're going to wade through some things. Okay.
So we'll draft up that document.
Okay, but considering that it sounds like it may be as early as.
Talk to the witness about his ongoing testimony. If you hadn't talked to him about what you're going to show him before.
Harvey about to tell.
I'm late. Number one.
All right, Mr. Harvey,
Harvey just told Love off. So they've been wrangling because there's a lawyer on the stand, Mr. Sprinkle, and he's testifying, but Whitaker's ready to wrap it up. It's like, hey, you can come back tomorrow. Now, the rule is you can't talk to witnesses. Well, he's actually a lawyer. So the state is trying to say, oh, well, because he's a lawyer and he's our witness, we can talk to him about stuff that we're going to be doing later on and evidence we want to show, blah, 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 blah. Basically, we want to, make sure he's going to say what we want him to say. I stopped it right at the part where Harvey jumps in, Bruce Harvey jumps in, and he tells him what he thinks about him. And somebody's mentioned this, that Harvey talks directly at Adrian Love, whereas others don't. They talk to the court, to the judge, and then the judge relays it as if you weren't really there. But anyway, I want you to hear this because this is pretty wild. Let's go.
Still on the stand.
Your Honor, I believe that the prohibition that Mr. Scheid is referring to is akin to the rule of sequestration and talking to him about what he has already talked about. I would ask that the court allow me to continue to speak with Deputy DA Sprinkle. He is our witness and he's not, nobody else is, I know not to talk to him about other people's testimony, but talking to him about things that I'm going to be showing or saying or whatever to him, I don't know that there's any legal prohibition against that and constraining us from interacting with our witness. He hasn't even been subjected to cross, so we're not trying to tell him what to say, but at this point, there's no difference in terms of his, anything that could be done improperly than there was before he was sworn. So I would ask that the court allow us, and if anyone else wants to talk to him, allow them to talk to him as well. There's nothing that can be, the rule of sequestration isn't going to be violated. So there's not a prohibition against us talking to our witness or any other
I mean, honestly, I think the rule is actually something like, overnight it's okay. Something at lunchtime isn't, but essentially you shouldn't, and he's a lawyer again, but you shouldn't be in the middle of testimony trying to coach him about anything, which and you won't be doing.
Right. But speaking to him about or asking him about or showing him evidence that we're going to be doing, or we have, like I said, there's nothing to coach him about. I've just started on the examination and I don't have any opposition to anybody speaking to him. I don't know if they've done it or not, but there's nothing improper that could be even done at this point with this witness, just because he has started his testimony. And I would ask that the court allow us to continue to work with and talk with our witness.
And I would object to that. He's on the witness stand, he's sworn. That's every opportunity to talk to the witness about his ongoing testimony. If you hadn't talked to him about what you're going to show him before now, it's too damn late, number one.
All right, Mr. Harvey, you keep talking to opposing counsel, and as you know, practicing law for as long as you have, you're supposed to talk through the court. Okay, so can you please try to do that?
Sure. There's every opportunity. You should have taken the opportunity to talk about his testimony before he got on the witness stand. He's a sworn witness now. And the case is Perry versus Leak. It's a United States Supreme Court case in which the government said that a defendant's lawyer can't talk to his own client overnight because it was improper to talk to a witness while the witness was on the witness stand. And the US Supreme Court said, yeah, that's the rule, except for the Sixth Amendment allows a defense lawyer to talk to his own client overnight. So I object to the state or anybody for the state talking to this witness or any witness while they are on the witness stand and testifying.
All right, so I don't think that the case actually limited it just to defense attorneys and defense counsel. That was the reasoning in that case. But, Ms. Love, I mean, be aware that if you talk to him about something overnight, they're going to get up on cross and ask exactly what y'all talked about.
That's fine. And I understand that. And Your Honor, that's fine. And if there's additional case law on any of this, I know that in the morning we're going to be bringing up, we're going to be briefing the court on some other things.
Okay.
I'll bring it to the courts.
All right. Thank you, Mr. Sprinkle. That actually reminds me. So when Ms. Smith was on the stand, and I may have heard it wrong, but I think that she said that, of course I know this because the trial's been on, live stream. Can everybody please tell or remind anybody that you think might be a witness in this trial to not be watching the live stream before they have testified, to not talk to any witness who has already testified about their testimony, and to not, once they themselves have testified, talk to any other potential witness about what they testified to. Y'all all know that, but not every lay person knows that. So just remind all of your potential witnesses not to be doing that.
Your Honor, I just want to point out that we beg, we admonish, all of that. And I've heard people say, it's everywhere. What am I supposed to? I'm like, turn it off.
Correct.
But, you know,
Yeah, no, I know. I'm just saying to the extent y'all
I love how
can
she's
try to
acting like
control
she's
that,
not in
please
control of
do.
the court.
All right, what else do we need to handle tonight? Or can? Oh, yes, you. Yeah, you're out of here. Thank you for the day.
and so, Judge, there was one other, well, I don't think there's anything I can do about it though. Now, I'm just gonna have to check on, the status of our witness who's currently,
Okay.
at Grady. But I mean, I think that I'm not gonna speak for the doctor, but there may be a point at which, we present something else to the court regarding, finding out with more certainty about his.
Y'all are
condition.
welcome to do that at any time.
Okay, thank you. Thank you.
Man, imagine.
Yes, sir.
Can I, and I could email it to everyone as well, but I have a couple of cases I'd like you to consider
All
so we
right.
can just start running in the morning. Vega, VEGA versus State. It's 285 Georgia. 32, it's in Division 3. It's a 2009 case. The cases it relies upon are still cited in 2023. And it specifically what we're targeting is where the conduct and the motives of the actor are not matters concerning which the truth must be found, i.e. are irrelevant to the issues on trial, then the information, etc., on which he or she acted shall not be admissible. Only in rare instances will the conduct of an investigating officer need to be explained. Otherwise,
Hang on just a second.
of course.
Sorry, did have the deputy going in and out of the jury room, and it looks like some of them are still in there. Go ahead.
Only in rare instances will the conduct of an investigating officer need to be explained. Otherwise, it is error to permit an investigating officer to testify under the guise of explaining the officer's conduct to what other persons related to the officer during the investigation. The mere circumstance of an officer's initiation and continuation of an investigation without more is not relevant to the inquiry. And the reason, there's also Leslie, by the way, LESLIE versus State. That's 355 Georgia Appeal 244. 355 Georgia Appeal 244. It's in Division 7. It's a 2020 case. It says the exact same thing. But
Yeah, you know, my understanding of those cases, and it used to be, especially before our new evidence code, that, you know, every time there's a hearsay objection when there was an officer on the stand was, oh, it's to explain his conduct, and that's hardly ever relevant. This is A, not just an investigating officer, but B, if Ms. Love, I know you had said some things up at the bench that I think are relevant in responding to this issue of whether, I don't know if it's so much his conduct, but, you know, I'm sorry. The practice that he goes about in deciding to sometimes not, I guess, bring an indictment against somebody that had been arrested.
Yes, the decision, the way that he does his job. I mean, yes.
I just want the court to appreciate this then. Then are we allowed to bring in people who've been exonerated by DNA from the Fulton County District Attorney's Office under Michael Sprinkle murder case that has been found to be innocent? Do we get to bring in individual people who say that they were wrongly charged and their murder case after indictment was dismissed? Do we get to bring in people who have pled guilty but will explain, I only pled guilty even though I'm innocent? Because this is just opening up, to me, the DA's office reputation. You know, I could put my reputation in this courtroom as well. I could have a lot of people come in and say, you know, I believe beautiful things, but we don't do that. And that's
Which is why, as you know, up at the bench, I instructed Ms. Love to focus and tailor her questioning so that it focuses on what he did in this case.
okay. I thought we were still talking about okay. And I agree with you. Whatever he did in this case may or may not be relevant, but right now he's talking about, I don't indict everybody that's brought to me. Sometimes law enforcement doesn't do a good job, so
There you
I
go.
have to pick up the pieces. I don't see why that would do it.
I don't know why Miss Love asked that question anyway, but I mean, it's Miss Love's case. Well, it's the state's case being led by Miss Love.
Mm.
But one
Wow.
thing that I think
Do
it
it still.
is, this is not the typical case in that the defense actually in this case has somebody, a couple of people, I think, who were once indicted for the murder of Mr. Thomas, who
Facts.
no longer are. And we have this other set of people now indicted. And there has been very much suggestion through defense questioning of witnesses thus far. And I don't know, I mean, I suspect will be an opening and a closing as well, which is entirely appropriate as a defense counsel to do, but to poke holes in the state's case by saying, you know, these people, law enforcement thought it was them, XYZ, and all of a sudden, you know, it's not. So y'all actually have somebody you're pointing to and saying, this is who ought to be being prosecuted, but they're not. And it's because of, I don't know, whatever reasons y'all come up with to argue. But that, I think, takes it out of the general, well, conduct's never relevant, because neither side should be hamstrung in not being able to counter what the one side is saying about the case. So. Anything else?
If it's tailored, then we can do it
Yeah.
question by question, but right now it's very broad.
Yeah, I agree. And I did not want Mr. Sprinkle sitting up here saying, you know, hey, I'm brilliant. And when I decide, you know, somebody should be prosecuted, it's because I know, or obviously he's not going to do that, but anything like that, because his thoughts about it aren't really relevant.
And Your Honor, that is the point that I was actually trying to stay very narrowly focused on, because it's not about his thoughts, but there has been a persistent assertion by way of cross-examination and whatnot regarding it. I won't say impugning, but it kind of is why certain decisions were made. There have been questions posed that have been stricken, that have amounted to, they were just after this person, or you ignored this person. And even when we have witnesses that have testified and, you know, backed up and been given immunity and said certain things, the suggestion has been made that they were given immunity because, you know, the state only wanted to go after X, Y, or Z. And I believe that it is very relevant and important for the jury to be able to gauge what at least was done in this case. And it's not just the decision of the DA's office. This is a person who actually took steps that were of an investigative nature. It is important that they are able to gauge that what has happened here in the context of, and I said it at the bench, what he does with each case. This is not no different. And we did say that we were going to tailor it, and we're going to do exactly as the court allowed, go narrower, and then talk specifically after that, after narrowing it down, you know, generally, is this what you do in each of your cases? So I believe that the court is actually absolutely correct. It would be hamstring this, the state's ability to put what this person has done in the context of what they do each time, and then have the defense say, you know, well, he just went this extra mile because he was trying to find information. He went looking for these jail calls. He did all this work because he wanted to find something on this person, versus this is just how he treats an unindicted case. And I would like to, of course, present more case law on bolstering, as the court said that we could in the morning, to argue the point.
Your Honor, can I just invite the court to observe that to the extent that the court has been listened to the cross-examination and how we've been not presenting our case, it's not our case.
Right.
Our defense is that any challenges to the credibility of the investigation or the investigators has always been in the context of this case. Right? It's just been challenging what was done in this case or what was not done in this case. And so we've been narrowly focused on defending the allegations and the investigation of what we thought were improper investigations or targeting wrong people or targeting certain people. So I think that's relevant. And what Mr. Sprinkle did in investigating this case, assisting the police in this case, sure, that may, like Mr. Steele said, may or may not be relevant. Right? But for him, again, I don't want to repeat everything that's been said already, but to have him go on and talk about, well, in this case, hypothetically, I may do this because this is why, and for him to go into explaining about the secure system and this is what inmates do when they get to the jail when they're down in booking versus elsewhere. All of that is really not necessary for the jury's consideration. It's just not relevant. And for him to talk about other cases really would be improper bolstering. He's bolstering himself. He's bolstering either the work of the DA's office or investigators, and that's just not proper unless he's talking about what was done in this case.
All right, yes, thank you. I will keep all of that in mind. All right, I will see y'all do we even think 8:45 is going to give us enough time? Let's meet at 8:30 in the morning.
Oh my gosh.
Of all of you. All right, see y'all at 8:30. Y'all have a good evening.
All right, let's see what happens. All right, let's see what happens.
They were taking Love to school.
All right. Woo. Okay.
That needed to happen, though. It was
It
about
did,
time.
absolutely. No question about it. I think it's a little bit too little, too late. If you ask me, they should have
It
been
is.
calling her on the carpet a long time ago.
Yeah, her head's already gotten big in this case, and I'm not trying to talk bad about anybody. I'm just really calling facts. She's determined to see it through now. I think at first she was trying to get a mistrial going, and I think
Love
she's
or
determined to see it
Whitaker?
through.
Ooh.
Love.
I think Love has always been committed to the case. I don't know if I was ever really truly sold on the goading as much as she. No, I think she really believes that she's winning this case. I really do think she is. I think she understands what's at stake, but I just don't think she's conveying it very clearly, in my opinion.
I don't think that she is as dumb as she's trying to portray that she is. I think she is trying to portray that she is, oops, what? I don't understand. I messed up. Like they talk about they've been emailing with her for 20 years. They talk on the phone. I think it's an act, and I don't like it when people act like that. They try to be fake.
Right.
And that's exactly what she's doing. But I'm gonna let you wrap up. Thank you.
All right. You got
Bye.
it. Thank you, friend. Grace and peace. Everybody, thank y'all so much. This has been a wild day. Starting out with YSL, jumping over to Judge Cross and Ashley Merchant and the FOIA request for Fonnie. That was pretty wild. And then we ended it with YSL. Man, tomorrow's going to be, I don't know. I have no idea anymore. Tomorrow's Friday. Who knows what's going to happen tomorrow? But I do know one thing. Lord willing, we're going to be back here again. So we're going to start again at 8:30 tomorrow. But that's the plan at least. And court, Judge Whitaker said they're going to start at 8:30. Jury will come in at 9. Again, Mr. Sprinkles should be jumping back on the stand. We'll find out. Hopefully everything's going well with Mr. Zachary. Most importantly, hopefully he's not going to be in peril of legal issues and whatnot. Hopefully his health is up to snuff. I don't think he's going to come tomorrow. I think it'll probably be next week if he does. But everybody, thank you again. Thank you so much for the very kind super chats. The supers have been fantastic. Thank you so much for N. Doug, who's just been blessing the live stream with these memberships left and right and center. Thank you so much for that. Thank you to everybody who supported the channel, whether you liked it or just commented, being a part of the best live chat on the planet, all of that stuff. I really do appreciate it. And let's do this again, Lord willing, tomorrow. Tonight is Thursday. I'm going to be doing my live voice chat with the community tomorrow evening. And because I got a deacons meeting tonight. But besides that, though, everybody, I'll see you real soon. We'll do it again tomorrow morning. Grace and peace. Take care.